Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
As the agent for Peyton, Ansley, John Milton, you are indicating to me that you're quite familiar with Peyton, Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton, Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes, that language doesn't make any sense. So
No, I do not.
I understand? Okay, well, I'm telling you that. And so until you disabuse me of the notion, I am inclined to believe that you are both the agent and the person. So, and it's an all
I'm not a
caps.
person, I am one of the people, thank you.
Okay, thank you.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Welcome. Let's see. I might even be in focus here this morning. Happy Monday to everybody. Welcome. Let's see. What are we waiting for my camera to load? It looks like this right now. Any minute now it'll be here. Wait, there I am. Wait for it. There it is. We're here. We can start now. I don't know how else to say this. I don't know how else to say this. Pickles, not politics. That sums it up. Pickles, not politics. And if there's ever been a time where I can say I am so happy that we are trying to foster and encourage an environment where people can disagree and still be friends, it's now.
May be upon us.
So thank you all, no matter whether we agree or disagree, for being willing to come here into this environment and share your opinions and do it in a respectful and thoughtful way. Do it with words and discuss and listen and learn and sometimes, in my case, sometimes change my opinion. So. I appreciate that. I appreciate what each of you do to make that possible. So, all right. Good morning. Good morning. Yes. Let's see. I don't know what else to say there. I don't want to get into a discussion about that would incite any sort of divisive commentary. I just think that now more than ever, all of us in all areas of our life probably need to.
This is not Burger King. People do not get to have it their way.
Be a better example of encouraging discourse.
When are we going to break for lunch, Judge?
Not discord, discourse. Just talking, communication, and all that. All right. Where do we begin? I think we'll begin with I Teach Him. Hi, says I Teach Him. I Teach Him, you're first in chat this morning. Something tells me you've done this once before, but is this a first? Maybe that was my imagination. I might have dreamed that you were first in chat previously, but the name looks slightly familiar as being a first in chat before. If it was your second chant. It was your second one, second time. There it is, second time. I knew it. I knew it was there. Congratulations. I was positive you had won once before, but congratulations. That is awesome. Good to have you here first here. Look at Danny on direct with the big old amen. Thank you, Danny. Appreciate what you do as well. And it was fun being on your stream the other night. Congratulations on the new benchmark. And for those that don't know, Danny on direct, a fellow YouTuber. She's a lawyer out in Utah. And has some insights into some of these areas that are interesting. Covers some of the stuff we don't as well. So if you're looking for something that strays beyond what the narrow niche, however they say that we cover, highly encourage checking out her channel. I'm going to be out there. We're both going to be out there. I think I'm going to meet Danny for the first time at the Corey Richens, or right around the time of the Corey Richens hearing there at the end of August. So I'll be out there for that, and we'll be bringing that to you as well. So good to have you here. Thank you very much, Danny. All right, niche equals niche. Okay, Red Pen is my my de facto English teacher. You can see that because she has a red pen. My English teacher used it on my assignments a lot. There we go. So niche it is. We're going to stick with niche. Selena Carr says, I sure love my fellow addict and RA as a leader. It's been a great 15 months. Thank you, everyone. Thank you, Selena. Appreciate that. We have a buffer sound. I'll check that in just a minute. According to Woo, member for 14 months, says, still looking cuter in orange than Letitia. Have a great week, everyone. That's funny. I'm sorry, that's funny. Teresa, member for 14 months. Thank you very much. Welcome to the gallery. Snakes Will Hiss says, yay, best place to be. 4 months. And yes, there is definitely a snake in your profile picture. And it's close to you. And I think you're aware of it. And you're not surprised. That's a great picture. All right, congratulations. We have some birthdays today. We're going to we celebrate everyone's birthday. At least we try to. As long as you will out yourself publicly and say today's my birthday, or over the weekend it's my birthday, something like that. We are here to sing to you. It's not to humiliate you. It's to actually sort of humiliates me. But when I say we, I mean all of us. That means you can't sit there quietly watching the stream and not participate. You being here means that you're going to participate in the song. And you can do that a couple ways. First of all, you warm up with me. Ready? La 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 la. Sounds good. All right, you know the song. We're going to sing to Chantel, Dan, Sherry, Too Tricky. Well, just Chantel, Dan, Sherry, and Too Tricky. Okay, we've got 4 people. We can do this. Ready? Dancers at the ready? Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Chantel, Dan, Sherry, and Too Ticky. Happy birthday to you. Too Ticky, I added an R previously, but I see it's Too Ticky. Chantel, Dan, Sherry, and Too Ticky, congratulations. Today is your special day. I realize there are a million places you could be and a million people you could be with to celebrate, but you've chosen to be here with us. That privilege and pleasure is all ours. Thank you very much. If there's anything we could do to make your special day more specialer or even specialist. Red pen, does that work? Did I use that correctly? Please let me know. Look at that. Well, I encourage you to go out and get free pancakes at Denny's or IHOP. Mrs. R.A. has delivered toast and scrambled eggs to the studio this morning. Hand delivered. Hopefully you get some hand delivered free pancakes, a free stack of flapjacks. Happy birthday. Thank you very much. The music stops, but the party does not let it continue. There we go. All right. Appreciate that, Sharon. Thanks for that. Let's see. Hazelnut and Pretzel says Hazel and I are sick today. Oh, no. I'm sorry. I give you permission to turn the volume down a little bit and continue watching. Does that work? Let's see. Wallflower, member for 17 months. Thank you very much. Welcome to the gallery. And Katie, look at this yellow courthouse. I can't see how many months it is for some reason on this one. But at least 6. Welcome to the gallery, Katie. Appreciate your support. Kaylee says, shoot, my daughter's birthday today, turning 4. Her name is Esme. Esme, happy birthday. The music stopped, but Esme, let's, you know what? 4 is a big year. I would hate to go on my 4th birthday and not be sung to. So Esme, we're gonna do round 2 just for you. Deep breath, project your voice to the back of the room, blend your voice with those of your neighbors, just for Esme. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Esme and Emily. Happy birthday to you. There we go. A rare birthday, a make-up birthday song. The same still applies to both of you. Free pancakes at IHOP. I think even if you're 4, they might give you a smaller stack. But happy birthday. Terminator. Oh, my mom would have been 100 today. Wow. That's awesome. Happy birthday to your late mother. Hopefully you can celebrate by remembering some of the amazingness that made her what she was. Thank you very much. All right. Happy birthday, Esme. Happy birthday, Emily, as well. We got you in there at the last minute. Twice the fun. Thank you, Joyful. I appreciate all you singing loudly from whatever cubicle or carpool you happen to be in at the time, or even if it's just in your front room. Don't go to any places, any establishments that Recovery Addict eats at, especially if it's your favorite, because they'll announce bankruptcy within 24 to 48 hours. This is true, and I don't know why. I don't know what I did to cause that. But Kimbers, Ohio. Oh my goodness! Look at this, 15 months, Kimbers. Love it. Thanks, RA. All right, quick synopsis of where we are. We were expecting to be approaching the end of the case in the Alec Baldwin trial this week, but that isn't going to happen anymore. That's over with. If you missed the Alec Baldwin, and I realized there were a lot of people who said, "Hey, this is Rust Round 2. It was bad enough the first time. I'm not going to watch a second." You have got to go watch maybe the last 2 days of the trial, because it was unbelievable, and it took the first day to set up the second day. So Thursday, especially Thursday evening, there was a little bit of testimony that broke that there was some other ammunition, and then
I saw a chicken fighting.
Yes, and there was a chicken fighting. No, there wasn't. But yeah, there was. It blew up, and then Friday was gold all the way through it. It was unbelievable. I could not tear my eyes away from what was happening. It was amazing. Bri Bear just gifted a membership this morning. Went to Zimmy from the bus stop. Congratulations, Zimmy. Thank you, Bri Bear. Thank you. So now that we, I had to go back and watch a whole bunch of different people to see reactions, and it was amazing. It was absolutely amazing. But crazy case, and it leaves me conflicted a little bit, right? Because in my head, at least from like a moral standpoint, I put the culpability for the shooting to be on Alec Baldwin and Hannah sort of equally, just because of my background training with firearms. And because of that, I mean, it's ingrained in me that, you're holding a firearm, you're responsible for it. And Red Pen, I missed your milestone chat. Hang on, let me find that. I've got this new feature where I can hunt down and recover. There we go. Red Pen correcting RA's pronunciation for 18 months now. Yes. Where were you before I started? I needed that a long time ago. Let's see. Wallflower, thank you. Katie, we got you. Wallflower, Katie, Kimbers, Ohio, Bri Bear. Is there anyone else I missed? We got Snakes Will Hiss. Teresa, 14 months, according to Woo. Selena. I think we got everybody now. I think I'm caught up. But thank you, Red Pen, for doing the hard work. What's on the agenda today? Krista, we're going to talk about that. Let's see. Lilith Geist says, Recovery Addict, I had no interest in Baldwin trial. Turned on the last day by accident as background for writing my web novel. Watched Hooked the entire evening instead of writing. Oh, that is great. I love to hear that. It was amazing. Honestly, I don't think we're going to see another trial like that in the near future. It was a perfect storm of scenarios that was just amazing. It was funny because I had actually recommended, there's a family that lives near us that homeschools their kids, and they said, we want to teach them about the legal system, about the justice system. Are there any cases coming up that might be appropriate for kids to watch so they can see the whole process? And I said, look, here's you've got Alec Baldwin. Okay, it's a tragic case. First of all, it has a tragedy, but it's accidental, where there's no like evil intent in there, right? And I said, so that's going to be good. It's probably going to be quite respectful or very minimal as far as the injuries that are portrayed during the trial of Joel and Helena, and so I set the stage for them and said, look, this is going to be the one you want to watch with your kids. Okay, it's a jury trial. It's a famous person that they might recognize. And it's relatively short, being just a week or two long. Spelled this all out, and they were so excited, and then it turned into a train wreck. And the spiciness on the last day is definitely not kid friendly. But so now I have to find them another trial. We'll see what we can do for them. Taminator61 gifted 5 memberships this morning. Thank you very much, Taminator. Lissy, Cricket S, Two Ticky, congratulations, Two Ticky, on your birthday as well. Joyful and Sandy Beach, all gifted memberships. Thanks to Taminator61's generosity. Let's see. Kaylee says, thank you so much, Recovery Addict, for singing to Esme. Both my girls loved it. We can read documents. There are some documents to read. I was going to jump to because honestly, looking at the schedule, the next big case that we're following is the Ashley Benefield case, which starts, I believe, on the 22nd, which gives us a week. And there's no big trials going on right now. There's no big trials. So I think, let me check my schedule one more time, upcoming cases. Let's see if we have something. Oh, and I have to tell you right now, Wednesday, midday, I've got an appointment. There's a venue that I do audio video at that just got a $120,000 upgrade. Oh my goodness, they dropped everything into that. It was amazing, and I'm going to go there and do some training with some of the crew up there to see how everything works. So I'll be Wednesday afternoon at least. I've got to take time off. I've got to schedule that right now.
I'm not a camel.
Okay. Josh says, when is my courthouse going to change colors? I've been green forever. How do I find out exactly how long I've been a member? I think... Give me just 1 second. Let me see if I can find that for you. Studio memberships. I'm trying to find it for you. I don't remember. Okay. I did win my fight with YouTube, by the way, for those of you that are curious. There was a particular day when there was a lot of generosity, when a lot of you were trying to hit a certain person with the gifted membership and it was not working. I'm looking at you, Adam. And at the end of the day, I'm like, wow, that was an incredible day. Just the number of gifted memberships were off the charts. Like, I don't remember ever, well, maybe one other day in the last 18 months we've had that many gifted memberships in a day. And I went back the day after, because everything updates the day after on YouTube, to see what the totals were. And it basically showed nothing. I'm like, okay, I know that's wrong. And I called YouTube. It took till, that was, I don't know what day that was. That was the 10th. It took till today for YouTube to get it fixed, but they just fixed it this morning. So it shouldn't have affected anyone else. It was just on my side that just didn't connect everything together on the account. I don't RA, if you're on the movie set, I don't think you would be stopping to check that every time. It's actually in the actors rules somewhere, did a video on it. 2 others check before you. I agree. And I'm telling you, it is so ingrained in me. Like, every time somebody hands me a firearm, they can tell me it's unloaded. They can show me it's unloaded and hand me a firearm. I'm still going to verify it myself. That's just how I was raised. And so it's hard for me to separate my personal experience, and because I have never been an actor on a movie set, to separate that and say, oh, I'm good. This is a cold gun. I can do what acting I need with it. I'm scared to death of that. All right. Miss McGuire, member for 5 months, says, so happy to be here. I feel as though I've known you all forever. My second family. Josh, I think it was Josh. I cannot find... There's a perks button somewhere that shows... I don't know. There's a perks button that shows your membership information and may give you information about how many days you've been a member and everything when you're going to upgrade. Can somebody help him out a little bit? Look on the spot that says see perks. That's the one. I just can't see the spot. I've been on a couple pages, but apparently I'm not a member on my own channel and I can't see the perks. Okay. Thank you, everybody, for helping him there. Oh, it's right next to Recovery Addict and the subscribers number on the main page. There you go. There's your answer. All right. We have simply Nikki. Welcome to the gallery. Look at that blue courthouse by your name. Thank you. Thank you. Appreciate your support. We have a little bit of court hopping we're going to do. Was I in the middle of a conversation? Did I forget to tell you something? Man, the brain fog is thick today. No, we were looking at upcoming stuff. That's what we were doing. Okay, today is July 15th, 7:15. We have a pro se defendant in Judge Wolf's court today. I'm showing 7:14, 7:15. So we're going to keep an eye out for Judge Wolf. There may be a pro se defendant making an appearance there. I don't see anything else. Judge Simpson has those 4 teens that were tried in that protest at the college. Squirrel. Going to be on the 18th. That's on Thursday. That's all we got this week. We just have nothing big happening. And then Ashley Benefield starts on the 22nd. So.
When are we going to break for lunch, Judge?
Pro se defendant cases. Let me take a look at Judge Wolf really quickly. While we do, let's jump first to...
This is not Burger King. People do not get to have it their way.
Judge Chisholm's
Somebody just
channel.
sent me a video of roaches fighting.
Who I think is...
I don't know who won.
It was on vacation or something. Let's see what's going on here this morning. It's awfully quiet, and everyone's holding very still, as if they're not moving. Oh, they just cleared it off. All right. Let's see if Judge Wolf is up yet. Judge David Wolf. He is not live yet. Let's look for Judge Simpson. Judge
Shame on you, sir.
Judge Cedric Simpson.
I
saw a chicken fighting. Never seen that before. Real colorful chicken. I cannot find Simpson. Let's see. Let's try this guy here.
The trial as well too.
Bug Dugger.
Right. Mr. Berry, are you ready on anything? You ready on Ledford?
Yes, sir. I'm ready on Ledford.
Let's call it. City of Detroit versus Henry Lamar Ledford Jr., case number SB 148022551. Appearance for the record, please.
Elwood S. Berry Jr., on behalf of the defendant. State your full name, Mr. Ledford.
Henry Lamar Ledford Jr.
Your Honor.
Yeah, today is the date time set for a trial. I'm going to bring Officer McLean out. I did offer that Mr. Ledford did request an appointed attorney. However, there was one, I can see that no one called him because there was no notice of appointment in the file. Were you able to work something out?
Yes, Your Honor. Per the prosecutor, this matter is to be dismissed.
Okay, so we don't have to have it. I know there's no objection for you. Officer McLean, can you put your appearance on the record, please?
Yes, sir. Police Officer Cedric McLean, Badge 4012 with the Detroit Police Department.
Good morning to you. I'm gonna dismiss the case for city attorney, all right?
Yes, sir.
There's nothing further. Have a very good day. Be safe out there, Officer McLean, and you too, Mr. Ledford.
Thank you, sir. I appreciate you guys, and you guys have a wonderful day. Thank you, Your Honor.
Waiving the warrant fee as well. Have a good day, sir. You're welcome.
That's a good outcome. Got the whole thing dismissed. Canton. Oh my goodness. Let me stop for just a second. Canton, the select board that has just been crazy, absolutely crazy the last couple of weeks, which we're going to follow. They have a meeting every Tuesday and Thursday. They have just decided not to air it on, well, not to meet in person anymore. They're going to do it over Zoom. It might still be aired on Canton TV. We might connect directly via Zoom on that one, though. We've got the connection information. I think we're going to still bring that to you. The thing about Zoom is they're going to have a lot more control over the participants, and so they're just going to cut people off when it's time to cut people off. It's going to be interesting. But the Canton meetings, so they're trying to do this to sort of control things a little bit. Trying to see if we have some other more interesting courts that are live right now that we can follow, especially with a little better audio than that. Let's see. Judge Simpson is not live yet. Chisholm's live. Man, it's a quiet day. What about Misaki? Have we been to Misaki before?
Time is that hearing set?
9:30.
9:30. And we will make sure that you get a copy of that mailed to you. Miss Carey will get the address from Mr. Saladin. We'll be back here on the 29th at 9:30. If you choose to have retain an attorney, you may. Do you wish to have the court appoint an attorney to assist you?
No, Your Honor, I'm probably going to have Mr. Burnett.
Okay, thank you. Now, I've already said several times, we've never seen this happen here. None of us have, because the law changed again just a couple of years ago. This is the first time it's ever snuck up. So we'll deal with it on the 29th. Thank you.
Thank you, Your Honor.
All right, so thank you. Adjourned.
Is she typing on a regular keyboard? That doesn't look like a stenographer type. The custom keyboard. That would be amazing if she's able to keep up full typing on a regular keyboard. Do we have another case here, or are we moving on and out? See if the judge stands up or if he stays there. There's a new file. Special delivery. Oh my goodness. I'm going through all my messages here on the burner phone. I've got some crazy ones. Nurglerot, I just saw your injury from the thorn that went through your foot and your shoe. That's not a thorn. At that point, it's a spike. When they get that big, and that sounds incredibly painful. Let's see. Thank you, Abina. I have heard about that case. Interesting defense there. She got her Mega Key 6000 gamers rig. It's a loud keyboard for sure. I think it's a mechanical keyboard. It's like a. Hey, here we go. Hello, ma'am.
You're on the record now for 28th Circuit Court and taking up the case of people in the state of Michigan versus Molly Marie White. This is file 24-13886 FH. Appearances from counsel, please.
Joanna Carey, Chief Assistant Prosecuting Attorney for the People.
And I'm Jeff Harrison, here on behalf of Ms. White.
Ms. White joins us today via Zoom from the Wexford County Jail. Ms. White, are you able to see and hear the court?
Yes, sir.
We are here today for a defendant's motion to modify the terms or conditions of bond. That motion was filed back on July 1st. The argument is that the defendant has been accepted into an inpatient treatment program. Mr. Harris, I'm sorry, and I did receive a written response from the prosecutor, and I've gone over both. I will note that motion did include a statement from Addiction Treatment Services in Traverse City. Mr.
Well, for on the rarest of occasions, I will say this. I don't know that the record needs any more supplementation from that which has already been supplied to the court. It is not a complicated issue from our perspective. Just for background, perhaps to flesh out the record a tiny little bit. It's our policy that the client, the defendant in this case, do the legwork, at least on the initial stages, because the determinative factor of somebody's ability to succeed or have a positive experience in rehab is their willingness to submit to that sort of treatment and their wherewithal to persevere through that treatment. I will say this, I'm impressed with the level of stick-to-itiveness that Molly Marie White has exhibited here. We've had to change the date a couple of times due to various entanglements and scheduling issues and that sort of thing. And she has been consistently able to maintain her contact with the rehabilitation people and to get a new date as necessary in light of the court schedule. That having been said, Your Honor, the nuts and bolts of it are kind of straightforward and are contained in the written motion. Thank you.
Carrie, have you done a scoring?
Yes, and I put it in my written response.
You know what?
10 to 46.
Yeah, I really did that. Thank you.
That was in your.
Give me a minute here. We're trying to find a couple different feeds here.
Yeah.
Get a few options ready for you.
For what it's worth, Your Honor, I concur with that story.
Ms. Carey?
Thank you, Your Honor. I will note that the letter from Addiction Treatment Services has a date that's already passed for an admission date. We don't have any information on a new date. Or there's been nothing provided. Her criminal history dates back 2006. This is not her first controlled substance conviction. She has in 2012 2 convictions for delivery and manufacture of a Schedule 1, 2, or 3 controlled substance. She has possession of methamphetamine, habitual offender second in 2018, use of meth in 2021, and possession of meth also in 2021. So this is not her first go around, and with her guidelines, we believe that probability of conviction is very high. This is serious.
What was the nature of what are the nature of the allegations that led to the charge? In other words, was it a traffic stop? Was it found on a person? Things like that, give me an idea as to the nature and likelihood of conviction underneath the court rules.
Traffic stop.
All right. Was she the only person in the vehicle?
No.
All right. Was it on her person? Allegedly? All right.
She attempted to conceal her identity. She wouldn't provide her name. It was.
Defendant reactions aren't helping her right now.
It was not, Your Honor. We recently completed a preliminary examination. The material in question was found inside a winter glove that was in a pile of the belongings of the 3 people in the car.
That the defendant removed from the car after being asked to remove her belongings.
Yeah.
Right.
So,
all right. So, okay. So there's reason for asking that. I'm going to come to the reason in just a moment. Has she had any other rehab efforts, Mr. Harrison? That's always something that's good to note inside when these things are being requested. Recently we had a case that I dealt with over in Big Lake City last Friday, where when it came to sentencing, I looked at this defendant who had a significant criminal history, #4s, stuff like that. But what tipped the scale for me was he literally never had any treatment program. So what it's important to know, has she had any in the past?
She has, Your Honor.
So
generally speaking, you know our response to that is that sometimes perseverance is the key to success, and this is another example of that.
Well, so here's what I'm struggling with. And again, when the court looks at pretrial release conditions underneath the court rule MTR 6.106, as the council all know, the court looks at the likelihood or nature of the conviction, likelihood of conviction, nature of the allegations. And I don't want to say anything about her. It sounds like she's got some arguments. So what I'm sitting here looking at is a person who simply, I don't know, doesn't want to. This is really difficult. These become difficult because don't want to comment or make a decision based upon her right to remain silent and her right to have a trial. Because of that, I'm only left, if I had, for instance, if I have an admission, yes, I have a problem, yes, this was me, then I've got an idea, but I've got a defendant who isn't at that level yet. And I'm not trying to force her, because I don't want that. I can't do that, and I don't want it. I want to make sure she has her day in court. So really what I have is I have a defendant who has had problems in the past, has had rehabilitation based upon what Mr. Harrison has said, and might need more. Maybe it did or didn't work, But really, I've got a person who's facing life in prison who doesn't want to sit in jail. So, hold on, Ms. White, you do have the right. I mean, this is your motion, but I'm not going to ask any questions. That's really dependent upon Mr. Harrison. Mr. Harrison, do you wish to call your client as a witness?
I do not at this time, Your Honor, for
obvious reasons.
I would think would be fairly obvious reasons.
Ms. White would have the right, if Ms. Carey were to ask a question that could inculpate her, she would have the right to invoke that, the right to remain silent. We wouldn't want to prejudice her that way. So I understand that's why you don't want to ask her any questions. I think that's fair.
I think at the end of the day, you could look at, obviously the allegation could be leveled, has been leveled, that this is an end run or some kind of effort merely to avoid being incarcerated. And I never know how to respond to that, Your Honor, because ultimately that is what we're asking for. I mean, it boiled down, that is what we're asking for. I think the significance of the reason for the release to attend substance abuse treatment, that is not an easy road to hoe either. So it's not like we're asking for a furlough to go to Disneyland pending sentencing either. So somewhere between the two extremes, I think, is where the truth, I use that word begrudgingly, lies.
Well, again, when I think about this thing, I don't want to impugn somebody for invoking the rights, because I greatly respect that they have the right to remain silent, they have the right to be presumed innocent and proven guilty, and so forth. But I also note that, you know, a lot of drug treatment programs, sobriety court programs, the law requires the defendant to have to enter the plea first to even get the benefit of that program. And I have gone on record and said that sometimes part of my reason for allowing bond, sending people to rehab programs is kind of my way of doing a mini version of a drug treatment court, because I get a conviction and how they perform in the rehab program impacts the sentencing and whether, you know, and I'll take that into consideration. So, all right. Based upon, I'm sorry, Ms. Carey, what was never mind. You have it listed here. Court finds here, at least for today's purposes, that there is some likelihood of conviction. But, sorry, that's a really silly way of saying it. That there is a strong likelihood of conviction, but then again, there's actually a pretty good argument. So it's really, I said strong, I guess I'm going to say that it really is somewhat questionable. I don't know anything more about the facts other than what the attorneys have said. At the same time, there appears to be some issue or some actions, at least for the purposes of pretrial release, that the defendant was providing false names, making furtive gestures, efforts to maybe derail the discovery of evidence, such as trying to hide it or throw it out of a car or whatever. The court also looks at the defendant's prior criminal history and can say that in the last 12 years, she's had 12 years, she's had multiple convictions involving controlled substances, 1, 2, 3, 4, 5 of them, and now finds herself facing at least what the court considers, if it's a 10 to 46 with a tail of life at the end. If found guilty at a trial, or even at a plea as charged, she's probably looking at most likely a prison sentence. And the court finds that based upon the nature of the potential life, the threat here of a prison sentence or likelihood of a prison sentence, the court finds that the bond previously set is appropriate. And even though sometimes I have been a little bit critical of the amount of bond set for this, in this particular instance, again, I think the $100,000 when someone's facing potential in life and has had a repetitive problem with controlled substances makes that person a threat and flight risk. And because of where the case stands right now, the court denies the bond modification. I also don't have a date when she's set to go into the program. So
we neglected to attach that. I did email that to just now from the table.
Oh, okay.
It is set for tomorrow. It's largely moot in light of your ruling.
All right.
But it was set for July 16th at 9 a.m.
All right, I do accept. I'll accept that statement from Mr. Harrison as an officer of the court. However, still.
I've never had help like that. I went to Odyssey House for 9 months. I relapsed. My mom got sick. Like I did relapse. However, I asked for help this time. I know I've been in trouble for drugs.
I understand, ma'am, and I appreciate that. And I understand your desire to make a statement today. Mr. Harrison, as counsel representing you, chose not to ask questions. I respect the decision. Why? I don't think it was ineffective for not calling you, because if he had, we'd have other information, questions, about relapses and things like that, which right now doesn't help you. So the court stands by its ruling. The court denies the bond modification motion. Thank you. Eric.
All right, Allie B from Tennessee. Happy Monday, everyone. Thank you very much, Allie. 14 months. We're jumping around a little bit. We've got a couple other courts we're trying to line up. We're watching for Judge David Wolf. We think we've got a pro se defendant in Judge David Wolf's courtroom today, but he's not come by yet.
Possession.
No new letters from Sarah Boone yet. Keep an eye on that as well.
23.
See if we can get some other courts for you this morning.
You have Mr. Berkshire. All right.
I do.
So we are, here we go, Nancy. We are back on the record, and this time we're going to take up, looks like we have two cases here, and they're each entitled People of the State of Michigan versus Scott Allen Brookshire. These are case numbers 23-13533FH and 24-13791-FH. The court recognizes Mr. Brookshire, who has joined us today via Zoom from a treatment program. Am I right, Mr. Harrison?
Correct.
Mr. Brookshire, are you able to see and hear us, sir?
Yes, Your Honor.
All right, thank you. Appearances from counsel, please.
Good morning, Your Honor. Corey Williams, on behalf of people. And I'm Jeff Harrison. I'm here on behalf of Scotty Brookshire.
All right. So we have sentencing set for today. In the 2024 file, we have a conviction for possession of a controlled substance less than 25 grams. Looks like we took this plea 4 months ago, back on March 15th, 2024. And then we're here today for a sentencing in the 2023 case, which is a probation violation. And that's based upon the same misconduct. Am I right, Mr. Saladin?
Your Honor, I'm sitting in for Van Amel. Yes, that's my take.
And again, I didn't cover it. Mr. Stephen Saladin.
Yeah, I'm going to jump here
today on the record with.
He's clearly a robot.
Sorry, on behalf of the Michigan Department of Corrections, standing in for Agent Sean Van Atmel. All right, so Are we going to proceed today with sentencing? I think we've kicked the cans on this to allow Mr. Brookshire to continue in rehab.
Yeah, and we're comfortable proceeding today or whatever.
Mr. Wiggins?
I have no objection.
All right, thank you. So let's go ahead and take, well, wait. In the past, did we go over the PSI? I don't see any corrections on here, so.
No, we
I
did
don't know
not
if
go
we-
over it.
All right, let's start first with the.
Let's
the
jump.
2000,
We'll do.
the
We're gonna jump
PSI for the
to-
2024.
Called this morning to get in the Zoom, but I haven't
I
received
have a
any.
new address to provide the court, Your Honor, which I think is
I
what it's
see.
to say.
We'll figure that out. So here we go, Mr. Buzan. The first hearing is called a pre-trial,
Gotcha.
and that's on August 8th
Gotcha.
at 1 p.m.
Thank you.
Do you want all 3 dates?
No, just that first one is okay.
The first one. Perfect. Okay. And then let's address the new address.
The keyboard
Mr.
is
Foreman,
just
did
too
you
much
provide
for
that
me.
to Ms. Horn?
I just sent it to Ms. Horn in the chat. Yes, Your Honor.
Okay, perfect. And is it's Lansing? Okay. Mr. Buzan, you gave a new address to Mr. Foreman in Lansing. Is that correct?
Yes.
Is that your current good, stable address?
Yes.
Okay, that's the address the court will now use to send all mailing and all notices for you to appear. Okay?
We're in Lansing, Michigan here.
We'll get that updated today. With that, Mr. Foreman, would you like to be heard on bond?
Thank you, Your Honor. I spoke with my client this morning. He informed me that he's lived in the East Lansing area his whole life. He's currently living with his mom at that address on Champion in Lansing. He's also working. He works at Meyer Warehouse. So that's a good, stable job. He informed me that he has no criminal convictions. There is some driving history, but no convictions on his record, and he was very forthright with me about that. So we would request a personal bond in this matter, Your Honor.
Okay, thank you very much. Mr. Buzan, did you hear what Mr. Foreman told me?
No, yeah.
Is that all accurate?
Yes.
Okay, so Mr. Buzan, when I make a bond determination, I need to consider 2 main factors. The first is, will the person appear for their court dates? You've appeared here. From what you're telling me, you went, out of the way because you didn't get the mailing you needed, but you took the steps necessary. That shows me you take this seriously. You have a lawyer now. All those things give me reason to believe that you will always appear for your court dates. Am I right?
Correct.
Okay, and then the other factor has to do with public safety. And Mr. Buzan, what you need to understand is that there are public safety concerns inherent in these allegations, where the allegations that you were driving, not just carelessly, but recklessly in wanton disregard for other people and their property on the streets of this community. And then on top of that, your driving record isn't great, especially for a young person. You've had a careless driving in the past and a speeding ticket. So, Mr. Buzan, what I just need to know and be convinced of right now is that I would intend to order you that you need to drive in conformity with the rules of the road. And, the other way I could do this is not allow you to drive while you're on bond. I don't want to do that. You're working. You're presumed innocent. I want to give you that, obviously you have that presumption, but I need to know that you will conform your driving to the rules of the road. Is that something that you can assure me today?
Yeah.
Okay.
Yeah.
Anything more you want to say on that front?
Nope. Just
yeah. Not at this moment, no.
Okay. Anything you want to say on that front, Mr. Foreman?
Your Honor, just he and I have had discussions about, making sure that we didn't have a specific discussion that you might order, no illegal driving or anything like that. But I think that would be a fair condition for a bond, given the background here.
Okay, very good.
That's not a condition. That's a standard that we all have to apply to.
Your bond is $500 personal recognizance. That means I'm trusting you to always come to court for the reasons stated. And that means, Mr. Buzan, I'm accepting your verbal assurances today on the record that you will comply with my bond conditions and thus are not a public safety threat. Mr. Buzan, your conditions are as follows. You must appear as directed. You may not leave the state of Michigan without permission of this court. You must not commit any crime while you are on bond to this court. And you must not engage in any illegal driving. Understood?
Understood.
Okay, I have one more thing for you. You need to have your fingerprints taken, and I'm signing an order to that effect right now. You must have your prints taken at the East Lansing Police Department. So you'll receive an order with instructions on how to comply with the order. Mr. Buzan, pretty much what you need to do is call the phone number on the instructions, which is the East Lansing Police Department, and set up an appointment to have your prints taken. You must have them taken by July 29th.
Welcome, Darlene.
Okay.
Any questions about that?
You said East Lansing Police Department?
Yes. Do you know where either the East Lansing Police Department is, or it's also the same building as the court and City Hall?
Okay.
It's right downtown East Lansing. The address is 101 Linden, and that address
You've probably
is
sped
on
by it
the
before, Zachary.
instructions.
Okay.
Okay. So are we clear?
Clear.
Very good. Mr. Foreman, anything further?
No, Your Honor, thank you.
Okay. Thank you so much. Good luck, Mr. Buzan, and we'll see you again.
Thank you.
All right, Mr. Buzan.
Jonathan, that's it for you.
Great, thank you.
Jonathan,
Thank you.
you can go home now. Oh, that was the voice of Kate, I think, that was speaking. Let's see what else we have. Josh Hutchings has told me we've got a case coming up in Thurston, Washington, which is literally a West Coast case. So it would start later in the day. Usually they start around lunchtime. But let's see, we've got a 7-day trial. Let's see what we got here. State versus Telus, 7-day trial starting at 9 Thurston time. And Telus is... trying to see what the charge is here. Driving under the influence, 3 or more priors in the last 10 years, operating a vehicle without an ignition interlock when required, and driving with license suspended first degree. They have a 7-day trial for this? 7 days for a DUI? That's as long as, Alec Baldwin's was slated for involuntary manslaughter. Interesting. Okay. We'll keep an eye on Thurston County for that. There might be a couple other cases as well up there. As we wait for this to join, let's see if we can jump to court 3, see what's happening here. Camera 3. Oh, it's Judge Shackelford. Do we have some audio maybe? That'd be great if we got some audio. Looks like we have possibly a defendant whom I'm blocking. Yep. Why is there no audio? Give us 3. What's happening here?
Ma'am, okay?
Okay.
All right,
my
Miss
fault.
Farn, you're all set.
Thank you.
We'll get the next one here.
Okay, Miss Patton. Do we have Miss Patton in the courtroom? Let me find her.
Paging Miss Patton.
We have her? Where's she at? I just saw her. I was trying to bring her in.
Your Honor, and we have one of the complaining witnesses present as well.
All right. We're looking for Miss Patton. I know she was here. Yeah, she's
hiding.
It looks like, oh, here she is. She's way down at the bottom, room 26. I don't know how she got there. Do we have the complaining witness present in the courtroom?
He's on Zoom.
Hello.
Hi, Miss Patton, turn on your camera for me, okay?
Okay,
All
I
right.
could
Give me
see
just
only
this-
the
It's all right. Give me a second. Is it Daniel Callow? Let me see if I see him here.
Defendant is Monica Patton.
I don't have Mr. Callow in any of the breakout rooms. I don't know if he left, but he is not here.
Your Honor, I just spoke with him and he was present. I can call him again to come onto Zoom. Otherwise, I think Mr. Gazicki and I have an understanding of how this is proceeding.
All right, well, let's just call him and we'll go forward. I saw that he was present earlier. This is 231302 and 240003, the People versus Monica Patton.
Good morning, Your Honor. Jessica Davidoff, the People, P86743.
Good morning, Your Honor. James Gazicki on behalf of Ms. Patton. Your Honor, as to the case 23-1302, we're moving for dismissal. This matter was set for a settlement conference. That victim did not appear. On the other case, we're asking for a jury trial.
Okay, on case ending in 1302, the case will be dismissed without prejudice. The complaining witness has failed to appear. And then on Monica Patton, the case with Daniel Callow, we're setting that for a jury trial.
Yes, Your Honor, with a final settlement conference in person.
All right, let's look at dates. This one is one of those, a city day. I'm trying to see Miss Davidoff if we could do October 4th.
Your Honor, I don't think I can do October 4th. Is it possible to do the 25th?
Mr. Gazicki, can you do October 25th?
Yes, I can, Your Honor.
All right, 1 second. Let this pause and just check real quick.
Anyone know
All right, jury
what
trial.
the charges are?
Jury trial will be 10/25 at 9 a.m. And the final settlement conference will have to be October 9th. Oh, I'm sorry, October 7th,
Okay.
10/7 at 9 a.m.
October sounds far away. Before you know it, we're going to have
And
Ryan
you'll get
Koberger's
notice, Ms.
trial
Patton, of
started.
those dates. You must appear in person on those days.
Okay, person.
All right.
Thank you, Your Honor.
Krista,
So,
welcome.
All right, we're all set.
Outpatient. I'm doing outpatient. Okay.
Ms. Patton, you can appear via Zoom on 10/7, and you'll have a jury trial on 10/25.
Okay, thank you.
All right, you're all set.
Thank you, Your Honor.
Continue.
Okay.
Thank you. Are we ready on Gilmore?
Yes, Your Honor. The people are ready.
And Gilmore, I haven't spoken to Gilmore. I don't know if
see if
Gilmore's here.
Yeah, I don't think so. Oh, yeah, he is. He's in House Counsel 6. We'll get you that file.
It's gonna be in person.
Okay.
Well, she's muted here. Krista, welcome. I imagine you're late because you were rewatching a bunch of stuff from what I can see. You were on the replay crew. BK starts, I think we've got a June date for BK next year. I'll just double check. The date might change, but we have the month of June, I think, as the current schedule. But the courthouse is going to change here probably next month, I think. The courthouse will change. 3 months goes fast. It does. Let's see. BK trial gives me chills. It's going to be a crazy trial. Another great watch. Judy, Judy K. McGee, my courthouse needs renewed today. Wish I could afford buying membership, but I'm grateful for the gifted membership. Judy, keep your gifts on. It'll happen before you know it. Let's see. We'll have Sarah Boone, which I myself am looking forward to. Sarah Boone happens on... Let's see where she's at. Oh, I've got her court date pulled up right here. 10/7. 10/7 is court. We'll see her in a hearing on 9/24. So we basically got 2 months till the next hearing. Before then, we will have a letter. We'll have a letter from Sarah Boone. October 7th, my birthday for Sarah Boone. Ashley Benefield next week. We're planning on that trial right now. Apparently it's 3 months to my birthday. Bug Dugger just gifted 5 memberships. Thank you very much for your generosity, Bug Dugger. Looks like the gifts went to Canty Black Fox, Mary Sue Powley, Vicky Hendricks, AJ, and let's see, Tracy Grover. And look at this, Judy K. McGee was gifted a membership by Allie B. from Tennessee. So just like that, Allie B. from Tennessee came through, Judy, and hit you with the membership. Thank you very much for your accurate gifting, Allie B. That's amazing. Thank you as well, Bug Dugger, for sharing 5 memberships. That is really cool. How long has Sarah Boone been pushed back? Megan, no, they have not moved Sarah Boone's court date since she got her last attorney. This 10/7 date is sticking. And even though she's pro se and she has no attorney, she'd like one, this date is sticking. So if she gets attorney between now and then, it's going to be, they have to work quickly. She's
Good morning,
unmuted.
Ms. Persicone.
Good morning, Your Honor.
How are you? It's good to see you.
Likewise.
What do you have this morning? There you are.
PCC with Doug Harlan today.
Okay, let's see if your client's here. Have you checked in already?
Checked in.
Did you meet with a check-in clerk?
No, I have not.
All right, let me see.
I was sent right to your courtroom.
Okay. I don't see your client here yet, but the clerk will check you in. He's scheduled at 10, so we've got to, oh, there he is. She'll check him in and then we'll get you in a breakout room. Do you need to speak with your client and the prosecutor?
I do. My client's all set, actually. I don't need to speak with him, but I do need to speak with the prosecutor.
Okay, we'll get you in with Miss So.
Perfect. Thank you.
Yep.
Hey, Donnie, your messages keep getting zoinked out because they're in all caps. If you can turn your caps off, that would be best for everybody. All caps causes problems for us. This is how the deals are made right here. Backroom deals. Keep checking, seeing if we have anything from Judge Wolf yet. Got nothing. Let's see if we got Judge Simpson.
Here. Amy, I got it to open. Oh, you know what? I went straight to voice.
So Airbnb update for you. We've got some renters that are here for a little over a month, right? Which is cool. We like them. And I'm sitting in church and I got a text yesterday. So the fridge, the kitchen, and the laundry room power doesn't work. I'm like, this is literally brand new construction. It's brand new. And I'm like, okay, so the power doesn't work. That's got to be somebody tripped a breaker somehow. All I can think of is that possibly the coffee maker we have in there might be on the circuit that caused a breaker to trip. Because if they were running like the fridge compressor and the, but I'm like, laundry's on its own circuit. Everything's on its own circuit. What's what? But yeah, a breaker tripped. And so we've got the electrician coming today to upgrade the breaker. We're going to a 15 amp instead of a 20 amp instead of a 15. But let's see what's up here. This is a big view. You can see all sorts of stuff. East Lansing. It's not quite the Heavenly Wood courtroom, but it's quite nice. It's pretty neat. No worries, Donnie. No worries. Glad you got the caps fixed. Judge Simpson's not live right now. Looking for him, Judge Wolf, any minute now. Judge Wolf might have a good one today. Deals in the breakout rooms. Mary Sue, I think you're going to get your wish there. Brian Koberger is going to be in Boise, I think, for sure. Oh, this is Purgatorial Wood. It's the other version. It's the other side of the cherry stain on the wood is dark. Not a fan. It is pretty deep. Deep cherry. Oh, Dusty,
Thank you.
I told them I would be there within half an hour to fix it if they wanted me to, or if they were comfortable cycling the circuit breaker, they could do it themselves. They're like, oh, we got it. It's working. Never mind. Sorry for the inconvenience. I'm like, no. Or I'm sorry that it was out for a little while. We'll be there to fix it tomorrow. So we want to keep people happy. No, I was not looking for a way to get out of church. What's funny is my electrician was there in church with us. And so I'm like, hey, Monday. And so I didn't even have to make a phone call. I could schedule it right then. Fix the problem now, save the headache later. I agree. My idea of a perfect rental is everything just works for the renter. It just functions. Vicky, I'll scan for your mail here in a little bit. Red Pen, we had never tested. I don't drink coffee, so I don't use a coffee maker. But I guess the coffee maker has some sort of a heating element in it, and typically those type of heating elements draw the most power out of all the electrical devices. So we'd never tested it on that circuit. And I think it's on the same circuit as the fridge because it's there in the kitchen. But we have put each socket in the kitchen on a different circuit.
Ms. Moynihan, good morning. I see you've joined us on Canon. We are trying to get a hold of Mr. Polk. I don't know if you can get him on for us.
Do you see the little flashes on the judge's remote right there? That is infrared light, and it's visible to our eyes because it's being picked up by a camera that does not have an infrared filter. So she's pushing the button to mute and unmute the volume. Fun fact, pointing a remote control at a camera can often detect the infrared light. Selena, we're super excited about this. We've had a lot of shorter term rentals, nothing much over about a week and a half. But now it's going higher. So you can check your TV remote, see if the batteries are dead. Here's a sort of depressing courtroom. Not a lot happening anywhere else. Hey, there's a defendant Gilmore outside on a walkabout, getting a little fresh air.
Mr. Gilmore, if you could just mute yourself as soon as we get the attorneys back and we'll call these cases.
Yes, ma'am.
Yeah, we don't want to hear the birds chirping and the bees buzzing there behind you. Wait till they start bringing, hey, Gordon, none of that. It's fully furnished. They have no need to bring furniture. Judge Boyd is just going live. There's one we can jump over to. me a second. We'll get her pulled up for when she appears. Everyone's having a late start here. Judge Boyd in the morning is a lot of fun. You can always tell if she's a little bit spicy while she's calling roll. Oh, Dawn, I am so sorry. Oh no. Thanks for stepping up and doing that. Let's make sure we got audio here. We're good. Just waiting for the judge to unmute. I think we've seen this purse before. She's got two purses. One I think is actually a vase, a purse vase. Lots of flowers here today as well.
Just sent me a video of roaches fighting. I don't know who won.
Wow. 2 months. That is terrible. Oh my goodness.
All right, everyone. I'm going to call the docket, and I think we're going to have a problem today because the elevators are not working. I thought maybe they were going back to the 40s where you have an attendant working the elevator. I was this close to tipping him. Then I realized, no, the elevator is just broken. They have instructions. So I think defendants are going to be late today, so I'm going to give them a little bit leeway. In custody, we have Jose Mejia, Bernice Valdez. It's going to be a Monday.
No, Judge, no.
Well, at least the clock works. Nelda Rios, custody. Wilfred Salinas, custody. Jose Barrera. Camila Scavon.
Your Honor, President, counsel is present. He was ordered to be on Zoom today. I believe they're standing.
All right, yes. And I'm just, as soon as, I think he may be already on Zoom as the iPhone. So just as soon as I finish the docket, we'll take you up.
Thank you, Your Honor. Let me be patient.
All right, thank you. Oh, patience is key. Jose Lopez, custody. Arturo Villanueva's by Zoom. Jesse Arriaga. Thank you. Raymond Amaya, custody. Joshua Wong. Melanie Barron.
DSN gifted 5 memberships. Thank you,
Christopher
DSN.
Herrera, custody. Dundre Scott. Frederica Ojeda.
Counsel is present, Your Honor. I will find him.
And did I pronounce his last name correctly?
Yes, Your Honor.
He's not even here to see that. That doesn't happen often. Michael Johnson, Nicholas Estrada, custody. Ezekiel Neely. Ramsey Ibrahim. Luis Beltran, custody.
Allie,
Ovalle Torres.
Dr. G is an amazing guy.
Freddie Jacinto.
I can't speak for him, but I definitely would encourage
Luis
you to reach out to him.
Martinez, custody. Felix Maldonado, custody. Deshawanda Robinson. Daniel Guerrero. Eli Stribling. Makisha Cyphers.
I bet he would talk to you.
Councilperson, I expect her, Your Honor. I know she's in.
All right. Now I'm giving everybody a little bit leeway because the elevators have complicated instructions on them. Leon Small, custody. Joshua Tejas. Thank you. Roseanne Garcia, custody. Fernando Cordova, custody. Carla Hernandez. Thank you.
Our mods are amazing. They are they're very busy. They get contacted by a lot of people. So please give them patience if they don't respond to you right away.
All right. Is there anyone who came in late or your name was not called? Yes. Desiree Gonzalez. Do you know your case number or SID number? Okay.
11772.
And have you had any contact with your attorney?
No, not as a recent.
Who is your attorney? Do you know? Otoro Alfonso? All right, we're going to make sure that you're able to get in touch with your
Looks like
attorney
Judge Wolf
today.
just went
Just have a
live.
seat and we'll get back with you. Anyone else? All right, attorneys, I always repeat these rules because when I don't, I find that attorneys don't follow them. So these are the rules. Criminal trial division is there. Their files are there. Family violence files are there. Just grab your file, place it on either prosecutor's table, have a seat.
We're gonna pick up Judge Wolf's trial. Just 1 second. Need to shut down this one and bring in this one. Go full screen on 7. Why are we not getting audio yet from Judge Wolf? This is our guy. This is our guy. He's the pro se. Come on, come on.
Because he's the guy.
The witness problem, the state has indicated that they may be wanting to dismiss the case against Matthew Aldridge. But Matthew Aldridge has not appeared in this court officially. So what I want you to understand is this: you can play this game with trying to say that you are the attorney of fact or whatever. And if you persist in doing so, the only choice I have is to issue a failure to appear warrant for Matthew Aldridge. And if you, under oath, tell me today that you are in fact Matthew Aldridge, then we can take steps to try to resolve this matter. So it just boils down to, if you want to stand on your procedures, then what I'm going to do is, and you refuse to identify yourself as Matthew Aldridge, then I have no choice but to issue a warrant for failure to appear against Matthew Aldridge. And I'll have you step back with the officers and they'll try to identify whether or not you are or not. You cannot defeat the ends of justice or the justice system by simply trying to say you're not who you say you are. So,
may I speak?
yes, sir. Put that microphone up so we can make sure that, there you go.
By appearing in attorney in fact, I'm protecting my Fourth Amendment right.
Your Fourth Amendment right. What right under the Fourth Amendment are you asserting?
I have the right to my own private property, and I don't have the right. I do not have to give my name. It's basically the Fifth Amendment too. You're establishing evidence against yourself.
And I've explained to you what's the process is going to be today, correct?
I am aware. I am Matthew Aldridge, as described in the criminal complaints I've set out.
Hold on just a second. Raise your right hand and let the clerk place you under oath.
Okay.
Are we going to address subject matter jurisdiction?
I do.
All right. Now, are you Matthew Aldridge, the defendant in this case?
I am Matthew Aldridge, as described in the criminal complaint that I sent registered mail on Thursday against the witness.
Arrest him now, Judge.
I'm not sure that we have received anything.
Yes, the witness.
He sued the
We
witness.
haven't received anything. What exactly were you saying?
It's registered mail. I have my tracking number. It's at home. It is registered mail. It went out Thursday from.
So you're using the
Hendersonville.
government entity or a semi-government entity of the post office registered mail to send something to this court?
Well, every time I've stated something on the record in the clerk's office, you've always asked, I haven't seen nothing in the mail. And so I figured that's where you'd be looking for it.
All right. Well,
Majestic Unicorn.
you have identified
welcome.
yourself as Matthew Aldridge, the defendant in this case. And therefore, General Sagi, General Willoughby had indicated that he was going to dismiss this case based upon a witness issue that the complaining witness or the state's main witness was someone who is no longer with the law enforcement here in this area and was not willing to return based on issues that had happened. Is that still the state's position?
He's going to win. Going to dismiss the charges against our pro se defendant.
Yes, Judge.
All right. Then Matthew Aldridge, now that you have identified yourself correctly as the defendant in this case, then the state is moving to dismiss the charges against you because of a witness problem. Case is dismissed. You are free to go.
Thank you, sir.
All right. Next case on the docket is the State versus Laura Morris.
It was
We have set
nothing
that
he
case
did.
for trial on January the 15th.
It was nothing he did.
And the next case is
issue on the state
2023
side.
CR 19412, State versus Vishal J. Patel. That's Mr. McKinney. That's to be, was that the one that was moved to the 30th? Oh. That is now set for the July 30th date. And that brings us to 2023 CR 19431, State versus Wesley Sovine. Defendant is charged with solicitation and sexual exploitation of a minor. This is a hearing
we're
to
gonna bail
admit the
on
child
this one.
advocacy interview. Is that correct?
Jump back.
All right. Based on the nature of this charge and what we're dealing with, then we will terminate the live stream.
And we're off anyway.
Paper discovery, we would ask that digital discovery be sent over and set this for exam.
Okay, it's currently set for a preliminary exam next Monday, July 22nd at 10 a.m. Are you able to appear at that time?
Yes, Your Honor.
All right. The exam will continue then. It's in person, 7/22 at 10 a.m. at the 23rd District Court. I'll see everyone back on that date.
Thank you, Your Honor.
All right, have a good day.
You too, Lily.
See if we can jump back.
And
to
Mr.
Judge
Morrison,
Boyd.
your bond continues, you're all set.
Okay, thank you.
And Miss Moynihan, are you with us?
Hi, Judge.
Hi, I see Miss
Pearson.
Diallo is checking in. So, and I believe she's here for Mr. Polk. So,
Okay.
good morning, Miss Diallo.
Good morning,
We're going
Judge.
to
How are
jump
you?
back to Judge Boyd because she's ready to start hearing cases now that she's called roll and people have made it up the elevator or the stairs.
All right,
That
the
pro
court
sec guy got
is
so
calling
lucky.
2020 CR 12250. NIMAG numbers 746635, 746637, 746638. That party is announced for the record. State.
Zach Dunn for the state.
Defense.
John Young for the defense.
And are you Mr. Small?
Yes, ma'am.
All right, your attorney, Mr. Young, has filed a motion to withdraw. You're aware of that motion?
Yes, ma'am.
All right, State, do you have any objections?
No objections, Your Honor.
All right, State, you may continue to confer.
Thank you, Judge.
All right, defense, if you want to put your reasons for withdrawal on the record, please.
Basically three. He absconded, he cut off his monitor, and he instructed his family to stop paying me.
All right,
And he's told me he does not want my services.
is that correct, Mr. Small?
Yes, ma'am.
All right,
did
attorneys
all
don't
three
work
of
for
those.
free. All right, thank you, Ms. Young, Mr. Young, and each of the motions, your motion to withdraw will be granted.
Thank you,
You may be
Tom.
excused. Mr. Small, are you able to afford an attorney?
That's what we're working on right now. My family is.
I'm sorry, what?
My family's working on that right now.
What does that mean? They're working on it. When are they going to have it
I
done?
mean, I don't, honestly, I really don't know.
All right, just have a seat. We'll see about getting an attorney for you.
Okay, thank you.
You're welcome.
We are in Bexar County, Texas right now. This is Judge Stephanie Boyd. She runs a tight ship in this courtroom, doesn't put up with much flack.
Yes, have you pulled your paperwork? Oh, you need to give it to the clerks.
The only thing she can't control in her courtroom is the temperature.
Yes, I couldn't hear what you said.
Better call Saul. I think we accidentally deleted your message. We were trying for something else. Remember, it's Pickles, not politics in here, so we're steering clear of political issues. See if I can get this.
Freddie Jose Jacinto, where are you? Come forward. Counsel, you're on that side. All right, Mr. Jacinto, the state has filed a motion to dismiss your case. They say they're dismissing it because their witness is missing, which I'm assuming is the complaining witness. So whatever brought you here today, you need to internalize that and make sure you're not back in felony court or any court for anything else. Do you understand?
Yes, ma'am.
Do you have any questions about anything?
She's looking at his shirt. Thanks for dressing appropriately.
All right, you're excused.
Thank you, Your Honor.
You're welcome.
Thank you.
Yeah.
Somebody complained that, but you know what's so funny? Today is the day I'm feeling, the temperature is at a pleasant temperature.
I know it's hot, no one's like thermometer, because she's wearing a thermometer, and I can get her in it, but she's not wearing it, so I know it's hot.
All right, let me.
Please. Judge, it just makes you. Judge.
Yes.
That means not on the document, it was an add-on, me and Norma talked about it.
Okay. All right, let me take that.
Yes.
All right. What is happening with Moses Ross?
So Judge, this was a case where the GPS was installed and it was supposed to be removed on July the 1st, and you wanted to make sure because you gave enough time for the complainant to be informed that the GPS was coming off. Last week. We confirmed with family violence. They tried to reach out several times and there was no response back to them. Unbeknownst to me, someone from pretrial contacted Mr. Ross. He just told me that this morning. Contacted him on the 3rd of July, and the device was removed at that point. So today he was supposed to come in to talk to you about removing the device, and you were going to basically tell him to stay away from the complainant and then, we would remove it, but it's been removed. I don't know, Judge, if you want, I've looked in the file, I didn't see any type of order for it to be removed, but I don't know if you would still like to talk to him.
Is he here? Oh, let's bring him up.
Mr. Ross?
I'll say this. Honestly, I'm talking just very briefly about it.
All right, state.
This is one we talked about. We corresponded about the GPS renewal and we said that we had reached out to the community.
Yes. All right, so Mr. Ross, my understanding from probation and through probation's conversation with the state is that they were unable to reach the complainant. Is that correct?
Correct.
And we can go on the record and state, you can put on the record the attempts you made to contact the complainant if you so choose. Court is calling 2023 CR 3543 and 2024 CR 4456, State of Texas versus Moses Ross for the state.
Alan Jackson.
And we have probation officer, Miss Abrams. And are you Mr. Ross?
Yes, ma'am.
All right, so you are on GPS. The court did not want the GPS removed until there were attempts made to contact the complainant to let the complainant know that the GPS would be removed in state. What is the update?
Marina Winter has made 2 different attempts, including leaving a voicemail in an attempt to reach out to the victim and let them know we have received no contact back.
All right, so Mr. Ross, I want you to hear me and hear me clearly. You are not to have contact whatsoever with the complainant. Do you understand?
Yes, ma'am.
If you have contact with the complainant, what's going to end up happening is a motion to revoke will be filed. If the motion appears to be in legal format, I'm going to sign off on it. And then once I sign off it, a warrant is going to be issued for your arrest. You're either going to make bond or you're not going to make bond. And then we'll have a hearing on the allegations of no contact, if that's what the allegations are. You understand?
Yes, ma'am.
So is there anything you do not understand about the words no contact?
No, ma'am.
All right. So don't call her. Don't write her. Don't apologize. Don't say I've worked on myself. Let's get back together. None of that. Do you understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.
Thank you.
I'm surprised she didn't instruct him not to use someone else to contact her. It was basically an indirect contact.
This is not Burger King. People do not get to have it their way.
Okay. First round is
No, just send it 10 years ago.
Let's jump over to back to Shackle.
All right, ma'am.
Yes.
And you understand the prosecutor is offering you this under a diversionary status 7694A for a period of 8 months of probation?
Yes, ma'am.
Okay. And ma'am, knowing all of that, how do you plead to the charge of domestic violence?
I plead guilty.
I think you're
Has anyone forced you to get you to plead?
No.
Has anyone promised you anything other than the plea agreement to get you to plead?
No.
Are you pleading guilty of your own free will?
Yes.
All right, ma'am, what'd you do to make yourself guilty of domestic violence?
I threw a rock at my son's dad.
All right, and that you have a child in common?
Yes.
All right, and he did not want you to throw a rock at him, is that accurate?
Yes.
Were you accurate?
And I threw a rock at him.
Okay. Are you satisfied, Mr. Gazicki?
Satisfied, Your Honor.
All right, I'm going to accept the plea as knowing and voluntarily given. Ma'am, you'll receive notice from the probation department, and I also see Mr. Smith is present. You'll also receive notice, sir. They're going to conduct a pre-sentence investigation. And after that, we will come back for sentencing, okay?
Okay.
So if you don't get something in there to set up that To set that up within the next week or two, you need to call the probation department at this court so you make sure you don't miss your appointment. All right?
Okay.
And then we'll give you the sentencing date after that interview's been conducted.
Okay.
All right, you're all set.
Okay, Your Honor, hold on before that defendant leave. I know I dipped in, but I know the victim had some concerns about wanting to have communication with regards of the kid. I don't know if we addressed that before I got it back in.
Mr. Smith, can you unmute yourself? Are you requesting a limited contact?
Yes, I'm asking that something be lifted because before this incident, we were either contacting each other daily or every other day to be able to FaceTime our son.
Okay, so it's currently set at, and I'll make sure that it knows, or that the file's documented at this, but the bond will be modified to no assaultive contact, okay?
Okay.
So that means the two of you can communicate for purposes of child transfers, doctor's appointments, whatever it might be, but you can't, Miss Henry, you can't scream, you can't yell, you can't make threats. And if you have any concerns, I suggest the two of you communicate in writing, and then there's no confusion as to who said what. Understood?
Absolutely.
All right, you're all set.
Thank you, Your Honor.
Thank you. And are we still waiting for an attorney on this?
All right, back to Judge Boyd. What do you say? Clearly, the last woman did not live in a glass house.
Deputy will leave no stone unturned.
Absolutely.
Well, there we have more rocks. Two cases back to back.
All right. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. There's no answer.
State?
State would ask for bond forfeiture.
All right, that will be granted.
Bond
The client will be
forfeiture.
remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right,
Appreciate
thank
that. Thank you.
Sorry, I was hiding for just a minute. I was reaching out to somebody sending a message. Now Boyd is talking about rocks. If we get a third trial where they bring up rocks, that will be like the bingo.
Who is here on Arturo? Let me.
So on
pull that up.
on the pro se defendant, we saw him. He was very brief. It was in Judge Wolf's court, and he lucked out. The complaining witness, a law enforcement officer, has left the area and is not willing to return just for this little trial.
And number, we don't have a jury trial
So
date for
the case
Arturo
was
Villanueva.
dismissed. 3 makes it a hat trick.
So
think
I
that's
need
the
a jury
proper
trial
term.
date for that.
Mr. Villanueva is present. As is, who's this other guy? Daniel Vela.
And does anyone have a copy of the motion to travel? Arturo Villanueva.
Yes. Sure. Good morning, Your Honor. That's my client. That motion to travel is basically from the 20th to the 27th of this month, and it's to go to Alabama.
The lawyer's eyes. I've never seen a blue glow around the eyes like that before.
All right, thank you. Don't run. All right, while she's doing that, what date for jury trial, State? How long do you expect this trial to last?
Day, Judge, day,
All right, Norma, I need a jury trial date, criminal trial division, a day.
1 day. I think it's a reflection of his screen. He has a very blue screen, which means he's probably running a Windows device. Sorry, was that too much?
Thank you. All right, your jury trial date is going to be September 3rd. You'll need to make sure that you are in court dressed for trial. All right, next we're going to proceed on the motion. State, are you ready? Here you go.
Your Honor, is that the motion to travel?
Yes. All right, court is calling 2024 CR 0176, State of Texas versus Arturo Villanueva. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the defense?
Daniel Vela on behalf of Mr. Villanueva.
And are you Arturo Villanueva?
Yes.
All right, state, any objection to counsel and defendant appearing by Zoom?
No, Your Honor.
All right, the defense has filed a motion to permit interstate travel from July 20th through July 27th to Alabama. State, do you have any objections?
No, Your Honor, we just asked that the defendant be UA'd upon return.
All right. And defense, how is he arriving in Alabama? Is he driving?
I believe
Yes.
so.
Villanueva,
Yes,
how are
with the
you
family.
getting to Alabama?
Yes, with our family.
All right. So I don't know if there are any conditions because this is a failure to stop and render aid in a moving vehicle. So I don't know if there are any conditions of his bond that he's not allowed to drive. Does anyone know?
No, there's not.
All right. Does anyone want to check? Because it'll be a shame for him to be driving in Alabama and it's a violation of his conditions of bond. Mr. Villanueva, do you have
Yes.
a no driving?
No, no.
There has never been any conditions like that since he was
Yes.
arrested for this.
All right, so it needs to be one at a time. Court reporter is already can barely hear you all. So one person speak at a time. Mr. Villanueva,
Yes.
have there been any conditions of your bond that you are not allowed to drive?
No. No, ma'am.
All right. To the clerks, do you all see anything where he's not allowed to drive?
Why does the judge not want him
Okay.
driving?
All right, then what the court will do, there's no order attached to your motion, but the court will grant permission to travel. There should be a UA upon return. And you're allowed to travel to Alabama from July 20th, 2024 through July 27th, 2024. And Mr. Villanueva, your jury trial is going to be September 3rd. Do you understand?
Yes.
All right. Is there anything else?
No.
No, Your Honor.
All right. Thank you. You're both excused.
Allie B, I'm excited for you. Good luck. That's awesome. And Dr. G is amazing, by the way. I think you might want to email him first just to make sure his schedule. He used to be his Fridays were his down day where he didn't take any clients and he was free. That's where he could usually talk. But that was a hit and run, and they won't let him drive anymore, or was it a failure to stop and render aid?
Joshua Wong.
Joshua, there in the back. Looks like he's dressed appropriately for court. Hands out of the pockets. Good job, sir. Looking neat. Oh,
All right,
hands back in the
this
pocket.
is Criminal Trial
Hands
Division.
up. There we go.
Yes.
All right, so what is happening with Mr. Wong's case?
Judge, Commissioner Pro is looking for possibly a PTV.
Okay.
This is something I would have to take to my supervisor, which I can do today, although I don't know if he's there but I can do it today, or, I mean, if we get a small reset, I could, accomplish that, at least get an answer and then confer off dockets with Mr. Brown.
All right, so how much time are you asking for, State?
At least 2 weeks, Judge.
All right, Ms. Ferguson, on Wong, can I have a 3-week reset, please?
Yes, sir.
Thank you. You may be excused.
August 5th?
All right, we'll be back on August 5th. All right, are you feeling okay?
Yes.
All right, if there's something happened where you were lightheaded or passed out, you probably need to go see a doctor. You understand?
Yes.
All right, once you sign the reset form, you're excused, and thank you for dressing appropriately for court.
Thank you.
Daniel Rivera?
Yes.
Yes.
Yes. Joshua Day? Ready?
Thank you.
Neat.
If I could have Camilla on the, she's on the.
Okay.
We're taking it, you know what I mean? Thank you.
Let's say they're on.
Yeah.
On these are done.
It's quiet. We might make a slight appearance down in Florida really quickly. You ready to jump? On your marks, get set. Here we go. Hands up right inside the ride. Boom.
Yes, sir.
There we go.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf. Yes, sir. You're waiving your right to testify or remain silent at the evidence you're hearing and at the trial, which will be your decision to make. Yes, sir. You're waiving your right to appeal anything but an illegal sentence. Yes, sir. Are you doing this for your own free will? Yes, sir. Mr. Jackson, do you feel the pleas in your best interest? Yes, sir. You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea? Yes, sir. I'll accept the stipulation. I'll find there's a prima facie case in the new case. I'm going to find that his plea to the new charge will serve as a basis for his admission that he violated the terms and conditions of his probation. I'm going to find that Mr. Jackson's pleas were freely and voluntarily made after consultation with his attorney. I'm going to accept them. In case number 24 CF 2037, he's adjudicated guilty of fraudulent use of a credit card. He's placed on a term of probation not to exceed 40 months. He's ordered to pay fines and costs of $1,028. I'm going to reserve on the issue of restitution. He must complete 50 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of a probation officer. His cost of supervision will be $20 a month. If he's required to give a DNA sample, he must submit one. He'll forfeit any seized items. He's to have no contact with any victims or co-defendants. This sentence will run concurrent with the probation he's currently on. On case number 23 CF 3005, I've accepted his admission that he violated the terms and conditions of the probation. I'm gonna find that I find that admission was freely and voluntarily made. His probation is modified as follows. If he was not originally adjudicated guilty, he'll be adjudicated guilty of the underlying grand theft. His probation is modified as follows. To include 6 consecutive weekends in the Bay County Weekend Work Program that will begin on the weekend of July 26th. All other conditions that were imposed and have not been completed are reimposed. There's an additional $250 imposed for the cost of the prosecution of the violation of probation. Mr. Jackson, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, One may be appointed to represent you at no charge. Good luck to you. You need to step over, be fingerprinted, and speak with the probation officer.
All right, thank you, sir.
Yes, sir.
Barb's, I used to go to
You step right over there, sir.
I used to go to thrift stores and buy
Mr. Pacheco?
Miss Me girls jeans.
There's Christina Pacheco coming
sell
forward
them.
in 2421
for $10
55
and sell them for
CF.
90 online.
We're also going to take care of misdemeanor case 22297 MM. That is a violation of probation, and based on her new charges that she's pleading to today, we would admit, and the agreement is that probation will be revoked. Any court costs and fines will be by civil judgment. As to her new charges, she will be pleading to possession of methamphetamine, possession of paraphernalia, and driving while license suspended. The tampering charge will be consolidated. The agreement with the state is for a withhold of adjudication, 18 months probation. She will perform 100 hours community service work, $20 a month cost supervision, drug and alcohol evaluation, any recommended treatment, zero tolerance for the use of
Fingerprinting going
controlled
on in the background
substances
there.
and random UAs at her own expense. Department of Motor Vehicles may apply additional penalties. It will be time served on adjudication of guilt and time served as to the two misdemeanors, DNA sample, and forfeit any seized items.
That's the agreement with the state.
Yes, Your Honor. Yes, ma'am.
All right, maybe lower your hand and state your name.
Christina Pacheco.
Ms. Pacheco, you heard the announcement of Ms. Jewell, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning, which would impair your ability to either enter the agreement
No,
or
sir.
understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver and consent form. There's the front. On the back's the signature of the defendant line. Is that your signature?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your cases with Ms. Jewell?
Yes, sir.
Have you had sufficient time to speak with Ms. Jewell about your cases?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that being in the plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state to prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Ms. Pacheco, do you feel the pleas in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea.
Yes, sir.
I'm going to accept the stipulation. I'm going to find there's a prima facie case. I'm going to find that Ms. Pacheco's plea was freely and voluntarily made after consultation with her attorney. I'm going to accept it. In case number 2155 CF, she's adjudicated guilty of possession of methamphetamine, count 1, possession of paraphernalia, count 2, and driving while license suspended or revoked, count 3. On count 1, adjudication of guilt is withheld. She's placed on a term of probation not to exceed 18 months. She's ordered to pay fines and costs of $1,078. There's no restitution applicable in the case. She must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of a probation officer. This cost of supervision will be $20 a month. Within the next 30 days, she must undergo a drug and alcohol evaluation, follow all recommended counseling, zero tolerance for use of any controlled substance not prescribed by a treating physician. She'll be subject to random UAs at her own expense. The Department of Highway Safety and Motor Vehicles may apply additional penalties. If she's required to give a DNA sample, she must submit one. She'll forfeit any seized items. The possession of paraphernalia and driving while license suspended or revoked, she's sentenced to the time she served in the Bay County Jail, given credit for that time. The sentences will run concurrent with each other, and concurrent will count the sentence received in count 1. In case number 2200297 MM, her probation is revoked. She's sentenced to the time she served in the Bay County Jail, given credit for that time. Any money she owed and not paid or reduced to a civil judgment. I think the state's consolidated any other charges that were pending. Ma'am, you have 30 days to file your notice of appeal if you wish to appeal the judgment and sentence. If you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you. You need to step over, be fingerprinted and speak with the probation officer.
Terry Rogers?
A lot of people being pumped
Your
through
Honor,
this
information has been filed in this case. We would waive formal reading, enter a plea of not guilty. I have emailed a counter to Ms. McAfee. She will be back in tomorrow. I don't know if the court would allow me to keep setting on Friday, but I'd like to if we can get them done.
July 19th at 9 o'clock for a pretrial. Rogers. Terry Rogers.
What's he got in his
Terry
mouth?
Rogers.
I'm thinking it's a Werther's hard candy. No, he's chewing it.
Is David Smith out? There you are.
It's a caramel.
Thought I saw you a minute ago. You were in the back row.
I think he's got a big hunk of caramel in his mouth.
Your Honor, an information has not yet been filed, and Mr. Smith, Ms. McAfee, and I have been talking about it. I can tell the court that the current status is the child abuse cases will not be filed. They'll be contributing to dependency of minors. We're still working towards getting this straightened out if we can have the July 19th.
July 19th now.
Saltwater taffy.
Well, I'm trying to do it Friday. I'll be in here. Mr. Warnock? There's Michael Warnock, and information has been filed with waive formal reading, enter a plea of not guilty. A counteroffer has also been sent on him if I could have July 19th.
July 19th at 9 o'clock.
Thank you, Your Honor. Not today. We're going to do it Friday.
Gavin Miller.
Nice mustard colored suit there. Hang on, is that a... For some reason I thought he had a bolo tie on, but no, that's a lanyard and he has a tie underneath. A green tie with a mustard suit. Bold choice, sir. Bold choice.
Yeah.
Step on up to the platform there next to your attorney who has a broken finger. Apparently it has a broken finger. Sign here and here.
Initials right there.
Initial here.
Yeah, this is Gavin Miller. We're going to take care of case 242551MM. It's going to be withhold and time served.
Okay.
For case 242923, the state has filed a one-count information charging a third-degree felony, punishable up to 5 years in prison, $5,000 fine, or both. He's prepared to enter a plea of no contest to that with the understanding adjudication be withheld. He'd be placed on a period of probation not to exceed 36 months. During that time, he paid court costs and fines of $1,028, perform 100 hours of community service work at a minimum of 8 hours a month. His cost of supervision would be $20 a month. He'd submit to a DNA sample if required and forfeit any seized items. Presently, there'd be no contact with Miss Jackson, that's his mother, and I've told him if she reaches out and wants contact that she can request it. He would undergo a mental health evaluation and treatment, undergo a parenting class, and contact with the child would be as allowed by DCF. The child is at home and he plans to be at home.
Is there a case plan on her?
No.
So does DCF got any involvement?
Not that I could see. Not formally.
So what's the relationship with the child?
It's his young infant.
Pardon, is his own?
It's a 1-year-old.
Okay.
Okay, we're gonna bail just briefly.
Is there, I guess the only no contact is the
Is this. And the his wife, the mother, is in the home as well. So, and Miss Jackson's actually living there.
Okay,
It's
we're gonna bail for a minute.
multi-generational home.
Let's talk briefly about the Ashley Benfield trial, which is coming up shortly. This was a rushed marriage. Ashley Benfield. This is the next trial that's coming up. It's in I think it's in Florida. Tell me it's in Florida. For some reason, I'm thinking Florida. They call it the Black Swan trial. She was a ballerina. She was 24. She met 54-year-old Doug Benefield. Got married within 13 days, and then a short while later shot and killed him. It was a whirlwind marriage, to say the least. So, gold digger case. There are some allegations that might be the case. Yes, it is in Florida. So yeah, it's gonna be interesting for sure on this one. It's spicy. Thrift stores are awesome. Yes. Let me just say, can I take a brief hiatus from court for just a minute and tell you that if you are looking to earn a little bit of money, thrift stores are a gold mine. If you have a couple things, okay, you know how they say it takes money to earn money? You need to have a little bit of money so you can buy something at a thrift store. And you need to have a good device that allows you to access the internet, preferably while mobile, like a cell phone. Then you need to start doing some research. An area you're probably interested in. Say you're interested in old glassware, or you're interested in clothing, or you're interested in electronics. You just need to learn a little bit about that and find out what the good brands are, what people want, even though it's used. And then you go and buy them at thrift shops and turn around and sell them online. And I did a lot of that, just a ton. When does it start? It starts on the 22nd, Jules. It starts on the 22nd of this month. So next week, a week from today, will be jury selection. No, this is what the evil Depop girlies do. Squidward. I'm just saying, I made a lot of money buying girls' jeans at thrift shops, like the ones with little fancy back pockets and all the little glitz and glam. I had no idea what it was, but I made a ton of money doing that. So you just have to know what the good brands are and what they buy, and you can research on YouTube, and you can search for sold items that were used, and you can see the prices they go for, and then you know if you should make money or not. So we have Corey Richens on the 22nd. That's a hearing, though, right, Ashley? Or sorry, we have Karen Reed. We have Karen Reed on the 22nd. That's going to be the decision whether or not they're going to refile the charges. That's going to be spicy. Tomorrow we have the Canton Select Board, which they've moved from an in-person meeting to a Zoom meeting, which I predict will not be very spicy at all because they're not going to allow anybody to talk. Karen Reed on the 22nd. That's the motions hearing, where we'll see if the state wants to refile the charges. Like the picture of Billy, the kid that was purchased for $2 and is worth millions. Teresa, that happens, but don't count on that. I would instead look for the small profit items. Look for, depression glass, if you know that. If there's some types of brands of glassware and just like kitchenware that people collect. And you can find a piece that pops up here and there. If you're into old books, there are some copies of books, first edition stuff that are worth a fortune that turn up in garage sales and stuff all the time. Let's see what else. Let's see. One can still try to make a commotion. I think they will. They will have 15 minutes of public commentary in the Canton Select Board meeting tomorrow. It's going to be Zoom only. I think the Zoom will be broadcast on the Canton TV channel still. If not, we're going to be on the Zoom, or we're going to make every effort to be on the Zoom tomorrow anyway, and we'll try to get it directly from that. Okay, let's see. The china that we own, the full china set we own, it's like Winterling 2 from somewhere in Germany with platinum rimmed china. It's amazing china. I bought it for $50 at a thrift shop. The vegetable dish alone, I can sell it for $90 to a store that will turn around and sell it to somebody else. It's worth a ton of money. You can make some good finds. All right, courts are going slowly. Let's jump back to Boyd.
So probation, I'm going to want a field visit one time per month for 3 months. She is going to do intensive outpatient treatment with probation, and that'll be the dual diagnosis. And probation, do you think a referral to felony drug court would help her or no? Or is that too quick?
It wouldn't hurt, Judge.
All right, so we're going to do a referral to felony drug court. And let me just tell you, felony drug court is a difficult program, but they'll be able to help you with all the issues that you have. You have a mental health issue, they'll be able to help you with that. The BIPP course that you're supposed to be doing and the parenting classes that I'm going to order for you, they're going to help you with that. Do you understand?
Yes,
So you need to go over there and be 100% honest with them. And if you miss your appointment with them, a warrant could be issued for your arrest. Do you understand?
I understand.
So we're going to do a referral to felony drug court.
Thank you,
We're going
Tower
to do
Hill Girl.
120 sober meetings
In 120 days.
in 120 days.
One a day.
And she's going to restart BIPP. And I'm going to order parenting classes. And once you complete those parenting classes, her community service hours will be deemed satisfied. How far did you go in school?
12th grade. I wasn't able to graduate because I wasn't able to pass my tax test at the time.
Okay.
Science and math.
All right. So what do you want to do with the rest of your life as far as employment wise? What's your dream job?
To supervise where I used to.
I'm sorry, what?
To supervise where I used to.
Okay, supervise where?
Loan companies. Broadway Finance, Midwest Finance, and loan. I used to work in field collections.
All right. So what are you doing to make yourself indispensable to somebody who needs you in finance?
Unfortunately, I can't get a job anymore.
Okay, what did she say?
Unfortunately, she can't get a job anymore because of her felony.
With that field.
With that field.
All right. So then what's plan B? You got to have a plan A, a plan B, a C, and sometimes a D and an E. So what's your second plan?
Oh, it's customer service. That's what I know. Right now I manage a laundromat.
Okay. All right. So are you taking any classes? Sometimes at the college they give free classes or they give classes with minimum fees to help people who are trying to improve themselves in their business. Because at some point, there are some occupations that I think are going to be done away with because of computers. Mm-hmm. For example, when I was growing up, they used to have full service at the gas station. Somebody would come out, pump your gas, and you didn't even have to pay extra. They would clean your windows. They would check your oil, tap it off if it needed to be tapped off. Then they stopped doing that. And now at the grocery stores, they're doing all that self-checkout to eliminate cashiers. Mm-hmm. So you need to figure out if where you work, if for some point in time they were to say, you know what, we don't need anybody working here. All we need is somebody to get the money from the machines. You need to figure out how can you make yourself indispensable. In the words of Briscoe County Jr., you need to figure out what the coming thing is and be prepared for the coming thing. Okay? So probation, anything else she needs?
No, Judge.
All right, so here's the thing. You're on probation. You're on probation and you're looking at 3 years in prison if you don't successfully complete it. And if you end up going to prison for 3 years, guess what? Your 7-year-old is either going to be either going to be 10 or either going to be 11, mm-hmm. and your 17-year-old will be 20. Those are formative years that you will have missed. You're going to need to be clean and sober. If you have mental health issues, we're here to help you with that. Do you understand? And don't come to court positive. but I appreciate your honesty. But don't walk into a court positive when you're here for a compliance hearing. You understand?
Yes, sir.
So they're going to do a referral for you for felony drug court. You let felony drug court know that you want to be in the program. It's hard, but if you successfully complete it and you really work that program, you're going to see great benefits and you're going to see great improvements in your life. You understand?
Yes, sir.
All right. If you need anything else, you can always come back to the court if you feel as though probation is not addressing it. You understand?
Yes, sir.
All right. So just have a seat. Probation is going to go over those conditions with you. And if you ever feel like using, pick up the phone. This is the court where I encourage people. If you feel like you're going to use, pick up the phone, call your probation officer and say, I think I'm going to use. And you know what they're going to tell you? All right, we're going to get you into a sober support meeting, or we're going to do this. The number one thing is not going to be, we're going to file a motion to revoke, because I want you to be clean and sober and healthy. And I want you to successfully complete this. All right.
Thank you.
All right. Good luck to you.
Thank you.
Anybody else ready? It is 10:03 and we are recessing at noon. So the people in the audience, if your attorney hasn't shown up, you can step outside, pick up the phone, call them, and let them know we're recessing at noon.
She's a rare breed when it comes to judges. She really does have the defendant's best interest at heart. And if the defendant is obviously not willing to help themselves, then of course, then she defaults to the public's interest. but she's amazing. We did send her flowers last year. It was great. We actually got to see the flowers being delivered on live, which was cool. She has her own channel. She used to communicate with people in chat, but she got in trouble for that with some cases. There have been some. Every time a judge gets too friendly with the YouTube chat, there seems to be cases that slap their hands a little bit. Fleischer is very similar. He comes across as stern, but he's a really nice guy. In her case, though, in Judge Boyd's case, she doesn't communicate with chat very much. She has a book club. And she has been a guest on other YouTube channels as well. And she loves helping people who are in school for law schools, things.
All right. Do I have the dismissal? Oh. All right. Thank you.
Okay. And that's already been requested.
Fleischer.
All right. Thank you.
Fleischer has a loud bark.
Okay.
But I think he's a softie at heart.
Criminal Trial Division on page 2, Jose Barrera. That case has been dismissed.
Yes.
Okay.
Absolutely. Yeah. Absolutely.
And it got really quiet right there. Let's see. Let's jump back down to Florida.
Thank you. I won't be able to see you at the jail, but I'll talk with you on Friday in court. Okay.
All right, July 19th at 9 o'clock. Yes, sir.
Joshua Lee.
Lee? Lee, you're before the court today for your arraignment. Madam Clerk, he has not been appointed the public defender.
No, sir. I'm proceed pro se for the moment.
Okay.
Really?
All right. You swear Mr. Lee in, please?
Raise your right hand.
Yes.
Promise swear the testimony you're about to give is the truth,
I do.
All right, sir, state your name.
Joshua Lee.
And Mr. Lee, you're asking to go to represent yourself, is that correct?
Yes, sir, for now. I don't see where I'm going to need a public.
Okay, well, let me go through this colloquy first, and then we'll go forward to that, okay?
Yes, sir.
You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law. You understand?
Yes, sir.
They're there to assist you in entering a plea. They're there to assist you in preparing for pre-trials, and they're there to assist you in going to trial.
Yes, sir.
All right. And also they're there to perfect the record if that need be. You understand that?
Yes, sir.
And you still wish to represent yourself?
For the time being, yes, sir.
All right. How far did you get in school?
I'm GED.
Okay. So you can read and write.
Yes, sir.
What do you do for a living?
I work in the coal mines up in Alabama. Well, I did until I lost my job. I'm going back to a different company this time.
All right. Have you ever represented yourself in court before?
just at pre-trials and that first appearance. I'm not
Okay.
claiming to be a trial attorney. I just
I understand.
want to reserve my rights until, but I believe that this state is going to have an offer for me. Then she said that we'd try to bring me back Friday.
Okay.
And we'll try to resolve this case then.
All right, and that's state's position. You have a plea offer. What I'll do is I'm gonna find that Mr. Lee's competent to represent himself. I'll allow him to do that. I'll enter a not guilty plea on your behalf, or you can enter a not guilty plea on your behalf at this time. We'll set you a pretrial. Is that what you like to do?
Yes, sir.
We'll set you for a pretrial July 19th at 9:00.
Thank you, sir.
Yes, sir. And you remember at any point in time, if you like to have an attorney appointed to represent you and you meet the financial criteria, one can be appointed to represent you.
Yes, sir.
Okay.
He's like, I think I'm good. I can handle this part. It's just pretrial. Pretrial is pretty easy. I'm not trial attorney by any means. I'm a coal miner, but I can do the
Mr. Lindsay,
pretrial
you're
stuff.
before the court today for your arraignment.
Wow.
You've been charged by way of an information. It's like 10 counts of possession, control, or intentional viewing of material, including sexual conduct by a child. Each of those are third-degree felonies, punished with 5 years in the Florida Department of Corrections and a
Let's see what Judge
$5,000
Boyd's doing
fine.
right now.
You've indicated you'd like to.
Marco Mars on De Zavala, and our advocate had already requested them as of the 12th of last month.
All right, and when are you expecting those to be in?
I don't have an update on the timing for that last part. They said they don't have an update yet, but I can absolutely reach out, Your Honor, and get a clarification on expected timeline.
All right, so this is what I'm going to do. I'm going to set you all for one last discovery date. And if you all don't have the records on this date, this is going to be the date where you need to make sure you subpoena persons to appear and bring records with them.
Instanter.
Yes.
Yes,
So
ma'am.
Ms. Ferguson,
Instanter.
on July 15th, this needs to be set for a discovery hearing, and it's going to be an actual hearing unless you all have all of the records. So what date? Oh, I'm sorry. Today is
Coming
July
back in an
15th.
hour.
We're coming back in an hour. Yeah. All right. So what date? 30 days. And it will be a discovery hearing. All right, so we're going to be back on August 13th. Everyone needs to have witnesses. If there are records that are missing, you need to have witnesses from those facilities. If there's no objection from either party, they can appear by Zoom, but we're going to get somewhere.
Understood.
All right, is there anything else?
Not on this.
Thank you, Judge.
defendant.
All right, thank you. Once you sign the reset form, you're excused, and thank you for dressing appropriately for court.
Thank you, Your Honor.
Thank you.
We're going to do that.
Apparently, Levi's and a polo shirt is all you need. That's the bare minimum. I think the judge would even appreciate the right defendant in Levi's and just a plain tee, just no logos. The bar is not very high, but some people fail to measure up even to that.
All right, who's here? I'm Melanie Barron.
That'd be me, Judge.
All right, Miss Barron, if you'll come forward.
I do not.
Hang on, we're going to jump back to
Hello.
Florida first. Hang on.
Yes, ma'am. I'm actually just able to get a private attorney this morning. I'm meeting with him after this.
You should probably meet with your private attorney before this.
Yeah, I'm a nurse, so.
All right. Is an information been filed?
Yes.
Okay.
Possible prank
All
call.
right. Are you hiring an attorney this morning?
Yes, sir.
Who are you going to see?
Waylon Green.
Hello. Hello.
Hi, good day. This is Ella from Great Vacation. How are you doing, Dwayne?
I'm doing well.
That's great. I'm calling you, sir, with regards to a large amount of travel credits that you have on file, and my job here is to close out all expired accounts. But when I saw how much credit you had available, I wanted to touch base with you because I didn't feel comfortable closing it out without at least giving you one last opportunity to use them. By any chance, Sir Dwayne, do you see yourself traveling in the future?
I'd like to. How much credit is it?
Upon checking here, sir, the only thing I can see is the credits that you have here covers an entire package in full, in which the package has 5-day, 4-night stay in Las Vegas, 5-day, 4-night stay in Orlando, Florida, an all-inclusive flex cruise with 6 days and 5 nights of accommodations. You can choose with Carnival, Norwegian, or Royal Caribbean Cruise Lines, and also a 3-day, 2-night stay with your choice of destination. So you can choose anywhere in the Southern, Eastern, or Western Caribbean with 2 round trips airline included. And the package has also no expiration date. This way you can use it anytime you want. So since the credits that you have here, sir, covers everything in the package, the only thing that you're responsible for is just the one-time booking fee. And that's for the one-time booking fee, Sir Dwayne. Can I have a moment and I'll check that for you?
Yeah, did it say it covers the Vegas cruise as well?
Yes, sir. Everything that I mentioned was already credited by the package that you have. And
Okay.
it's also fully, it's also fully customizable, so you can choose and pick any destinations you want. So let me just check for the one-time booking fee. Just give me a moment, okay? Please stay on the line.
Okay.
Good morning, Dwayne. How you doing today?
I'm doing well. How about yourself?
I'm doing wonderful. My name is Cheryl, and I am one of the senior promotional directors. The reason why I have just jumped on the line is I will be the one that further assists you. But first and foremost, did the representative leave you with any questions for me?
She was checking on a booking fee. She said we could do. There was a Vegas cruise that was available.
A Vegas resort stay. Vegas don't have a cruise, but you would have 5 days and 4 nights at a resort in Vegas.
Oh, there wasn't like a river one, like a Colorado River cruise or something?
No.
Oh man.
Now there's a cruise on Royal Caribbean, Norwegian, or Carnival, but there's not a river cruise. No.
Oh, okay. Well, I want to go to Vegas. That's I need to sort out a legal thing there first because I think I have an outstanding warrant. But I made a lot of money last time I was in Vegas, and I want to do that again. But I didn't think I'd be able to afford to. But this credit might make it possible. Hello? Hello? Why? What did I say wrong? What did I say wrong? Apparently, that blip was you muting me. You can hang up. I know you're not coming back to talk. I'm just going to waste your time. But this is just one more person that your phone system can't scam while you keep me on the line without hanging up. So, I know she's not listening anymore. I'll hang up and let him call back. All right. Okay. Sorry. The Vegas cruise was off. Sharon was on it. The first girl said the Vegas cruise was an option. The second one was like, nope, no more. So the warrant was an issue. I wonder, I should have asked if they help with legal fees. But anyway, let's go back and see where we are with, let's see, down in Florida again. How about that? Why no Vegas cruise? What river? Does they have no water in Vegas? Don't they have a river that goes through Vegas? There's got to be a river down there somewhere. It's the Colorado River or something like that. Land cruises are a bit bumpy. What about cruising the Strip? Isn't that a thing? Can't you cruise the Strip? She didn't hang up. She was turning you in for the cash reward. Yeah, I'm sure. Hey, we got a live one. We got a live one here. You can cruise around in the Bellagio fountain. Closest body of water is Lake Mead. And that's a ways away.
All right.
I thought we went back.
Who's
to
here?
Florida.
Luis Martinez?
Hey, Your Honor.
And where is he?
He is in Vegas.
Come down.
Jury box, not.
Sure.
Although we may have five cycles, I don't know.
Hey, you never know. Family violence. This is Luis Martinez.
Yes, Your Honor.
Yes.
Oh, I apologize. Am I
No, what is happening with this case?
taken off? So, Your Honor, we had CPS records here. We had multiple sets actually of records. We've gone ahead and created those records and given them to defense as of today.
Okay.
And we've had some preliminary discussions as well about the forensic interviews. And counsel is aware of who they can reach out to come by the DA's office to view those at their leisure.
All right. Is there any other discovery?
I believe we're in good shape overall, Judge.
I think we are, Judge.
All right. So I need an acknowledgement of discovery sign state. Were you able to tender an offer?
I've got no criminal record anywhere.
We're
I definitely don't have a warrant in Las Vegas.
Judge, nothing firm yet.
Given that counsel had not yet had a chance to come by and view the forensic, we felt like we've talked, Your Honor, but we would like them to kind of have that opportunity, if that's okay.
All right, Ms. Ferguson. If on Luis Martinez, if I can have a 30-day reset at that time, you will need to tender an offer.
Absolutely, Judge. And we'll get you that discovery acknowledgement.
All right, thank you.
Yes, Judge.
What date, Ms. Ferguson?
August 12th.
All right, we'll be back on August 12th. Do you have any questions, Mr. Martinez? All right, we'll bring you back on August 12th. At that time, the state will tender an offer. Do you understand?
Yes, sir.
All right, thank you.
Thank you, Judge.
You're welcome.
Can we put your Melanie Barone again?
Oh, just give me 1 second.
You can't approach yet. Just stand where you are.
Let me just find this.
Yeah, so there is your.
In about an hour, we're going to have some cases come up in Thurston County, Washington, which we're going to try to follow today. Not a lot happening in the world of true crime as we speak, but we'll have a few of these smaller cases, and then next week we look to start the Ashley Benefield trial.
All right. Yes, Melanie Barone.
There are videos.
I'm sorry.
There are videos available, but there's multiple videos, and it's about a couple hours worth. If I could get a little bit more time to try to download those for myself, so I can dig through them.
All right. Let me see what page she is on. All right, does anyone see what page Barone is on? All right, thank you. All right, so this is going to be the last date for discovery. Counsel, if there's an issue with the download, then you'll need to bring them over a disk or a hard drive for them to download it for you.
Understood.
Otherwise, if you don't want to do that, just pick a time for you to come to court. And if we're not in jury trial, they can set it up in the jury room for you.
Okay.
All right, Ms. Ferguson, if I can have a 30-day reset on Melanie Barron, please.
We're going to jump to a different.
All right, we're going to come back on August 12th, and that's the last discovery.
A big
So
active
what is
Zoom
going to be
court.
due?
If you have some things that you think are difficult with the local rules, let us know. And as I said, Mr. Amos, if there's some specific supplement you think needs to be signed for this case that is not covered by the form protective order on our website, you can let me know that. And I will just say, if y'all have anything to add to the comments that you've made today or to your motion and response,
We are hopping like
you
crazy.
may file and serve a reply or a amended response or whatever it is you want to call it, and I will take a look at that. It would be helpful if you would do that in the next couple of days.
Your Honor, I have already offered to amend certain responses now that a few things have been clarified. So, my plan was today to amend certain responses to start getting him the information that he needed. And now that the court is going to order the protective order, the problem with getting him what he wants is the universe is just, it's so big. And because it hasn't been narrowed in any way, and there's been no agreement on how to narrow it.
Let me just say this.
That's the problem, Judge. It's the universe's
He asked
fault.
for information from the
just
website. You're
too
now
big.
telling us there are 5 different websites. I suspect that what you need to do is list the 5 websites and
Bite me, congratulations
look at the
on 18
website
months.
that
Thank you so
he
much.
just put on screenshots of. And I take it, Mr. Amos, you only want information about the website that was in.
Most done. He's out of it. He's playing bankruptcy.
Hold on.
We can hear you.
I assume would be the website covering the pool company in Austin, which is.
Your Honor, they have a corporate website, which is where they made the advertisements for the most part. Then they have like web pages that are part of the website. And I even gave them the URL for the website. They actually said it wasn't their website.
Well,
in the responses to requests for admissions. They just don't want to give me anything.
That is certainly not the case. If you looking at my responses, it says if you give us search terms and you clarify things and you enter a protective order, we will give you what you want. Those things never happened.
I want to comment on that briefly. We're not required to help them find stuff. We make the requests reasonably particularly. If they want to run search terms through their emails, they can do that.
Spicy.
And no, we're not obviously agreeing to a protective order. I don't think they've established a trade secret.
Well,
although I did send a draft one over, for them. They just didn't want to use it.
So for Amos, you said the corporate website is where what is?
I'll share my screen real quick. That's where they advertise. It's right here.
The ads.
Will my pool have a warranty?
And I've already agreed to give them everything for that particular website. But when a term says your websites and there are over 200 domains and 5 websites, I need to know which ones you're talking about, because the only ones that actually matter are the ones that the plaintiff looked at.
They haven't agreed to do anything, Your Honor. I don't have anything. And number 2, I'm allowed to ask go to your websites and get me your advertisements on lifetime structural warranty. This is just one of them.
So I guess I'm having a hard time understanding what you mean when you say there are over 200 domains and 5 websites. So
Premier Franchise Management manages franchises. There is a Premier Franchise Management website that only has to do with franchising. There are different entities under the Premier Franchise Management umbrella that are not related to this specific case. The domains, any of the franchisees who have websites, those domains are under the Premier Franchise Management, Premier Pools and Spas. So if a franchisee in Wyoming wants a website, Premier Franchise Management hosts it. That's why it's so broad.
It's not broad because there's a large number of websites. It's broad if it's not on point. It's on point. I said, well, I want every web page that says lifetime structural warranty on it.
And that is why I asked for search terms, so I could get your client what they needed.
Your Honor, we're not required to specify the search terms, but all they had to do is type lifetime structural warranty.
Your Honor, they've asked for ESI.
One at a time, please.
Cindy, thanks for the super chat. Vegas, here we come.
Your Honor, they've asked for ESI. I'm trying to get them what they want. We're in the process of searching the terms lifetime structural warranties. That one hit has returned 130,000 emails and multiple terabytes of data. This is why we have ESI protocols in place.
Turn those over.
Right, so they can do the search. It's just because it's a lot. I mean, they're a big company, but just because it's a lot doesn't mean they don't have to do it. They're the ones that have.
I assume that you don't want to have produced to you 135 terabytes of information.
I would take it.
Was 135 terabytes? That's a lot. But if it's responsive to the request, then it has to be produced. But if I think Your Honor, opposing counsel is referring to emails now.
Well, there's so much that's been requested.
All right. Well, I'm going to go back and look. I will look at the
Premier Pools and Spas apparently is
motion to
parties here.
compel and the response and anything else you want to send out today or in the next couple of days. And again, what I would request that you do is that you file it, but you also email it to my staff and let them know these are additional responses for a pending motion.
Your Honor, may I email your staff the petition since that's probably difficult to find?
You may, or you may upload it to the other materials.
Sounds like it was a pool.
I will tell y'all
warranty that's not being honored.
Future reference, it is helpful that you email the various pleadings that you're relying on. I mean, that you upload them to Box, but I know that Miss Williamson, before she went on vacation, set up all these tons of items on Box because
where have we seen Julie Lane before? She looks.
There are just so many things.
I think we've seen her
she tried
practicing somewhere.
To tailor it to the Box folders to the things that were set for hearing today. If you can't figure out where to upload something to, you can certainly ask, but I think it's pretty clear. All right. That's how I'm going to deal with.
We're in Texas. I think we're in the 345th district.
With the motion to compel discovery. So it's under advisement. And let's say by the end of the day, Wednesday, if there's any items you want me to look at, you need to file and upload or email any additions by Wednesday at 5.
Yes, Your Honor.
All right.
Yes, Your Honor.
We have a few more things set. Ms. Stroud, you have your hand up.
Yes, Your Honor. I apologize. I heard the case was called as I was watching on YouTube. I represented Belargin, but the order for that withdrawal was signed on July 8th, and therefore we didn't receive notice of the hearing, and so I didn't know that it was still on the docket for today. So I apologize, but to the extent that anything needs to be taken up for that, I would ask the court be able to do that as necessary.
No, thank you. I have no doubt that there are things that get signed and the items remain on the agenda. So thanks for letting me know about that. And so basically that hearing is not necessary because the order's been signed.
And to the extent that we needed to remove it, but on our office's part, I apologize in that error. Thank you.
No problem. All right. I think we will go ahead and take a morning break. It's 10:30. We'll break till 10:45. Y'all are welcome to just mute yourselves and turn off your camera, and we'll start back up at 10:45.
Or unmute and leave your camera on. That would be more exciting for the rest of us. Melinda? Okay, she figured it out. And there we're down to none. And then we're none. So back to Judge Boyd. Call a new case, Judge Boyd.
We'll get started.
It's awfully quiet. It's about an hour drive between the two counties. That attorney looked familiar. Lane. No Judge Simpson today, at least not yet. We're holding out for a little bit of Thurston County, Washington action with a couple of trials that should start this week. So we're going to be watching for those. Not sure what Judge Boyd has going this afternoon. Do you know if she has a jury trial today? Next big trial starts in 1 week. It is the Ashley Benefield trial. This was a ballerina, age 24. Met a guy named, I don't know what's Doug, I think it was his name. Age 54, got married 13 days later. And then I think within a period of just a couple months, ended up shooting him.
Thank you, Judge.
You're welcome. Have a good one.
Murder. That one's out of Florida, so that's the next big one. We're also watching constantly for updated letters from Sarah Boone.
Well, it's sorry, I've never, yeah, but it says that they refused, so. I know they showed up at
Yeah, it went really quick. The 13-day courtship and engagement is, I would say that sometimes you meet someone and you just know they're the one, right? But you need more than 13 days. You need at least 2 full weeks. And they didn't even have that. You need at least 2 full weeks of getting to know someone before you're like, look, I'm willing to tie the knot.
You're welcome.
Here.
Yes, you may.
She was a day short of that. So checking for Boone updates now part of my morning routine. Me as well. I keep a tab open, constantly refreshing that one. Most warranties last longer. 30 days is less than the normal holiday days you get during the year. Give it a fortnight at least. It's called an annulment, not an unalivement. Yeah, at that point, you could probably just get the whole thing reversed. You wonder with the age difference, I'm wondering if the financial position of the husband was an incentive here, but I think she's claiming that it was self-defense. So we'll see what happens. Good morning, Ricky. Good to have you join us. You're only 2 hours and 47 minutes late, but that's all right. You're here now. I haven't looked at brother-sister trial. I didn't follow that one.
Okay.
They had issues with their ballet company. The ballet dancers stopped getting paid. There's a bunch of people sitting in court waiting to have their day in front of the judge, and no attorneys here to represent them, so they get pushed off.
That's the second one, Judge.
All right. Thank you.
Thank you, sis.
Yes. Have a good one.
Thank you.
Out you go, sir. Don't let the gates hit you in the ankles on the way out. He's a tall fellow. He's really tall. It was financial problems for a while before the incident. We'll probably get some testimony about ballet then. You can't get the money if you just married and then unalive them. There's a waiting period before you can do that. Oh, Ashley says, I'm glad I've never had to go to court in my life. I too have been fairly fortunate, aside from traffic court. I've made a couple appearances in a couple different cities. Lenova, I think it's the only ballet case that's out there right now. Never traveled to Ireland. I've been to England and Norway. And my family, I think, has been to Scotland. I didn't go with them. It's quiet in the court. We might have to end up jumping back to Travis County as they're on break. They literally just share like a Word document as their screensaver, and up you can see the cursor is still sitting right here on the page. Can you see the cursor? Where's my cursor? There it is. They just typed in the time. They're going to come back and just leave that sitting there. That's their screensaver. I've been to Canada very briefly, but not as much as I'd like to. I'd like to go up and fish, but I'm worried about all the moose and the grizzly bears that would attack me. Wow. When did that lady in red just appear? That is a standout outfit. And she's got red hair as well. She is really commanding attention in the courtroom. She like appeared out of nowhere despite that dress. She's already tall and wearing high heels. I'll have to rewind and see when she appeared. I glanced away for a minute and boom. She's not dancing with you? No, she's conferring with the prosecution right now. I love how it is a given that moose and grizzly would attack you. AC, I'm just saying statistically, everything I've seen about Canada is moose and grizzlies attack you. Amber, heat exhaustion. Oh my goodness. Stay cool. Stay cool. That's some serious stuff. Another lawyer shuffles in.
Hello.
Sidesteps the lady in red. Drops off a file. Canadian Cobra chicken. What's Donna from Suits?
Yeah. Thank you. Yes. Those eyes. Those eyes.
Okay, attorneys are showing up. Apparently those calls saying get down here, judge is breaking at noon, were working. Lady in red does not care that she's completely blocking the aisleway. Everyone else has to squeeze by. There we go. Oh. Heels as well. If I had to stay crouched that long, it would not be nearly as graceful standing up as she was.
Yes.
I saw bison in Yellowstone. I've seen bison on Antelope Island in Utah, and I've seen bison on a farm, like grass-fed bison.
Are the parties ready on Daniel Guerrero?
Right.
Yes, sure.
Where's your client?
He's coming up, Judge.
Counsel, you're on this side. All right, where are we on discovery?
I just
fans requested some EMS records, which we do not have, and I've sent the request in this morning, Judge.
Okay. And is that the only outstanding discovery, the EMS?
That I'm aware of right now, yes, Judge.
Ashley Benefield is the next case. Starts.
All right, Ms. Ferguson on Guerrero. If I could have a 45-day reset, this will be the final date for discovery.
We'll have some smaller trials between now and then, though.
It's Daniel Guerrero on page 7.
I never wore the Miss Me jeans. None of them would ever fit me. Not
All
that
right,
I tried.
August 29th. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
All right.
You have a good day.
Thank you. You too.
So I'm curious, though, for those of you that have maybe some teenage daughters or granddaughters who wear the latest and greatest and expensive fashion designer jeans, what's the brand now? What's the brand that everyone wears now?
Sorry, I'm late. I had to walk up 4 flights of stairs. Thought I was gonna have a heart attack like that.
4? Well, but see, the problem is back in the day, we could run up those stairs.
Grace and
I probably still could, but I get to the top and I'd be even heavier than I was.
Yeah, the elevators are down. They did have an elevator attendant in the elevator.
Oh, yeah?
Is he gone now?
I don't know. The doors never open.
Oh, well, it was his job to make sure that the doors would open. Hello.
Hello, I walked all the way up here. When I heard you talking about that, I wanted to talk about it.
Okay. Yeah, we have
I don't have to do my walking tonight. I just did it 4 flights up the stairs.
Oh, wow. And I think there's an extra floor. So it's really more than 4 flights.
You're exactly right. Between the first floor and the second floor, that's 2 floors.
Yes.
And I started
in the basement.
I started in the basement too, because you press the button and when the button doesn't stay lit, you know something's wrong.
You know how now on social media, people will take pictures of their food as though if they don't have a photo of it, it didn't happen. So unless you all have video of you going up the stairs, do we really know that it happened?
I've sold True Religion and Rock Revival.
Here I am with my tongue is hanging out, Judge.
Falling in the floor.
Oh. See, if we were on vacation, nobody would mind walking up the stairs. It would be interesting and fun, things to see.
Yeah. What I did on my vacation Monday morning.
Maybe I should start putting plants or paintings up the stairs, and that'll make it interesting. So you won't even notice that you're walking up. Yes, I did.
See, I noticed little things. See?
Yes. We're working.
After many years of being a man, I've learned how to notice a little things.
Oh, you have to notice it. You have to. So are you going back to New Orleans anytime soon?
Chris Wallace, thanks for gifting a membership.
When are you going?
Did she say Nolans? New Orleans?
We generally go to New Orleans.
Yeah.
Yeah, we're not.
Well, what parts of Iceland?
Oh, no, it's pretty small.
Oh, there he is.
On the Golden Circle.
I know what's happening.
And boots with the fur,
watched,
right?
I love watching HGTV, especially House Hunters International. And so they showed someone actually moving to Iceland.
Okay, we're gonna jump back to the other
for employment, and then they do a Where Are They Now, which I love the Where Are They Now because they bought a home, I think it was either Australia or New Zealand, and there they have some sort of auction. A house is on the market. It may have changed now. Maybe their market is not as hot as it was then. But you would just have a group of people, like if you were selling your home, a group of people would come and they just open the bids.
Maybe we'll do that.
Yeah.
All right, we're going to jump back to
the parties are to create the steering committees, and then the steering committees are to pursuant to subsection 4. Each group of parties are permitted to propound interrogatories and requests for production based on the common issues. The problem that we're having is some of the parties are filing individual discovery, which we feel is common issues. And so until we have some clarification as to the creation of the steering committees and then subsequently have them file those discovery on the common issue. Another thing that came up during when we were talking about the motions for clarification is the orders are unclear as to how we're going to treat the uncommon issues. And again, I don't think that we can have a meaningful conversation on how to treat all these things until the steering committees are created. But in an abundance of caution, I did go ahead and I filed the objection in the motion for protective order.
But Norma, it does show that Kelly Green is on the motion to revoke.
Yeah, but then John.
So that shouldn't be on the docket.
I think Kelly Green's the bondsman.
Yeah.
Yeah, she does the bail bonds for me.
Okay. Okay. All right. Thank you.
And that's stay on it.
Okay, so-
All right, well, if you have information to impart to Mr. DeLeon, please feel free to do so. Mhm.
He's wearing his Colonel Sanders suit right
I
now.
got punished.
Hey, if you all were in jury trial together, you all are sort of matching with your suits. We could probably go to jury trial today.
Why not?
You know, it's coordinating very nicely.
You could do red, white, and
I do
blue.
think I have a tie like that. I can probably have it couriered over. And he'll be black, I'll be white.
There you go.
Okay, I need the brand
Do the
name of
military part of the
girls'
trial?
jeans that's selling
What
for
is
about
it?
$100
What do you have?
used on eBay. I know there's
Apparently
a
I got
brand out
assigned
there.
to Leon Small.
Oh,
Yeah.
you have now.
Yes.
I'm off of the free optional.
That's what I hear.
Yes.
Do you have any knowledge about these new cases that I need to know about?
Not a damn thing.
Okay, then that's all I need to know.
Not a dang thing.
I think you all are interfering with Ms. Cutter's ability to reach where she needs to reach.
Oh dear. Well, let us get out of the way. But can I get Mr. Small in front of the judge? Christopher.
Judy Blue or Harla? Harla?
No, I do not.
What are Halara?
Christopher Herrera,
Present, Your Honor.
if you come down, sir.
Seven. Oh, I've sold some seven before. Is it like Seven for All Mankind or something like that?
Norma, the small case may have been filed away because, you know, we did the motion to withdraw and maybe it was put in a separate file. All right. So, Mr. Herrera, last time you hit your head, how are you doing?
I'm better now. I suffered a small concussion, but I mean, I think I'll be okay.
So did you fall from the step and went down?
No, there was like some type of metal object underneath the butts of the seats that I was in, and my leg irons, the chain got wrapped around it after my glasses had fell. And amongst trying to retrieve them, it's as if the seat pulled it out from underneath me. And at the time, my handcuffs were behind me. So like, I don't think I had to brace my fall, was my face. Yeah.
Wow. All right.
There's a lawsuit.
There's
So
a lawsuit. He's
the
gonna sue.
CPS records, my understanding, were in the file. So where are we?
Judge.
Has discovery been completed?
It is not. There is still a video, the child safe type video that I still need to view. And I've been given a copy of the CPS records. I need to review those as well.
All right. So the only thing outstanding is the review of the video.
Yes, ma'am.
So all discovery that's taken care of.
Good to go.
All right. So Ms. Ferguson, on this case, we're going to set it for 30 days. And I know we had a previous plea deadline date because an offer had been tendered, but then there was discovered that the CPS records were not in. So this date I'm going to give you is going to be your final plea deadline date. And state, is the offer still the same?
As of right now, Your Honor, yes. Counsel and I have talked, but as of today, the offer is still the same.
All right, Ms. Ferguson, I need a 30-day reset on Christopher Herrera. All right, your plea deadline date will be August 13th. Do you have any questions about anything?
No.
All right, so we'll bring you back on August 13th. At that time, you'll have to let the court know whether you've reached an agreement with the state. If you have not, Your next date is going to be a jury trial date. You understand?
Yes, sir.
All right, thank you.
Thank you, Judge.
Your Honor.
All right, watch your step.
Yes, ma'am.
I'll be
Thank you.
back in here. I'll be back in here.
Yeah, he's going to sue. Ken, I never felt that way. I never
Leon
felt bad,
Small.
running retail
Present, Your Honor.
arbitrage like I did. Mostly because
All
one
right, and
tiny
who is
little
the
store
state on Small?
had hundreds and hundreds of pairs of jeans, and I'd buy one or two of them.
All right, so you've just been appointed, however, state the unindicted cases. Where are we on that?
I would need to double check on those, Judge. I haven't seen it just yet, but I can right now.
Okay, because he has, counsel, he has a manufacturing delivery 4 to 200 grams, felon in possession of a firearm, and possession of a machine gun that hasn't been indicted yet.
Whoa.
All right, thank you. And then there's a case where it says pending with the magistrate, FTA use illegal. I don't know what that means.
I have no idea.
It's a 2024 PF 04474 case.
So let me roll my eyes more. Lord.
So I don't know if that's something new that Odyssey is doing and what that's about. Yeah. So what is the FTA use illegal? That doesn't give anybody notice or anything.
I asked about that.
All right. So Mr. DeLeon, I'm going to give you this number.
Okay. Looks like we need to point it to all your cases. Okay. So I'll figure out what's going on.
Looks like we got to deal with the machine gun issue, sir.
Right. So this is the number. I have no idea what that means, but it says pending magistrate. So.
That's
04474.
Yeah, it's
Mhm.
always the large cases that are assigned to Judge Nahara.
All right. So that's Judge Nahara.
And it's basically, they're not assigned to a court yet until they figure out that he is a pending NTR, they're going to push over to the 187.
Okay. Well, what are they trying to say the PF stands for? That's what I would like to know.
Pre-file.
Thank you. Yeah.
Don't need much, Judge.
Well, but you know what? I always tell people, if you want to know something, ask. Otherwise, you'll never know. Now I know that the PF is for pre-file. I think all that's going to cause a bunch of confusion.
What?
I don't think that's going to get transferred to a CR number. We're going to see how it works.
With Odyssey, Judge, because it is an odyssey in learning how to figure it out.
I tell you what, I'm not going to put that into the universe. It's going to go smoothly. So I am going to give you another court date. And Mr. Small, this is your attorney. If you decide at some point to hire an attorney, if it's set for trial, that attorney needs to be ready for trial. Do you understand?
Yes, ma'am.
Judge, if I can get that same date of August. What's it? 16th? August 13th.
All right. Norma,
The ideal.
you're going to put it on August 13th. And if you'll check with the state to see when they anticipate taking these other cases to the grand jury.
I'll check with Daniel, yes.
So August 13th, council will be your discovery date.
All right.
So this
And
guy has
also state
possession,
on that date,
intent to
you
distribute,
need to be prepared to tender an offer to Mr. DeLeon.
and possession of a machine gun.
All right. Is there anything else?
Nothing else, Your Honor.
Is there anything else, Mr. Small?
No, ma'am.
All right. And you have stars. Michael is a Cowboys fan. I know that's not cowboy related, but there you go. See, connections are I'm bringing people
Close
together,
enough.
Michael.
That sounds good.
Just talking about his tats.
All right, Judge. Thank you.
All right. Thanks.
I'll be back in
Thank you.
touch with you.
Thank you.
With a video call more than likely. Okay.
Yes, sir.
All right.
The video call because you scare me in person.
Who's here on Joshua Tez?
Favorite trial to watch? I tell you, it's hard to beat Friday's trial with Alec Baldwin. Hey, the lady in red's up.
All right. Are you all ready to proceed?
Yes, sure.
Look at that.
All right. Court
button down.
is. Oh, and who is this behind you?
This is one of my law clerks, Miguel. Is that okay if he stands up here with us?
Oh, sure.
He said
Miguel, what's your name?
Miguel Sperza.
All right. So what are you doing? Are you in school, law school?
Same age.
Oh, what year?
Second year now.
Oh, well, your law school days are almost over.
Yeah, almost.
After that, it's very quick. So do you want to practice criminal law?
Yeah.
Oh, hey,
Say
well,
yes.
I get
you're
the
always,
opportunity to come and watch. And
well, you're always welcome to come to the 187th anytime. And don't be shy. Talk to the attorneys. You will find that on the criminal side, no shade to civil attorneys, but on the criminal side, they're always willing to help you. All right, court is calling 2020 CR 2266B, State of Texas versus Joshua Michael Tejas. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Lee Cutter for Mr. Tejas, Your Honor.
And what's your name?
Miguel Esparza, Your Honor.
All right, and just for the record, Miguel Esparza is a law student at St. Mary's. So this is, I believe this may be his first time on the record. Is that correct?
That's
Second time, actually.
Second time on the record. Okay.
He was here with me the last time.
Ah, yes, okay. All right, Mr.
Is he
Tejas,
related
did
to
you,
the defendant?
you're Mr. Tejas?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Joshua Michael Tejas who was placed on deferred adjudication in 2020 CR 2266B for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on November 9, 2020 for a term of 2 years? Is that you?
Yes, ma'am.
State.
Yes, Your Honor. Violated condition number 41 in Bear County, Texas, the defendant Joshua Michael Tejas, the detonator failed to attend and provide verification of attending 90 Narcotics Anonymous meetings in 90 days from September 27, 2021 through August 31st, 2022, in violation condition number 41.
How do you plead to that? True or not true?
Your Honor, I didn't hear what you were asking me before. It has complete. Oh, sorry.
I did complete the 90 days and 90 meetings.
So is your answer true or not true?
Oh, I get not true.
Okay.
Violated condition number 2, on or about the first day of October 2021 in Bear County, Texas. The defendant Joshua Michael Tejas, the detonator consumed alcoholic beverages in violation condition number 2.
How do you plead to that? True or not true?
I don't waive the remaining violated condition.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Can we have just one second, Your Honor?
Sure.
I'm sorry, that's an alarm.
Okay, is it an alarm like don't plead true?
I was like, I don't know. Okay, then sure.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Did you understand? If you have an agreement, you think with the state, court does not have to follow that agreement. This is the contract with the court, not with your attorneys in the state. Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2, to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
It is to deny the motion and extend the individual honors for 3 years with weekly UA, I'm sorry,
Shaking his
weekly
head.
reporting for 90 days and also random UAs for 90 days, Your Honor.
He does not like that. Defendant does not like this.
Is that what you're requesting?
Yes, Your Honor.
All right, state you're excused.
Thank you, Judge.
All right, so why should I do this?
Your Honor, this is a very old case and he's completed his 90 narcotics in 90 days. He's completed outpatient treatment. You did have him on 6 drug tests a month at random with a daily call-in for quite a bit of time, and he only missed 3 call-ins that whole time. Yes, he missed 3, but that's it. He did obtain his high school diploma. He works for a government contractor. He also works for Spectrum. He's really done well with all of the treatments he's received. He'll drug test today, but we are asking this court to please allow him to show you for the next few months that he's very serious, and he's also spent 20 days in jail.
Okay.
as a result.
All right. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth? So help you God.
Yes.
All right. You can lower your hand, state your name for the record.
Joshua Days.
All right. What's your position at Spectrum?
I'm an inbound call center agent.
All right. Are you the person when you call and you're on hold for a long time?
No, I'm the person who I handle all the people who were on hold.
Oh, okay.
So I get the back end of it, and people are angry at me a lot, but I'm doing good at bringing them
All
down.
right. So why have you not been doing well on probation? What is your issue? Do you want to go to the state jail facility for 2 years?
No, man.
All right. So,
I've changed a lot over the course of the since I've been on probation, since the motion to revoke has begun, and I've completely changed. And I remember I was here last time when it was Thursday, and you were saying like, why do people change after the fact and stuff like that? And I hear you, but I've made a considerable change as far as my personality and things that I do, my habits, etc. I'm just a completely different person now, and I realized that I was becoming a product of a system due to my old decisions. And considering that I'm a new person now, I don't want to be a product of that anymore.
all right. And how did you enjoy the Bear County Jail?
I hated it.
All right. So I do see probation. I'm reading the court summary. So he's telling me he's completed his GED.
Or a high school diploma.
High school diploma. So that's been completed. And he's informed me that he did do his 90 sober meetings in 90 days.
Yes.
So what are you planning on doing with the rest of your life?
Well, nothing short of being very, very rich, honestly. Like, I don't mean to say it like that, but I have big dreams. I have very high ambitions, and I have the resources and the drive to accomplish 100%.
Well, I always tell people being very, very rich. Oh yeah. My thing is people should, but you know, it's people should want to be able to support themselves. I'm always shocked when people don't say, hey, you know what? I just want to be happy.
But yeah, I have big plans for like things that I want to do and stuff like that. I'm also working in the process of like starting a nonprofit for foster kids and stuff like that, because I was a foster kid as well myself. And so I have a lot of, I could go on and on about my dreams, honestly. I have big dreams. So
no, you know, there was always a big issue with the foster care system.
I agree.
Where children would age out of the system, and then it's good luck to you.
Mm-hmm.
And there's a program that I used to be involved in. I used to be on their board. It's called Youth Transitioning into Adulthood. Mm-hmm. And so it was designed to help foster children, because at the end of the day, I think all of us who went to college, when we went to college and you're short on money, you would pick up the phone, call your mom or somebody to send you money. But when you think about it, if you're a foster child, who are you going to call? So I'm glad you're looking into doing that to make the system better for foster children. I really wish they would take advantage of the fact that they can go to college for free.
Yeah. I didn't.
And you didn't take advantage.
No.
Look at this. I now had an opportunity
but I'm
to
actually,
have college
I'm
for
actually
free.
glad that I didn't. I needed to go through everything that I had to go through at the time that I did, including this. And this was, the motion to revoke was actually one of the best things that ever happened to me, honestly. It made, like I said, it made me realize that I was becoming a product of my decisions from years ago, and I really was not that same person at all. So then I completely changed my behaviors. I read every day now, like self-development books. Like I'm very intelligent, like self-taught. Everything that I've built as far as the business and stuff like that, it's completely self-taught. So I get my.
Well, if you're looking for doing a nonprofit, one of the things you should see if maybe you can go to the legislature and change the law, because sometimes when you're immediately out of foster care, they did extend the time for you to apply and go to college. And all you have to do is take one course, and you take that one course, and then it's available for you. But maybe you want to talk to the legislature about changing that, because sometimes when people are in foster care and they age out, they don't have necessarily the guidance to say, hey, just try college. And then if you don't like it, then you can do something else, but at least register for a
Texas.
class so it's available to you.
My goal with that is to cultivate a bunch of business owners who can, we can kind of like start like a little school to where we go to people who are going to age out, and then we teach them new ways to like make money so that they have something to do when they get out.
Well, you should actually talk to the organization YTIA. You've transitioned into adulthood, and let them know that you were in foster care, and let them know different issues you see, because they're always open to that. All right, this is what the court is going to do. Court is finding violation of condition number 2 true. If you're drug tested today, what are the results going to be?
Negative.
All right. So, Ms. Abrams, we're going to do a drug test today by 3 p.m.
KBF, that sounds awesome.
If it's negative, extend for 1 year. If it's positive, extend for 3 years. And there are to be regular random UAs if he's negative. If he's positive, as I said, extend for 3 years and have him come back here to look me in my face and tell me why he was positive.
This case expired in November of 2022.
Mhm.
So if we extend him for just that 1 year, that case would have been terminated 2023.
Yes.
So if negative, regular random UA thereafter would not be.
No, if he's, because it seems to me, and if this is not the party's intent, and if people don't, we can go off the record, if this is not the party's intent, let me know. It seems to me that when this motion to revoke was filed, I asked him to do certain things. He has done it. He's on probation. We're trying to rehabilitate people on probation. It seems to me that he's addressed the issues I wanted addressed. He's obtained his diploma. His phone won't stop going off. Maybe I should extend him 3 years for that. And, if he's negative, then.
I just want to make
Yeah,
sure.
no, I appreciate it. So, Ms. Abrams, how do you feel about the court? If he's negative, he'll be done. All right. If you're positive, you're not going to be done.
I hear you. I will definitely be negative. I haven't been using and I don't use.
All right. So you need to be drug tested. And Ms. Abrams, if you let them know he needs to be drug tested for alcohol as well, and that's by 3 p.m.
Sounds good.
Yes, ma'am.
All right. Is there anything else?
No, Your Honor. Thank you.
All right. Good luck to you.
Thank you. Have a good day.
Thank you, Your Honor.
You're welcome. Good seeing you.
Hopefully he's not back again tomorrow to explain a positive drug test. Guess what? TikTok just sent me money. I have not done anything on TikTok for over a year. And they just sent me $70.
Hi. Yes.
I'm not sure why.
How are you doing?
TikTok pays people. They do.
Oh, yeah. I don't know what's going on.
I made a viral video on TikTok. It had
I'm going to put you in charge of
16 million
that.
views. It earned me in 2 months, earned me about $600,
Oh, my gosh.
which is nice, but it's not enough to live on in 2 months. I've not posted anything in TikTok in years.
Who's here on Markeisha Cyphers?
It was a video of me trying on certain jeans. No, it was not. It's a science video.
All right, what's happening with this case?
Judge, we signed a motion to withdraw the MTR. My understanding, there was a new number 1 that had been dismissed out of Harris County, and then the rest of the cases, it was up in the community service, and then it should have been failure to provide documentation.
Okay. So let me see here.
I don't know what video people are watching that earned me $70.
I do not know why that keeps popping up. There we are. That's what I'm looking for.
But I have almost 26,000 followers on TikTok, 2.4 million likes. Maybe I should do something on TikTok. Free money equals kitty toys and a snack. It's probably going to go into like the gas tank to drive across the country is what's going to happen with that. It came into
All right.
PayPal already. It just
So
arrived
they
this morning.
withdrawn the motion, and they say it was based upon the new number one out of Harris County that was dismissed.
Yes, Your Honor.
The science. Let me show you the science video.
Now let's address the other thing that's going on with you. All right. They say that you have failed to start in or complete parenting classes. Why not?
You got to do the parenting classes.
Yes, Your Honor. First, I would like to say that I have.
Everyone, please whisper.
I have started the parent classes, but it's true I did not complete because 8 classes, I only completed 6 of the 8.
All right.
Yes, sir.
That needs to be completed. You understand?
Yes, sir.
All right. And then they're saying you have the restitution amount.
Your Honor,
How are you working towards that?
there's several ways she's worked towards that. She's had a medical problem. She's still in therapy from a car accident she had. She has sold a house and is pending receiving the money. It will be enough that she'll be able to pay off the restitution.
All right. Let me see how long you've been.
Same with the community service.
All right. So if you pay off that restitution amount, because that's what's pending, and complete your parenting classes,
Yes, sir.
then I will terminate you from probation.
Yes.
Otherwise,
will terminate
you're going to
you.
be on
That sounds
probation.
quite-
You can be on probation up to
serious.
10 years. Do you understand?
She can
You
extend
could be
her
on probation for a total of 10 years. Do you understand?
Yes, ma'am, I understand, but I thought I was on probation for,
You will.
No. What I am telling you is,
I'll tell you in a second, Lenova.
if you want this probation to end, you need to do what the court is asking of you. One is you need to pay off that restitution.
yes, ma'am.
I understand that people have illnesses. I understand that people are in car accidents and other things, but the complainants in this case, they want their money. And you need to complete parenting classes. Do you understand?
Yes, ma'am.
All right. And you need to make sure probation on this case, if you can make sure she has an installment plan in place, but she's saying she's selling a home.
Has sold a home.
Oh, has sold a home. All right. And she's going to be paying that off in full. Is that correct?
That was my understanding.
Yes.
All right. And so when is that going to happen?
Well, we're entitled, we're in the closing process, entitled takes up to, it can take 90 to 108 days. Been already sold it 2 months, been 48 days into it. So I'm just waiting.
All right. So, yes.
The restitution is included in our monthly payment.
Okay.
So there is a payment plan already.
All right. So she says she's going to have the restitution paid off as soon as closing takes place. All right. Is there anything else?
No, Your Honor, once those two things are completed, she'll give me evidence of that and I will come into the court.
All right. Thank you. Thank you.
Thank you, Your Honor.
You're welcome. Thank you for dressing appropriately for court.
Yes.
All right. Who's here on Ezekiel Neely?
Okay, we're gonna pause for just a minute here. Lenova, I told you I'd tell you what the video was. The science video is I bought they call it a ball chain. It's not ball and chain, but it's a little, think of like a dog tag necklace material or a keychain necklace material. I bought 100 feet of it. It's right here in this cup. And I took it in this cup and you pile it all up in the cup and you take it a little bit out and you drag it over the edge and you drop it. And when the part that hangs out of the cup is long enough, the weight of it is going to auto sort of siphon it out of the cup. So it'll go up and over the edge and fall. And as it falls, instead of just going up and over the edge, the part that's in the cup will actually jump up higher than the edge and it will start floating above the cup. And it's just really cool. It's a cool little effect. So I filmed that and it got like 16.2 million views. So I guess including what TikTok just paid me, my $70 chain made me 10x return. So I made $700 on it. Jen Del Rio, welcome to the gallery. Good to have you here. Welcome. We're gonna do a quick jump up to Thurston County.
Thomas Smith is in the courtroom.
Okay, I want to talk to him. I just have lots of people ready. So
I'd like to speak with you.
Who is that?
Miss Stacy, Jessica Stacy.
Okay.
And me as well. My name's Alicia Butler.
Okay. I guess I'll want to speak to those two.
Okay.
The judge is invisible.
Is Miss Stacy? Let me have Miss Stacy.
You want to see it? It'll make a mess on the floor, but I'll do it just for you guys. We'll wait. We'll come back to this because court's not starting yet. Okay, so let's see, which will work better? Is it like this? Will this be best? Let's try this camera. Okay, so here's our. The green screen causes problems for it, so we got to do this camera right here. Ready? Here we go. Oh, it's tangled up. It's not going to work. I have to rebalance this. So I have to pull everything out and restack the whole thing because it looks like the kids shook the cup up, which ruins the whole thing. And it's got some tangles. So we'll watch court for a little bit, and you'll see me slowly feed 100 feet of this back into the cup, and then we'll start over. Wah, 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 wah. Ended poorly.
Was she saying she wanted to talk to me again too, or the other two?
The sheriff spoke to you, right?
Yeah. Okay.
Just let her, she hasn't spoken to you.
Shame on you, sir.
Okay, 100 feet out. Now I need to put all 100 feet back in.
Are you here for court today?
Yes.
What's your last name?
Arlo.
And your first name? Perfect, thank you.
Thank you, ma'am.
Mr. Swenson?
Yes,
Let me know if you'd like any breakout rooms.
thank you. I'm waiting. It looks like my first cases are at 9:30. So I'm just waiting.
Sounds
for
good.
people. Thank you.
So it definitely takes longer to get this trick ready than explain it. That video was off the chain. Okay, so now it's stacked up. Now I can show you one more time here. Here we go. So you want to watch, you want to pay attention to the chain above the cup right here where it comes over the cup. It's going to make a mess on the floor. You're not going to be able to see that, but that's okay. Move the wires out of the way so they don't cause problems. So here we go. You ready? Yeah, it jumps out of the cup and sort of floats in the air. That was it. Take two. Worked like a charm that time. So, cool little science trick. And the reason it happens is because a couple reasons. You know, object in motion wants to remain in motion. And also there's this is not really a chain. It's like a lot of little segments, and each little hinge only bends a certain amount. And once it bends that far, it becomes a segment where if you pull on the bottom, then equal opposite pressure is applied on the other side. So it's actually throwing itself up out of the cup. But pretty cool. Looks like Robert is an Eagles fan. He's wearing the shirt. I think it's the hat on, even though it's backwards, and he's got the number 12 jersey, flag on the wall. So. Yeah, Candace, it's a great idea. I love it. I
I think I
just
need
tell
to speak to this phone.
Careful when you
Hello.
search this on the internet.
Hang
I
on a
bought
second.
this
I'm
from
going
a
to put us
company
together in a
called
breakout room.
ballandchain.com, I think, but don't you get into some weird stuff if you Google this wrong. So just be careful on that. It's not the Eagles, it's the Seahawks. They're the Sea Eagles. Okay, sorry. I'm sorry. As a Philadelphia and Philly diehard fan, I'm offended. You know, I'm all about sports. Yay, sports, go team. I could not tell you any sports. I can't even get the baseball teams separated from the hockey teams. We're going to check and see if there's some other courts coming up as well, because Thurston, I think, is going to be a hopping place today. Thurston County District Court 2 is what we're watching right now. Let's see if we've got any of the other courts. 1 is not live yet, though it will be. They put up a test video. 3 is live. That's a protection order calendar. I'm not really interested in that calendar. 4 is not live, so maybe just 1.
Heidi?
Now I have to put the chain all back in the cup. Hang on. It's going to take a minute. Mission accomplished. It's all back in the cup. And it's beautiful, pretty. Ask me for other science tricks. I've done. I used to teach. I taught a summer science class, mostly for homeschool kids, but for anyone who wanted hands-on science. We did everything from burning lasers, where we use lasers like lightsabers cutting through black trash bags, underwater O-rings. Did some gravity stuff where we had a pendulum and we'd have a bowling ball weight that would swing and almost smash your face, but then stop. We did. Let's see. What's some of the more fun stuff? Oh, visualizing sound waves using a speaker system and a board with salt on it, so you can see different tones and the patterns they make in salt on the surface. Did some fun stuff. We made a replica of Space and Time, basically a flat, think of like a trampoline, but made out of spandex, 4-way stretch spandex, and you can demonstrate how gravity works, and it's really cool stuff. How orbits function. Did some fun stuff. This is Thurston, Washington. You never know what you're going to get here. It's wild. Things are different up here. Thurston County's a bit. I mean, we've got some good friends from up there, but it's a bit funny. I will say one of my other videos that went viral on TikTok was showing how to pick a lock. Specifically, it was the old style of master lock, combination lock. Hey, Attorney Swenson's back. Welcome, sir.
Madam Clerk, are you there?
Yes.
Could I get a breakout room with Robert Chapman, please?
Yes.
Yeah, I'm thinking he better take his hat off once court starts. I didn't do videos of a lot of it. It was live and in person. I had, I think, at the peak, I only had like 12 kids enrolled in the class, but we'd set up a tent in the front yard. It was all outdoors in the front yard, and we'd do science all day. It was such a blast. Rick, you got your screaming goat today. I love it. Let's scream in unison. Ready? 3, 2, 1. Glad you got a screaming goat. Any suggestions as to what we think Robert might be in for?
Mr. Chapman?
Criminal mischief. I'm super excited about today because I've got the rest of the parts for all but one part. The last expensive part I haven't been able to buy yet. It's not in the budget yet. But I've got, Trent Smith's here too. I've got all the rest of my parts for my audio rack coming. All the bolts that I was missing, little nuts that go in the back of the screws that will attach to the audio adapters, the extension, antenna mounts, cables, everything. So we're good. I'm so excited. I don't know if you want me to do a live build or not, but see, public intoxication at an AA mandated meeting is my guess, says Jim Bob. That's a double whammy. Drunk and disorderly, domestic, ticket scalping. Melissa, this might be the best one yet. Where are we? We're in Thurston County, Washington, so we're on the Pacific Coast. think Joseph's taking us out into his greenhouse, which is cool. Is that a Seahawks hat he's wearing too?
Thanks, guys.
Oh, here comes the judge, everyone.
Thurston County District Court's now in session. Judge Meyer presiding. Buckley presiding.
Good morning. Please be seated.
Hey, Judge, Your Honor. Good to have you here. Smiley Judge is back.
Good morning. This is Thurston County District Court, City of Lacey calendar for Monday morning, 15 July. We have folks in the courtroom, some appearing remote. These proceedings are being live streamed on YouTube to increase public access. Ms. Langley, good morning.
Good morning, Your Honor.
Mr. McClellan, good morning.
Good morning, Your Honor.
And Ms. Langley.
Thanks. If we could start with Mr. Collins, he's number 5 and 6 on the 8:30. I think this was erroneously calendared, needs to be stricken.
All right. Jerry Collins.
I'm here,
Mr.
Your
Collins,
Honor.
good morning.
Good morning.
And Mr. McClellan.
That's correct, Your Honor. Unless the court sees something that we're missing, he resolved this case in June. There was a pending matter in a PFTC, and he resolved it back on June 10th. And I don't believe there was anything outstanding, so these may have been previously set, but there's no motion the city's aware of, and I'm not making anything now. So I'd disagree that we strike the hearings for today.
All right, thank you. Let me just confirm that so we don't run Mr. Collins back through this again.
Right.
I think Robert's about to get his camera turned off remotely.
All right, looks like back in February, there was a motion regarding a new law violation.
I think Joseph is touring the
And
back
that
40
was
acres.
regarding one of the cases that's on the calendar today. Actually not. It's regarding the protection order charge from January 26th. And as was pointed out, that it resulted in a deferred sentence. All right, so I'm assuming the agreement then on the resolution on the 10th of June on that case was to just note a violation and not take any further action on the two cases that are on the calendar today. Is that fair to say?
That is, my note said violations noted on backup matters, so maybe an order wasn't entered to reflect that. So if it wasn't, then yes, that is the position of the cities. No further sanction.
Okay. All right. So we'll just note on cases ending in 403 and 892 that the violation was noted on the 10th of June. No further action to be taken. All right, Mr. Collins, you're all done. We won't reschedule you on these matters.
Okay. Excuse me. Can I tell you something real quick though?
Sure.
I was supposed to report that I did my drug and alcohol assessment, and I have a mental health evaluation scheduled next week.
Okay. Yep.
And I'm not sure who I was supposed to report that to.
Okay. Thank you for telling me that. That helps. Telling me is great. So what we'll need are two things. On the drug and alcohol assessment, whatever agency you did it with, make sure they send us a copy of that to Thurston County District Court.
They said I had to sign a ROI, but I need one from you guys. That's what Northwest Resources told me.
Okay, yeah. So what happens with the ROI is you go to Northwest Resources and you sign an ROI, which is a release of information, which gives them permission to send that document to Thurston County District Court. So you don't need anything from us. You need to go to
Okay.
Northwest Resources, sign the document saying they can send the information to.
She said that I had to put a case number on it, and I'm not sure which case number to put.
Okay. Well,
can I do this case number?
Yeah, Ms. Langley can put it on there, and that's fine. Or you can use this case number if you have this.
Yes, I have this case number.
Okay, yeah, just use that case number and have them send that send that information to Thurston County District Court, and then you'll do the same thing for your mental health evaluation. Sign an NROI and sign an ROI with whatever agency you do the mental health evaluation, and have them send that to Thurston County District Court as well.
Okay, thank you.
All righty. Thank you, Ms. Collins. Have a good day.
You too.
Thanks. Ms. Langley.
Thank you, Your Honor. Let's see.
The judge just keeps looking at Robert.
Let's see who I need to. Can we call Miss Groth on the 9 o'clock? She's number 8.
Tia Groth.
Nobody up here. It feels weird.
Sure. Right there. Yeah, without having an attorney there. Ms. Langley is present. All right. So good morning.
Good morning, Your Honor. Sorry.
And see, Ms. Langley, we have a confirmation on 12 August. Are we just keeping that?
No, she intends to change her plea today. Hopefully the form has made its way around.
All right. Let's see what we have. And it has.
Who's number 12 on the Seahawks? Who's
you go by by Groth or Growth?
Groth.
Groth. Okay.
Yeah, Robert would not have made it this long with Judge Boyd.
Groth just sounds weird.
You don't have a cousin by the name of Lolly, do you? I knew a Lolly Growth spelled the same way. She pronounced it Growth.
12th man, meaning the crowd.
I stick with the German version.
Yeah.
See, all you sports experts knew that, and I'm thinking there's some guy out there with the number 12, and I have no idea who he
It's
is.
a tall man who stands out.
Okay.
And it goes good for my brother because he's 6'6".
And it is perfect. Yep.
For me, not so much.
So 12th man, that would mean
Ms. Groth,
football,
I have
right?
here the statement of defendant on plea of guilty to a charge of driving suspended 3rd degree. And on that form, it looks like Ms. Langley signed it for you. You gave her your authority to do so?
Yes.
Any questions for me about that form?
No.
Okay. You had sufficient opportunity to go over that form with Ms. Langley?
Yeah, she explained.
You understand by pleading guilty to that charge, you give up the constitutional rights set forth in paragraph 5 of the plea form.
Yeah.
And you understand the sentence recommendation is to defer sentence for 90 days, or pardon me, the sentence of 90 days to defer that for 1 year, and you're not to drive until you have valid license and insurance.
Yes.
Okay.
Oh.
And your statement here
and Robert just got
indicates that on the 15th of May, you were operating a motor vehicle in the city of Lacey. On that date, your license was suspended. Is that accurate?
Yes.
I'll find sufficient factual basis for defendant's plea. Find the plea is made knowingly, voluntarily, with full understanding of the consequence. Accordingly, I accept defendant's plea and are finding guilty based on that plea. Is Langley anything further on sentencing?
It's an agreed recommendation, Your Honor. Thank you.
Thank you.
I think my package has just arrived. I'll be right back. Don't let Robert get told off by the judge while I'm gone.
And Ms. Garoth, anything else you want to say?
No, I just wanted to ask if the $43 fine that she was talking about will be released after this so I can go pay it.
Good, excellent question. That's exactly what I'm looking at right now.
Because I was trying to pay it beforehand, but I have my husband's debit card and they wouldn't accept it.
Okay. And what's the status on you getting insurance? Do you have insurance?
We were just trying to go through this and then we're gonna go get insurance through the general because it seems like it's the cheapest and then I can take my driver's test.
Okay.
I just started work about a month ago after having baby and she was born premature and stuff, so we had a whole bunch of emergencies and everything. And
right.
Finally getting things together.
Okay, good for you.
Yeah, and no more babies.
It's not the baby's fault, but
definitely
it is
not
a
her fault.
distraction.
A distraction, but she almost killed me.
Oh my gosh.
Yeah.
Not sure what Robert's doing.
And I have 4 adorable little girls, so 4 is good enough.
Okay. All right. So you have, I'm looking at your licensing history here. You owe a $75 reissue fee to the Department of Licensing.
Okay.
And you have this driving suspended ticket from the city of Lacey. That's the $43 that you were talking about.
Yeah.
And that's the ticket that's suspending you.
Yeah.
So what I'm going to do is I'm going to waive that $43 so you don't even have to pay it. So now all you have to do is go to the Department of Licensing and pay the $75 reissue fee. And I don't see that you have to retest. I think if you go pay the reissue fee, you may be able to just get your license. So don't drive until then.
Yeah, I've been taking buses.
Okay, but go to the Department of Licensing, pay the reissue fee, and I've waived the $43 on that ticket. So Heidi, it's the ticket from July 27th, 2016. And it was a driving suspended charge, so just waive that $43. Okay?
Thank you so much.
Okay.
If I could give you a hug, I totally would. I'm gonna go pay the 75 right now.
I'll just take the virtual.
Thank you very much, Ron.
Okay,
You're
okay.
fantastic.
All right. Bye-bye.
If I could give you a hug, I totally would. He's like, okay, I'll take the virtual. You stay back there, man. It was a hard pass on the virtual hug.
And for the record, I followed the sentence recommendation in this case, suspending the 90 days for 1 year and condition of law, no law violations, and no driving without license and insurance. Ms. Langley.
Thank you. If we could call Mr. Joseph Shelby, he's numbers 12 and 13 on the 9 o'clock. Anyway, he has to get to work.
All right. Thank you.
Shelby. TJELD.
Shelby on the 9 o'clock?
Shelby.
Yeah, it's spelled TJ.
Geldy, yeah. Oh, Geldy. I'm sorry. Okay. And what are we doing in Mr. Geldy's case today?
He is still pending competency in his Superior Court case, and we were tracking that. His next hearing is set on September 9th.
Oh, okay. All right, so we're in a stay here, and did you say the evaluation is scheduled right now?
I think they've been trying to complete it. This has been bumping along in Superior Court. I'm looking in Odyssey right now, and all I see is it's the next capacity competency hearing is set for September 9th. So
Okay.
if we could just set out after that, I don't know what else to do.
And Mr. Geldy, what do you do for work?
I'm working for the I'm gonna work for my neighbor doing what his construction stuff today. I've never done that before, but usually I make pizzas for my sister. She owns the Papa John's in Lacey and Tumwater.
Oh, okay. All right. And in this case, it's been around for a while.
Yes.
Ms. Langley, what's in this very short conversation I just had with Mr. Geldy, I don't see any significant issue, or is there something that you're seeing?
Oh, well, I'm only following what's going on in the other court. So let me see if I can talk to someone over there and see, because you know he's looking at some serious consequences. I don't feel comfortable if there's a competency hearing pending. So I'll see what else I can learn.
Yeah, I mean, I see the note from January that we became aware of the filing in Superior Court, but you know, people can get better. And Mr. Geldy seems just fine to me today. So, Mr. Geldy, you and Ms. Langley will be having, you know, some more conversations, and perhaps there's a way of resolving this matter without waiting for Superior Court. So I'll just set a new court date.
Okay.
We are in the stay of proceedings with, I mean, I assume both parties are agreeing that even though this case number isn't on the 1077, we're in a competency stay, Ms. Langley?
Yes. Yes, Your Honor.
Okay. We'll note the record that we are in the competency stay. And let's set I'm just going to set a hearing for 30 days out and just give the parties a chance to figure out if there's some other way of handling this rather than keeping Mr. Geldy coming back to court. So let's do that on Monday, the 19th of August. And I'll make that at 9 o'clock for Mr. Geldy.
Oh, okay. You know.
All right, Mr. Yeah, go ahead.
Well, it was 7 months ago. They told me my evaluation would be about 7 months. But then last time I heard it's another 7 months.
Right.
So, I don't know.
Yeah. And, you know, just so you know, that's not unusual right now. Western State, who coordinates the evaluations, they have about a year-long backlog. So that's why it's taking so long. But I'm going to set a hearing for the 19th of August at 9 o'clock. And maybe there's a way of taking care of this matter where you don't have to wait around, at least the matter in City of Lacey Court, rather than we can't do anything about the Superior Court matter, but the matter here, we'll have another conversation on the 19th of August. Okay?
Okay. The 19th at 9 o'clock?
19th of August at 9 o'clock. And do you get text reminders of your hearings?
Yeah, I do, but I'm going to tell my son right now.
Okay. Very good.
Okay.
All right. Thank you, Mr. Geldy.
All right. Have a good day.
You too. Bye-bye.
All right.
For pre-trial.
Listen. The 19th at 9 o'clock. I'll put it right down. I'll message you right now, okay? Right this second.
All right, Ms. Langley.
Thank you. If we could call Matthew Smith, number 9 on the 9 a.m.
All right, thank you. Mr. Smith, good morning.
Good morning.
All right, have all conditions been met? My quick review of the docket would seem to indicate that it has once we had that letter of apology written back in February. Ms.
The
McClellan?
other issue was the restitution. Does the court have my affidavit?
Let's see.
It was just filed, like just.
I know, Your Honor, I've seen it, and Ms. sent me a copy of a check that basically from a trust account that she sent to the victim. So while the victim probably hasn't received that yet, it's kind of a verified, and Ms. Langley's provided assurances and an affidavit to that effect. So
yeah,
that will get processed, and so I don't think we need to address this any further. I think we could just come from moving to dismiss.
Yeah. So Mr. Smith gave me a check. I waited till it cleared my trust account, and victim didn't want their address disclosed, and then I mailed it to the victim from my trust account for the full restitution amount.
All right, let me inquire, Ms. Langley. This will be somewhat. Does the name David Baum mean anything to you?
He's the
B-A-U-M?
husband of. Yeah, he's the victim, or the husband of the victim, Beth Ann and David Baum.
Okay. All right, so that's the reason I have a bill for David Baum is that's what bill was paid. Is that correct?
That's for the tires that my client slashed.
Okay.
And that is what we have paid.
Okay.
1,000 and change.
All right.
How many tires did he slash?
With that understanding, we'll note the completion of the obligations, and it's a motion to dismiss. Is that right, Mr. McClellan?
That's correct, Your Honor.
All right. Thank you.
I know Wade Wilson got 3,500 messages from adoring fans. I think Matt Smith is the one we're talking about who slashed tires.
All right, Mr. Smith, are you on the medications these days?
Yes, sir, I am.
Okay, and they're working, I hope?
They're working great.
Okay.
I have good support team.
Okay, excellent. All right, well, it's nice to see that all the things all the conditions of the continuance that we had a year ago, you've done, so thank you. And I've dismissed the case with prejudice, so it's all done.
Ooh.
Okay, thank you very much.
Dismissed with prejudice.
Bye.
Where have we heard that before?
Ms. Langley.
Thank you. We call Mr. Braun. He's on the 8:30, I believe.
Robert Braun. Mr. Braun, good morning. You're muted.
Good morning.
Here he is. Robert's up.
And let's see. Like we had an issue with treatment proof. We had non-compliance filed back in June. And then I'm assuming violation was noted because this was set as a sanction hearing. It looks like it's previously been set as a sanction hearing for ongoing positive UAs and non-compliance with treatment.
And I'm really impatient.
Right. Ms. Langley,
Thank you, Your Honor. He's been working with Providence St. Pete's Chemical Dependency, and he tells me that they are sending him to inpatient at Olalla, and he's just awaiting a bed date. So I'm wondering if we move this down the road a little bit and see if he successfully completes that.
okay, thank you. And what's the status on mental health evaluation? Ms. Langley, any idea?
I'm not sure where we're at with that.
I never took a mental health, but I know that's
what.
Right. And Mr. Braun, I couldn't understand what you're saying there. Has that happened or not happened?
I didn't know that I was supposed to take a mental evaluation.
And are you going to get one scheduled?
I guess I didn't know I had to take one. I don't see why I have to take a mental health evaluation.
Okay, let's see what the genesis of that was.
I heard the same thing.
It's actually really good for your back, the cinnamons.
Exercise.
Yeah. I don't need any of that. My core is.
What was that?
Anytime somebody that happens, it's quite good.
Somebody just
I think that the evaluation from Northwest Resources, I believe, recommended that he obtain a mental health evaluation.
Yeah, that's what I was just looking at now.
And then when appropriate, I think the city would like to be heard on how to proceed today.
Okay. Yeah. So actually, this is interesting because Judge Wilcox was talking to us at our judges meeting last week about a situation exactly like this, where the original treatment order was for something, typically a chemical dependency evaluation. And then the evaluator says, oh, by the way, they also need a mental health evaluation. Not ordered by the court, ordered by or requested by the chemical dependency evaluator, and Judge Wilcox is feeling like that's not, and there was no basis. It just says this is what they think is needed. So we had discussed at our meeting about the difficulties of adding on new treatment modalities, not part of the sentence, and perhaps getting the parties to agree as to what is really the essential treatment modality and addressing that. So understanding that, Mr. McClellan, you have something you want to add?
Well, and I agree. I think that's a good discussion point, I'm sure. And I agree. The city's perspective here, there's a DUI, and I presume there's something that went into the evaluator recommending that, but the intentions or priority for the city was chemical dependency treatment. There was quite a bit of issues on pretrial with violations, allegations of use, and ultimately we were able to resolve the case. And so getting him into sobriety, monitoring for use was, I think, at the focal point for the city. So while I don't doubt that he could benefit from mental health treatment as well, I can respect the court's purview of whether that's part of the sentence or not. So regardless of that, we're here for sanctions. The city, as I mentioned, there was issues on pretrial, resolving the case with him on probation now, and it's been an ongoing challenge with treatment compliance and allegations of positive UA. So I'm asking to go forward with sanction today if he is recommended for inpatient and that's what he's waiting for, I hope that works out. But I don't know that we need to wait until after that to address the non-compliance. So I'd ask we go forward with the sanction and still have him on, and then have him still show proof of ongoing treatment if that involves inpatient or otherwise.
All right, thank you. All right, it looks like the drug at issue is alcohol. All right, so Ms. Langley, on the issue of treatment modality, do you have anything you want to say?
I mean, my position obviously is that he's struggling enough that I don't think he should be expected to do anything other than what the court ordered him to do, which was to comply with an alcohol evaluation. So that's what we.
Yeah, I think we'll have agreement on that. So we'll note in the record that the only expected treatment for Mr. Braun is to be the chemical dependency treatment. Now, I do see an ongoing series of use issues raised from positive UAs for alcohol. What I'm going to do is allow Mr. Braun to try to deal with this issue by going to inpatient treatment. But in the meantime, I'm going to put Mr. Braun on scram monitoring. And Mr. Braun, you're going to wear an ankle bracelet, which is going to tell us when you're using, and hopefully that's going to be a reminder to you that you cannot use. Alcohol is not something you can do. There is no leeway on that. So I want you to have this scram bracelet on in the next 48 hours. I will make you eligible for the county funded program in that regard. So it's not going to be a cost to you, but you are going to have to wear that on your ankle. If you don't, then basically all you're doing is leaving me the option of locking you in jail until you get a bed date. So this is the one thing that will keep you out of jail right now. So you understand what I'm telling you?
Yes.
All right. So you're going to have to work with Ms. Langley on how you go about getting that done. I've signed an order. There's a phone number on here. You have to contact them at that phone number, and you have to have it on by Wednesday.
Okay.
And I'll set a follow-up date. Ms. Langley, do you have any information as to the pendency of a bed date, or is this just a hope that there's going to be a bed date?
What they've taught, I mean, it is Northwest Resources, so I think they'll find him a bed date, but we don't have anything specific yet. I'm in St. Pete, so I think they'll find it, but I don't have anything specific.
Okay, so I'll set a court date for 9:30 on the 19th of August, and hopefully at that point, Mr. Braun is in inpatient treatment. And that'll be a sanction review hearing, or a sanction hearing potentially. Okay, so Mr. Braun, you're going to be on that ankle monitor by close of business on Wednesday. No more alcohol. Do not want to see any indication that you continue to drink. So if you do, the response is going to be, you're going to go to jail, and we'll hold you in jail until you get to inpatient treatment. So the choice is going to be yours. Just you. Okay, thank you, Mr. Braun. Ms. Langley.
Thank you, Your Honor. If we can call Sarah Anderson, number 1 on the 9 o'clock.
Sarah Anderson. Ms. Anderson.
Where did she go?
I'm here.
All right, thank you.
9 o'clock before the 8:30
All
calendar.
right, and Ms. Langley, we have a hearing date set for 9 September. Are we keeping that?
I'd like to actually set an earlier hearing, Your Honor. She has had 2 cases pending, one here and one Pierce County. She just resolved Pierce County. So she's going to be entering deferred on this case. She's been working with Northwest Resources. I've talked to them. We should have the deferred prosecution letter at the end of this week. So if we could set this next week sometime, she's on scram. She'd like to get off that. And so I'm hoping to enter that deferred as soon as possible if we can.
Okay, what I'll say is this, we're going to keep the 9th September date. When you have the paperwork all ready to go and Ms. Anderson's ready to file the petition, then notify us and we'll squeeze her into one of the calendars.
Perfect. Okay, thank you.
All right, so Ms. Anderson, let me confirm, are you getting text notices of hearings?
Yes, Your Honor.
Okay, so as soon as Ms. Langley has all the paperwork ready and you get her all the information she needs for that, then she can get it scheduled much earlier than the 9th of September. But at least for the 9th of September, that hearing will occur no later than that.
I understand, Your Honor.
May occur earlier if we get all the paperwork in. Okay, so we'll text you notice of that if we get an earlier date set.
Okay, may I ask a question quickly?
Sure.
She addressed the scram. I have not had one positive reading on my scram I've had it for 5 months and a week as of yesterday. I have never had a negative UA, or I'm sorry, a positive UA for alcohol. I just want to, if at all possible, enjoy a little bit of my summer with my children, i.e. like going to the lake and swimming. And the unit cannot be submerged in water.
Right, yeah. And what did Pierce County do with the scram device? Looks like you had a Pierce County order on scram.
Yes, they defer to you guys. So they weren't at judgment to allow it to be removed from what I understood. I just closed my case with them on Friday, Your Honor.
Okay. I'll take a look at their.
And I will say really quickly, if I may, I did not know, no one made me aware that there was any type of friendship diversion program. So prior to getting onto friendship diversion, I paid in excess of $1,000 for the scram before I knew there was a program.
Okay. All right. I hear what you say. I'm guessing the implication is you're thinking, well, maybe there's a way to get reimbursed for what you paid. And the answer is no, there's not. But going forward, you had the county pay for that. So
I understand. I know that I will not be reimbursed, unfortunately. I just hope that maybe that will be looked upon in further fines, potentially, that I've already invested that amount of money.
Okay.
But I know that maybe not be addressed right at the moment.
Yeah, I mean, given.
Or ever.
Okay. Yeah, that's fair enough. When the matter's resolved,
you
can make that argument.
I was just noting, I don't see that the doc has been updated yet for Pierce County on my end, but I believe what Ms. Langley shared is it was resolved as a reckless driving, amended for DUI.
Right.
Gotcha, Josh. We're actually looking, looks like Judge Cedric Simpson is about to go live, so we might jump over to him.
So it looks like, as Ms. Anderson points out, Judge Wilcox authorized friendship pay for the scram device back in April. And then the issue becomes that we start seeing positives for marijuana, which of course is not a scram issue. I was wondering why there were now UAs being required, but that would explain it.
May I speak, Your Honor?
Yeah, hold on.
Okay.
Judge is doing some homework here. Digging to the bottom of this. My packages didn't arrive, by the way. False alarm. What are we looking at? And Jessica's... Are there stickers on the ceiling? Oh, they're like stars and things. I think they're the glow-in-the-dark type. So if you turn the lights off, there's butterflies and stars and... More scroll wheel ASMR. Ooh, Alicia, I think dropped her phone just now. Hopefully we don't say anything we're not supposed to in the meantime. It's a little blurry. Oh, 2 big boxes just arrived just now. I think this is a microphone drawer. And this one's from B&H Photo, and it's parts. I mean, they're both from B&H Photo, come to think of it. You've got mail.
All right, so you broke your hip, looks like.
Ouch.
Is that right?
Yes, Your Honor.
Okay, when did that happen?
April 26th, I was in a car accident on I-5.
Okay. All right. I see use of marijuana, and I see non-compliance with treatment. You missed 6 sessions in the month of June. And now we have a newest report from July. I get that shows the 6 missed sessions in June. And prior to that, we had refusal to do UA and then positive UA. So we have a whole host of issues here besides the scram, and the information on Pierce County doesn't tell me whether they've released the requirement for scram or not. Just because you were sentenced on that doesn't mean that's over. The court has to release you from their scram order, which they initially imposed. So I don't know whether that's happened. So I can't tell, but anyway, there are a bunch of issues. Now, I'm going to let Ms. Langley talk so that you don't get yourself into trouble on this. Ms. Langley, what do you want to say? We have a whole host of things that have not yet been addressed as far as pretrial violation.
Yeah, I understand that, and I understand that she's had some struggles. And part of it that's been difficult for her is this kind of, as I've worked with her attorney in Pierce County, and our attorneys here trying to figure out how these 2 cases were going to resolve, what was going to happen when. it's gone on a long time. I think she's mostly been trying very hard to comply with treatment. She did have problems missing some. I'm not sure that there's any evidence that she's been drinking, so I'm not sure what the scram would be doing. And as I also said, I have this new authorization from Northwest Resources. I understand she has her next appointment on Friday. She's already has an SB2 evaluation, so it's just a matter of getting the deferred prosecution letter. I guess so. I understand her kind of wanting to be off that at this point. It was not originally ordered in this case, I don't think, but then kind of the idea was to get some assistance with the funding. So I'll leave it at that.
Okay. All right. So as far as the reschedule the hearing, we'll do what I said before. We're going to leave the 9th of September. It can be rescheduled if we have the paperwork in sooner. I am concerned about the ongoing violations alleged. There may be, it's no fun having a broken hip, I'm sure, but that doesn't explain noncompliance in my mind.
May I speak to that, Your Honor?
Briefly.
Okay. My original classes were scheduled in person. The very first week of my treatment was the same week that I got in my accident that following Friday. I was in the hospital for 2 weeks up in Harborview Medical Center. After I was released, the day after I was released, I got the scram put back on. They had to remove the scram for my surgery. And then Northwest Resources allowed me some time to decide if I was going to be able to return in person or I was going to resume Zoom, like start Zoom treatment. And so I started doing Zoom treatment very reluctantly because I thought in person was going to be more successful to me. Now I'm realizing that Zoom actually works better because the counselor has 30 years of sobriety. I want to remain sober. I want to stay sober.
Okay. All right.
He's like, I've heard enough. That's it.
I reviewed the text. I don't see that we've had any positives for alcohol. I am going to authorize removal of the scram device, but I'm going to replace it with you having to do at least 2 UAs a week. So I need those UAs to come in negative. I don't want to see any ongoing use of marijuana. I don't want to see any other drug appearing in your system that's not a prescribed drug.
I understand, Your Honor. Numbers will be going down as I believe they have.
Okay, and they better keep going down.
Yes, Your Honor. Absolutely.
And you can't miss any more sessions because, you missed half your sessions for the month of June. So that's not a good track record.
I understand, Your Honor.
Okay.
Can I ask one question? Where are my UAs going to be? Can I request that they're through my treatment provider? Because it's hard for me to...
Yeah, that's fine.
Okay.
But they have to do a minimum of 2 UAs a week. And
I understand, Your Honor.
They have to report the results to Thurston County District Court. So make sure that you tell them you need to sign an ROI so they will send the UA results to Thurston County District Court.
Yes, Your Honor, I have an ROI for you guys already in place there.
Okay, well, let them know that will apply to the UAs, and they can get you on their UA schedule there.
Yes, Your Honor. I appreciate this so much.
Okay.
Judge is like, okay. Just for the record, I didn't do anything special for you.
When will Friendship Diversion be notified that I'm allowed to have it removed?
When you give them the document that I'm about to sign, and you'll have to coordinate with Ms. Langley to get a copy of that.
So she gets to go swimming with the kiddos.
You're welcome.
That's awesome.
All righty. Bye-bye.
Okay, we've got Judge Simpson in action now. We're going to jump over there.
Travel path. He is co-parenting his 11-year-old daughter. The mother does not have her license. She actually appeared before this court, I believe, a few weeks ago. Tony Malone. I don't know if that name rings a bell or not, Your Honor.
No, it doesn't.
Okay. But the daughter is currently getting treatment at Community Mental Health, also at She goes to, as a physician, she attends Tappan Middle School. There are prescriptions related to her treatment from Meyer Pharmacy. So I have the addresses, and we're asking that because Mr. Jones does have a license and he could pick up and transport his daughter to these appointments, get her prescriptions, that we're asking the court to add those addresses onto the travel path. It also includes the child's residence as well, and his place of employment at LA Fitness, Your Honor.
At where?
LA Fitness. And if the court would like, I can.
Whose place of employment?
Mr. Jones's place of employment.
Lady Cause, you missed Friday. How do I know you missed Friday? Because Alec Baldwin trial is over because of Friday. I'm not going to spoil it for you, but you need to go rewatch pretty much all of Friday. Skip the breaks. There are 3 breaks in a row.
When did that happen?
But it was amazing.
Your Honor, he's been, it's more of a side job there. It's he's a boxing coach there. He does personal training there.
Okay. All right. Go ahead. I'll let you finish, and I'll tell you what I've got to say. Because
that I've addressed the addresses. We would respectfully ask the court to add to the travel path with respect to the recommend.
Well, so that you know, I cut the travel path entirely out, and I did that because he shouldn't be on. Okay. Every time I get here with Mr. Jones, I get something new. And the last time that we were here, either last time or time before that, he had indicated that he had an apartment at the Pheasant Run complex. He, in fact, gave us a date. Well, he didn't give us a date. He gave Community Corrections a date that he was moving in. It was also relayed to the court that the complex of Pheasant Run was where his daughter resided.
Correct.
And so in trying to carve out, I did something very unusual in that because he is not supposed to be in Ann Arbor, Saline, or Pittsfield Township. So I carved out a specific roadway that he could travel, get to Pheasant Run, gave him Pheasant Run, and those were the only places within that he could be. He was basically down Ellsworth Road. The reasons given for that was because that's where his daughter resided. Also, the reason was because he was going to be working in Canton. He was getting his employment transfer. Then find out, he reports to Community Corrections that he no longer has the apartment.
Thank you, Ken.
Which
Appreciate
I'm
the super
not,
chat.
I wasn't clear on what happened there, but that he wasn't moving in.
And not to interrupt the court, I could address that when the court's ready as to why.
And then I just closed that whole way in and just told him he could not be in Ann Arbor, Saline, or Pittsfield Township. Said nothing before ever about specific addresses, never said anything. That to me is as much a surprise as never again said anything about trying to get to one of the junior highs here or middle schools here. Nothing about that. And now that's the first time that I'm hearing it today, asking for a change in that. And LA Fitness is located where?
On Maple Road, Your Honor.
Yeah, that's where I thought. But he can't be on Maple Road.
Understood.
So when did that, and he knew Ann Arbor was out, so when did that come up?
So it goes into my The address first for his daughter, Your Honor, if I may.
Pardon?
With respect to the address for his daughter, he had the apartment ready to go. He was incarcerated for 8 days. There, Mr. Amadeo handled the bond hearing for Your Honor. He was released on tether. The apartment was no longer available to Mr. Jones once he was released. So that's why he's not residing there, but his daughter is residing there. I did receive, I'm sorry, Your Honor.
Had he deposited funds for the apartment? I mean, I don't know how that would occur. Because he specifically told us his move-in date.
He was supposed to sign paperwork, and I believe the paperwork that he was supposed to sign, he was still incarcerated, was not able to meet that deadline, and then released the apartment. Is that correct, Mr. Jones?
And he lost the deposit.
And he lost the deposit.
Go ahead. What about the LA Fitness? Because that was never even mentioned, and it isn't contained on the as employment on the on his pre-sentence report.
Your Honor, he just did not bring that up to Mr. Odell about that. But with respect to the other addresses, with respect to the daughter's physician, community mental health, everything else, I received communication from Ms. Malone with these addresses. I spoke to Mr. Jones about this. He indicated she does not drive, and they have a 50-50 parenting schedule where he would have the daughter 1 week on, 1 week off. And because she doesn't have a license, he's primarily responsible for driving the child to her appointments, to school, to her extracurricular activities. And that's why I brought up to this court, the exceptions we would ask the court to make.
I just bought 4 cables that I can't use. They're 1 foot long audio cables. I need 1.5 feet. What was I thinking? It's going to be so close. They're going to be.
Miss Valera, where did I have in my file a letter or something from Heather Moon?
Yes, Your Honor, there was provided an updated victim statement.
Got it.
And I received that as well from
you. Have
I have, and I've shared it with Mr. Jones, Your Honor. And Your Honor, with respect to the rest of the recommendation, there is no objection to the other terms and conditions of the recommendation. It's just these addresses that we're asking the court to grant him.
How many addresses are we talking?
May I approach, Your Honor?
Well,
these, I mean,
yeah, but I mean, how many are there?
We have 1, 2, 3, 4, 5 addresses, Your Honor.
That would be within the no-go-to zone.
They're in community mental health, which is on Ellsworth.
This defeats the purpose of having a no-go-to zone.
South Grove Apartments, where the daughter resides. The Meyer Pharmacy on Carpenter Road. Pioneer High School, with the daughter has extracurricular activities.
He can go to a
and
different
Tappan
pharmacy.
Middle School, where she attends.
Why the middle school?
Not right now.
Not right now. She'll be starting in September.
Do I have, let's deal with the employment thing first.
Sure.
Do I have anything that indicates he's employed there even part-time side job, anything? Because that has not been reported to probation.
I've got 4 new XLR.
So he has nothing with him today, Your Honor. He's a 1099 worker. I would ask the court that we have a review hearing in September. I think perhaps that would be the ideal time. Perhaps he can bring that back to Your Honor to show.
But you're asking me for an exception to the exclusion zone. Well,
I'm asking for the exception for those, including the employment, but he doesn't have any proof of employment today. So if Your Honor, if he doesn't have anything today and the court wants to address the employment in September, we could do that, or he can provide that to probation. I'm sure tomorrow he can provide that to probation, a copy of the 1099, and anything else that he can get from LA Fitness to give to probation.
is there a court order regarding parenting?
They do not have a court order, Your Honor. All I have is communication from Miss Malone. And Your Honor, I just became aware of this right when I walked in. I believe the daughter walked in prior to this case being called. I mean, she's here. I mean, I don't want to have an 11-year-old come up here, but I don't know how the court wants to, as far as any proof or verification.
Ms. Polari,
Your Honor, I just wanted to state, when I did the PSI with Mr. Jones on July 1st, the only income or employment, I should say, that he mentioned to me or reported was that he worked for Spark, which did the curbside pickup at Walmart and Sam's Clubs. Those were the only employment. That's all he indicated to me when I met with him on July 1st. So there was no other gym or anything else that he was working on.
Your Honor, I didn't get a copy of any of these addresses. So this is the first I'm hearing about this on the record. So I haven't had a chance to do my due diligence and check things out either, just for.
okay, because.
And I apologize. I just received you.
No, I'm sure.
Basically, I'll keep wearing the GPS, but I'd like to be able to go all the places that I want to go normally.
And I don't know. What to. The problem that I'm having is that I'm really not clear what to believe with Mr. Jones. I'm just not. I mean, because frankly, during the course of the trial, I don't think he was telling the truth. When he came back up here, I don't think he was telling the truth. It's very clear to me that with certainly the women that were involved, he wasn't telling the truth. And now I get, we at one point have a picture of things that then change to another picture of something. And now we come here and, you know, I get it, counsel, but I'm now with the third attorney.
Understood, Your Honor.
And I have now a different picture.
Understood. I guess the only thing I could offer is the one person that perhaps could verify it, Miss Malone, who's not here today, and with the court's permission, perhaps proceed with sentencing, and then I motion it up in front of the court and bring Miss Malone in, or Miss Malone could talk to Mr. Benak and communicate to the court. I'm just not sure I'm going to leave it to the court's discretion how to handle this, but all I did was I received a text message with a copy of addresses from Miss Malone indicating these are the addresses, this is what the daughter, where she attends, her mental health treatment, her physician, her prescriptions, where she goes to school, where she has her extracurricular activities. That's all I have to offer to the court today, Your Honor.
Miss Monday.
Thank you, Your Honor. Perhaps at this time, as defense counsel suggested, the people would also request that we move forward and make no changes to the tether today. Have faith in Ms. Pilara to communicate to the court if she's able to get sufficient documentation, and maybe things could be changed later.
Sounds like a plan.
I guess that's one way of proceeding. I mean, I guess
Judge is doing the
People also
unzipped.
share the court's concerns because of the history of the case, the defendant's history before this court, and also it is the middle of July, so the concern about these school addresses being communicated. I understand that the defendant is being recommended for a 24-month term of probation, so eventually these children will be in school, but unless they're in summer school, they probably aren't right now.
Will they be in school before?
Certainly the community
next
mental
case,
health
though?
treatment is ongoing. I don't believe that's paused.
Okay, and again, with that, now I will say, at least with that, while it wasn't specifically stated, there was some indication of some type of treatment. But I don't even know, nothing's been provided, I don't think. Ms. Pilara, was anything provided to you regarding his transportation to for his daughter to community mental health?
No, Your Honor. Actually, I met with him, he was in custody, so, but he's not provided.
Your Honor, as prosecution noted, I will have, if the court would be satisfied, I would have Mr. Jones provide this information to probation.
All right. All right. Very well.
With respect, with respect to that, we have reviewed the pre-sentence report, Your Honor. We would ask the court to adopt the recommendation. Fines and costs, my client's asking for 2 weeks to pay the fines and costs. And I don't know if you want to hear from my client at this time or if you want to hear from, I know the victims submitted a victim impact statement. I don't know if they want to address the court, but my client would like to.
Wish to address the court directly.
Their written statement is sufficient.
All right.
They are present, however, the written statement they provided.
With the court's permission, my client has prepared a statement on his own. He'd like to read it to the court.
I stand before you today with deep remorse and regret for my actions. I sincerely apologize to the victims for the stress and harm I caused by my actions and my bad choices. I understand that my actions were hurtful, inappropriate, and have caused unnecessary anxiety. I take full responsibility for my behavior, recognize what it has had on the victims and their families. My actions were inexcusable, and I'm committed to making amends and ensuring that such behavior is not repeated. I'm truly sorry for the pain and disruption I've caused, and ask for the opportunity to demonstrate my genuine regret and commitment to a positive change.
Mr. Jones, you know, I'm rather amazed by you. That's the best I can put it. That's not necessarily a good amazement. I mean, the way that you just use women is just I mean, just incredible to me. And I know that maybe Mr. Sarapoulos doesn't know this or not, but during the course of the trial, we were dealing with Mills, And then out of that, what gave rise to all of that was you being out with some other woman after having been involved with Mrs. Mills for about 3 years. Then we come for a bond hearing, I do believe it was, an emergency bond hearing, which was prompted by this other woman that supposedly you had a 7-year relationship with. She's in court. Somehow, it was very clear from the expression on her face that she got lied to about who Miss Mills was, because she was absolutely shocked. You could tell from her face. And so it just is extraordinary to me that you would do this to all of these people. Not only, I think, as Ms. Mills put in her statement, they just hurting their hearts and their emotions, but then just doing all of these things to these women, promising whatever. I don't even understand it, quite frankly. But you do that, if you remember, I told you, I can't trust you. I just can't trust you to do anything, because when you were on the stand, you were lying about what was going on then.
Defendant just looks down, won't make eye contact with the judge.
And what is so hurtful to me, in a lot of ways, is that you're raising a daughter. Mr. Jones, if somebody were to do what you've done to these women, to your daughter, what would your reaction be?
I don't know.
You don't?
No, sir. Your Honor, I don't know. I would feel regret.
What?
Feel regret for that.
Regret?
Yes, that, maybe not give my daughter insight on looking out for people like myself.
Just regret?
Here comes the judge. Hurt?
Shame on you, sir.
Yes.
Man, talk like a father. How would you feel? You heard that about your daughter. Talk like a father. How would you feel?
I would feel hurt and regret and anger. The best thing I can do is teach her to avoid what kind of man her father is.
If you're raising a daughter, why would you act that way?
It's mental health, Your Honor.
I'm going to tell you what, it bothers me also that as bad as all of these women around you were treated by you, that when I pose that to you, reference your daughter, that's the best you could come up with.
Your Honor, I seek mental health. I'm seek a therapist. There's a lot of things that I'm with my own demons as far as my behavior to other people, and it's a mental health issue.
Now, I was hoping for a minute when I asked you that question, sort of laid the background, that I'd get some answer that would make sense to this court. Because the cold-hearted reality of what I saw with this case, my initial thought was to impose additional jail time. I'll be absolutely honest with you. Because I don't know, because I heard the testimony, I know what you did to the Mills sisters, I'll just call them. I know what you did there. Left the other woman at the movies that they had to take your date home because you left them. And then I don't know, and I can't think of her name. I don't know what you told that poor woman that you were involved with for 7 years to get her to show up and even write the letters that she wrote to this court.
Your Honor, I deal with mental health issues. I've had, a victim of sexual assault when I was a kid, and I have a lot of trauma and stuff like that in my behavior. Destructive from that in relationships has been destructive in many relationships with people. I've failed to address it after getting out the Army, and having trouble with the VA. And I've actually been, from this point, I've been seeking mental health counseling to deal with.
Judge is done listening. But the hard part is making a decision on what happens next, because there are people other than the defendant who are affected.
Where did that come from? And the only reason I'm asking that is because I'm looking at your pre-sentence report. He reports no self or family history of mental illness. You know what?
A lie.
I don't know about anybody else in my family and their mental health issues. My family doesn't address mental health.
Okay, let's leave the family part out. What about self? You just sat there and told. Seriously?
I left it out because I wasn't addressing it before my probation report. I haven't been addressing, which is why my actions been the way they were. I have not been addressing my mental health for a long time, and that's why my actions wasn't about my mental.
You know what? You might stop. Because I'm going to tell you what. You can lie to all those women. The last person on this planet right now that you want to lie to is me.
Shame on you, sir.
I'm looking at this report. I know that Ms. Flair does a thorough job in terms of these reports, and you're sitting up here telling me something different, and I think you're telling me something different because somehow and or another I'm supposed to, the light's not supposed to shine on all these women. You want me to shine it on you and feel sorry for you.
Talk to him. Talk to the judge.
Your Honor, I've been in denial about my mental health all the way to being in jail. I've been in denial about my actions, and things like that. And when I was released, I was told by my sisters I need to go see mental health and address my issues, and it was a tough thing for me to do. I've been fighting it.
So where are you going now, if you are?
It was on 124 Pearl or Street. It's in Ypsilanti. It's one of the mental health counseling that accept my insurance, and I have to do an intake and stuff like that.
So you haven't gone?
Your Honor, I'm filling out the paperwork and I have to turn it in, and I did, and I have to wait for them to the intake. But I made the efforts to do that, and I'm waiting for them to respond and when I can come in and my therapist will be.
Are you going to therapy? Are you gonna go?
So when did you go do that?
I did it online and filled out the paperwork. It was 9 pages, and I submitted it in. I contacted my IHA.
Where is it?
It's in Ypsilanti. It's 124 Pearl. It's a group. It's called. Can't remember it right off the top of my head. I could look at my phone, but I don't want. I know I can't do that. But it's a mental health counseling right in Ypsilanti. It takes Medicaid and.
Okay. Let's see if that's even the truth. Go get your phone, figure out what it is. Miss Polera, get a release so we can fax it over to him. I want to see if he even signed up for it. I'm going to pass them.
They have the documents. I don't have them.
They what?
They have the documents. I don't have I submitted them in online.
Okay. But we need to know where it is.
We'll just wait for a minute.
In 124 Pearl Street, Integrative Empowerment Group. It's 124 Pearl Street, Ypsilanti, Michigan.
You got a phone number? Get it to Miss Polera. Don't give it to me. Get it to Miss Polera. Miss Polera, can you get a release from him signed so we can at least see if he submitted the form?
They told me they'll get with me when it goes through empowerment interrogate. Right. That's the I have to go.
But while we do that, so that these other people don't have to wait for this mess, I'm going to pass the matter.
Is he in or not? Are you in?
I submitted. I'm not in yet. They have to review my paperwork and then they'll get a hold of me. I don't know who does that.
I'm passing this matter. You can go back and sit down, Mr. Jones, because right now this recommendation in my head is changing. Or cause the case. People versus Jeremy Ruff.
Good afternoon, Judge Kyle Hill, on behalf of Mr. Ruff, who is approaching the podium with myself. Mr. Ruff, once we approach, please state your name for the record.
You guys probably don't want to come up right now, do you?
We'll be fast, Judge.
Go ahead.
Jeremy Ruff.
Thank you.
So, Your Honor, I was very recently appointed on this case. I received discovery this morning. I haven't had a chance to review it myself, let alone with Mr. Ruff. We're simply asking for an adjournment on this matter.
I'll adjourn the matter to
1 p.m. And Your Honor, no objection, of course, to an adjournment. I did, however, notice that this perhaps should be placed on the non-DV docket. I think this is a stepchild relationship. I don't know that this is an intimidating relationship.
They've muted the audio for this one. Probably because of kids' names. Should be pretty quick. They're just asking for a continuance. I want to see what happens with who was it, Mr. Jones? I want to see if that checks out. Because if he's been lying to Judge Simpson, oh my goodness, it's going to come down around his ears. Holistic robot. I can write you a pass, and it usually works, but it usually works really well.
August 5th, what time are we? At 1 p.m.
Your Honor, if I may.
Yes.
Mr. Rupp indicates that he has a new job and he has orientation on August 5th. He's asking, I'm sorry.
I had orientation.
He had orientation today. I'm sorry. He had orientation for his brand new job today. He's trying to stay right by the court as well as employer. He's just asking for Zoom on August 5th.
If the forms are submitted, I don't have a problem with it.
Thank you, Judge. I'll submit those.
Bonds will continue. Thank you.
Thank you, Judge. And you can sit down.
Court calls case People versus Anthony Mesa Maldonado.
Testimony for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Mesa Maldonado. Please state your name for the record, sir.
Anthony Jose Mesa Maldonado.
Thank you.
Thank you, Your Honor. We are respectfully requesting a brief adjournment of this matter to further discuss this matter with my client.
During this matter, August 5th, 2024, 1 p.m.
Thank you very much, Your Honor.
Bond with its conditions will continue. Thank you. Court calls case of the People versus Alexis Naveen.
Testimony for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Naveen.
You know, everybody was blocking my view. I was wondering where you were. I knew you were on my docket. I'm like,
here, Your Honor.
Better be here. No, go ahead.
Thank you, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Ms. Naveen, stepping in for Ms. Perrony this morning. Please state your name for the record, ma'am.
Alexis.
Thank you, Your Honor. We are respectfully requesting an adjournment of this matter to track with Ms. Naveen's other matters. I believe the next court date on those is in August 22nd. And we would also ask.
That's the.
Oh, sorry, Your Honor. I was just going to say we would also ask for an adjournment of the bond violation as well to track with the pending felonies.
So the other felony cases are set for what date? The 22nd?
Yes, of August, Your Honor.
What's my closest to that? I don't have the 26th.
So,
were you looking to put it before or after, or did it matter?
After. After, Your Honor.
Probably the closest I'm going to get. I'll just adjourn everything, the pretrial as well as the sentencing on any violation to September 9th, 2024 at 1 p.m. Okay.
Thank you, Your Honor.
How's it going?
Well, Your Honor, thank you.
Is it?
It is, yes, Your Honor.
Really? You wouldn't not tell me the truth?
No, Your Honor, I'm doing well. I'm doing well, taking steps to make sure I'm successful.
I was saying to my staff when we knew you'd be out here, I may have mentioned this to you the other day, you're looking well.
Thank you, Your Honor.
All right. And look like things are improving for you. So that's always good to see.
Thank you.
All right.
The opportunity.
Just keep working at it, right?
Yes, Your Honor. Thank you.
All right. Take care.
Your Honor, thank you.
Thanks, ma'am, for coming with her. Because I see you back there. I saw you. I didn't see her. So. Court calls the case People versus Brian Cox.
Special one for the people. Public Defender Natalie Pate on behalf, but unfortunately not with Mr. Cox.
Mr. Player, on behalf of probation, Your Honor, today's court hearing was set for a review hearing for Mr. Cox. Mr. Cox was compliant with the terms ordered by this court, excepting he did pick up a new criminal case. Given that that case is a felony, I know he is not in custody there any longer and that he is not here. Probation's asking for him.
Yes, go ahead.
Your Honor, the record, we respectfully request an adjournment. However, our office was not successful in getting into contact with Mr. Cox prior to today.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. I'll give a 10% privilege. That warrant will issue immediately.
Bench warrant. You should show up for court.
Court calls the case. People versus Robert Anderson.
People, this is a public defender Natalie Tate on behalf of Mr. Anderson, whose appearance has been waived. Attorney Clara on behalf of probation, Your Honor, Mr. Anderson was scheduled for court for his hearing. He's compliant with the terms ordered by this court, and I did waive his appearance. Probation is recommending that all conditions continue, with the next review hearing being set October 7th, 2024 at 1 p.m. No objection, Your Honor.
So ordered. Court does call the case of the People versus Timothy Riley.
It's Clara on behalf of probation. Your Honor, Mr. Riley is compliant with the terms ordered by this court. Probation is recommending that all conditions continue, with the next review hearing being set November 4th, 2024 at 1.
So ordered. Court does call the case of People versus Benjamin Simon.
People, this is public defender Natalie Tate on behalf of Mr. Simon, who is here to resolve this.
On behalf of probation, Your Honor, Mr. Simon was scheduled before the court for a review hearing. He is compliant with the terms ordered by the court. Probation is recommending that all conditions continue, with the next review hearing being set November 4th, 2024.
No objection.
So ordered. Court calls the case People versus Vishay Dandamoody.
Absolutely, for the people.
Here's a Clara on behalf of probation. Your Honor, Mr. Dandamoody was scheduled before the court for a review hearing. He is compliant with the terms ordered by this court. The court is already aware of that other case that was that's pending and is at circuit court. I did waive Mr. Dandamoody's appearance from attending today, given that he's compliant with all other terms. Probation is recommending that all conditions continue, with the next review hearing being set October 7th, 2024 at 1 p.m.
How long does it take to grow your hair out to your waist? Is that a few years?
Let's call the case of the People versus Zia Combs.
Mr. Combs was scheduled before the court for a review hearing. He is compliant with all terms ordered by the court, and I did waive his appearance. Probation is recommending that all conditions continue, with the next review hearing being set November 4th, 2024 at 1 p.m.
Hearing no objection, that is ordered. Court does call the case People versus Marcus Jackson.
Absolutely, for the people.
Clara on behalf of probation. Your Honor, Mr. Jackson was scheduled before the court for a review hearing. He is compliant with the terms of the court, and I did waive his appearance. Probation is recommending that all conditions continue, with the next review hearing being set November 4th, 2024 at 1.
Hearing no objection, so ordered.
These are people who are complying with their
That's all for
restrictions. Don't even have to show up to court. They're just checking in. Looks like the judge is done right there. He shut off his stream. I wonder when Jones will come back, maybe during the next block. Let's see. Who do we have on 3? What's this? Oh, we're back up in Washington, Thurston County. Travis Joyce looks like he's playing, what is that? Halo? Oh, we've seen Attorney Hickok before. Christopher Wagner. At least his iPhone's here. I think Richard Peters needs glasses. He's squinting at us. Call of Duty, that's it.
I'm not sure if he knows how to get out of the breakout room, Your Honor.
He's stuck in the breakout room.
I'm not sure if the clerk is able to maybe close the breakout room. I was able to talk to him. There he is.
All right.
And Your Honor, after speaking with my client, we don't have any objection to the imposition of a no contact order at this time.
Okay, thank you. All right, I gave you the court date and I'll sign that new protection order, and that will be available to you through Ms. Hickok as well, Mr. Miranda, and we'll see you back on that court date for all three matters.
Yes.
And let's have strict compliance with those orders. I don't want to have any further issues.
Yes, Your Honor.
Okay, thanks. You're done for today.
Thank you, sir.
Thank you, Your Honor. Mr. Miranda, I'll be sending you those documents, okay?
Yes, ma'am.
Was that a scam device on his wrist?
Hold on, before you go, it looks like we also had an issue, Ms. Hickok. We'll need to get an affidavit of non-surrender on firearms order.
Oh, yes, I'll have my office submit that today.
Okay, thank you.
Thank you.
Yep. And are you getting that figured out there, Heidi?
Is that a scram or is that like a go-go gadget watch? Can somebody tell me? Mr. Hector, what does he have on his wrist there?
May I be excused, Your Honor?
Yes, you may. Thank you. Hey, Heidi, just make a note on your docket and let's deal with this after we finish the calendar. So we'll put all that together. Yeah, Mr. McClellan, have you sent in the order yet?
Not quite yet. Almost done with it. And it'll be in the 11 o'clock folder just with the other. I know it wasn't the cause number on the calendar, but that's where I'll put it.
Okay, thank you. All right, so yeah, okay. All right, let's try Krista Alvik on the 11 o'clock calendar. And Mr. White. Were we expecting Mr. White, Mr. McClellan?
That's who I was anticipating, yes. But I haven't heard from him yet.
All right. Let's try Cheyenne Anderson.
I'm here, Your Honor.
All right, Ms. Anderson's here. And Mr. Canine, are you standing in for Mr. Andrews?
Is that a dartboard behind her?
You're muted.
Who's behind me? Oh, I have to move.
Yes, Your Honor, I am in here for attorney record Nick
And
Andrews.
wander up in the other corner.
All right, thank you very much. Ms. Anderson, good morning.
Good morning, Your Honor.
And Mr. Canine, are you a Rule 9? Is that right?
Yes, Your Honor.
All right, and your Rule 9 number?
1 moment. Nine 9905523.
Thank you very much. Are you heading into third year?
Yes, I am, Your Honor.
Where?
So he's practicing.
I'll be finishing my third year at Seattle University.
Okay. All right. You're this close.
That's right.
All that's left is the bar exam.
The easy part, right?
Yeah, right. All right. So we're here on Ms. Anderson's case, and Ms. Anderson currently has a confirmation set for the 19th of August. Would Mr. Andrews just like to keep that date?
We would, Your Honor. That's correct. We're working towards a resolution here.
All right. Thank you. Ms. Anderson, you're aware of that?
Yes, Your Honor.
Okay. And you're receiving text reminders of your hearings?
I am not, Your Honor.
Okay. If you give us your cell phone number, then you will.
Do you want me to put that in the chat, Your Honor?
You can do that, or you can just tell me right now.
33.
867-5309. That's 867-5309.
Okay, thank you. And where's 336?
North Carolina, Your Honor.
Okay, is that where you are?
No, I'm in Washington.
Okay. All right. We'll see you next.
Did you say North Carolina?
On the 19th of August at 11 o'clock in the morning. And we will also start sending you text reminders of those.
Thank you.
You're welcome. Thank you, Mr. Canine.
Thank you, Your Honor. That's the only matter today. Have a great week.
You too have good luck in your third year.
Thank you.
Good luck.
Yep.
Good luck, says the judge. You're going to need it. Where do we go next? Call of Duty or Mr. Wagner?
Jarrell Bond. Bond, have a seat. Is that how you say it?
Oh, he's local. He's in the building. Who's your lawyer? Is that Chris Langley?
All right. I see back on the 31st of May, it was indicated you were going to hire private counsel and you walk in here by yourself today. So what's going on there?
I talked to my court appointed and told him that I was possibly getting a different attorney, but I decided not to. I tried to call him multiple times and I got no call back.
Okay.
That's
all right. So are you working?
Want him anymore?
Trying to.
So you're currently not working?
Not actively.
Okay. How do you support yourself financially?
I do have some money saved up.
Give me some idea. Is it $1 million? Is it $100?
Only like 8,000.
Okay. And that's what you're living off of right now?
Yes.
Okay.
Just
And
until this 3 months is up, and then
when you work, what do you do?
construction.
Okay. And are you looking for work?
Yes, Your Honor.
Okay.
Court-appointed attorney.
And so you're asking to have court-appointed counsel?
Yes, Your Honor.
Yeah, I'm not in 336.
Oh, never mind. I found one.
There are a couple states
Right.
where you can be an
I
attorney
will
without going
appoint
to law
Ms.
school.
Langley to represent you. She's been on the calendar today. I don't know how long you've been in here. So with the appointment of counsel, we're restarting speedy trial for you in this matter. So your 90-day period for speedy trial starts today. The conditions previously imposed by Judge Wilcox still apply, and I'll set a new court date for you with Ms. Langley.
They let him get speedy counsel, or let him get to court appointed even with the 8,000 in the bank, because he doesn't have a job right now.
Have their calendars. Can you look at a calendar and tell me? Okay. You're coming back on the 19th of August at 9:30 in the morning.
If he was working, I had 8K in the bank.
And you can appear in court or remote. That'll be your choice. And we're going to give you a document that has that information on it. Did you receive text reminder of your hearing?
No.
Okay, if you give us your cell number, you will.
360.
867-5309. That's 360. 867-5309. What is that on the ceiling in Christopher Wagner's?
Okay, we're going to print something up for you before you go, and you'll walk out. It has that new court date on it.
Thank you so
And you also need to give them the contact information for Ms. Langley. And we'll give you a sheet of paper that tells you how to get in touch with Ms. Langley. So don't make her track you down. You reach out to her.
Travis is just mad because his group's going on a quest without him. He's missing the raid.
All right, Ms. Bond, come on up. Yep. Justin Cruz.
That matter's ready. Good morning, Your Honor.
Thank you. Mr. Dichter, good morning.
Good morning. Nice to see you. I did see Mr. Cruz. There he is.
All right, Mr. Cruz, good morning.
Oh, you're muted, Justin. We got to have you unmute.
Hi, good morning, Your Honor.
There we go.
Hi,
And Mr.
Jonathan.
Dichter, I don't see any resolution today. I do see that we have a court date on the 26th of August. Are we just keeping that date?
Your Honor, Mr. McClellan and one of my associates, Mr. Wong, have been working really hard on this. It sounds like they're getting close to a resolution. I guess, would the state prefer a new pretrial, or do you want to just leave it to August? What do you think?
Well, it's the city, and
I'm sorry, the city. Pardon me. I apologize, Your Honor. Old habits.
Yeah. So the way we do this is we try to limit the number of pretrials. So we'll just keep the confirmation of the 26th of August.
That's
and
fine.
Matter can be resolved on that date.
Let me just double check that date and make sure I don't have any issues on my calendar. August 26th. What time is that, Your Honor?
11 o'clock.
We can make that work, Your Honor. No problem.
All right. And Mr. Cruz, are you receiving text reminders of your hearings?
I am, yes.
Okay, excellent. And we'll see you on the 26th of August at 11 o'clock in the morning.
Great. Thank you very much, Your Honor. Mr. McClellan, nice
All
to
right.
see you. Justin, I'll send you an email here shortly. Oh, actually, Your Honor, before we leave,
Yes.
Mr. Cruz was wondering, given the length of time the case has been pending with no violations of any conditions of release, if the court might consider exonerating his bail at this time. He's appeared at all court appearances. He's been in good contact with counsel, etc.
All right. I will exonerate the bail posted by Mr. Cruz.
Great. Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you.
All right.
You're
Take
welcome.
care.
Bye-bye.
Frees up a bit of cash.
Mia Hirata.
Good morning, Your Honor. Thomas Murphy, appearing on behalf of Mia Hirata.
Mr. Murphy, good morning.
Where's Mia?
And let's see, and Ms. Hirata is not with us this morning, is that correct?
That's correct, Your Honor. She's appearing through counsel.
All right, thank you. Looks like next court date is the 26th at 11, so we'll see you or Ms. Farina. I suspect one of the two of you at 11 on the 26th.
I assume Ms. Farina, she's in trial today, but I assume she'll be here on the 26th.
All right, thank you very much.
Travis is a thirsty man. Are those Turtle Beach heads? Is that a Turtle Beach headset?
And Travis Joyce.
Here we go. Travis, you're up.
Mr. Leone.
Good morning, Your
I hope
Honor.
when he
A little bit under
unmutes, the
weather.
earphones glow.
This comes
Yeah, you
on
sound
for
great.
this comes on for pretrial, and we have emailed Madam Clerk another a second speed trial waiver in this case. We're asking for another pretrial date to have more time to work on
the
this
wall
with the city.
behind him.
Okay, I think what we'll do is we'll just keep the date we currently have right now for confirmation, which is the 23rd of September. So, that's out 2 months. That should be sufficient.
Plenty of time.
Yep, get this resolved. So we'll just leave it currently set for the 23rd of September at 11 o'clock and see you then.
Thank you very much, Your Honor.
And feel better.
Thank you.
Yep.
Their trident's mounted to a deer head. Looks crazy.
Carlos Mullen.
I'm also here on that matter, Your Honor.
Mr. Murphy.
Yes,
Good
sir.
morning
Mr.
again.
Mullen.
And we're here for confirmation of trial. And what are we doing today, Mr. Murphy?
Mr. Mullen is appearing through counsel, and we were just asking for a continuance today, maybe like 30, 45 days. I know Mr. Mullen is currently finishing up treatment, working on that, so.
Okay, are you expecting a resolution in this matter?
I believe so, Your Honor.
Okay, so since we are here for confirmation, if we want to continue it, we'll need a waiver of speedy trial filed. Will your office get that into us today?
I believe it was filed this morning, Your Honor.
Okay. With the understanding that we have a waiver of speedy trial, Mr. McClellan, any objection to striking the trial date set for the 24th?
Not with the waiver, Your Honor. Thank you.
Okay. We will strike the trial date, and I'll give you a new court date here in just a moment, Mr. Murphy. And Mr. Murphy, is it realistic to have the issues resolved by the confirmation date of August 19th?
I think that's fair, Your Honor.
Okay. So we'll make that the confirmation date with a trial date on the 28th of August, if not resolved on the 19th. All right.
Thank you, Your Honor.
Yep. Thank you very much, Mr. Murphy. And for those in the courtroom for whom Ms. Langley is your attorney, if you haven't spoken with her.
She said she was going to call me next week.
Okay, well, so Ms. Murphy or Ms. Langley, do you need to speak to some of these folks so you're ready when we finish the private counsel cases?
So some of them are ready, and then I need to speak to, I think, Ms. Geiger, and I need to speak to Mr. Wagner.
Okay, are either one of you in court?
And Mr. Smith.
Mr. Smith.
Okay,
I've spoken to Mr. Smith. We
well,
can
we have
proceed.
two Mr. Smiths.
Okay, I've spoken to Mr. Thomas Smith.
Trent Smith. We haven't spoke today yet about Ms. Langley.
Okay, the two of you will be in a breakout room, and while we're still working on some of these other cases.
Thanks, Your Honor.
Can we call
You're
Thomas? It's pretty quick, and he needs to get to work.
And do that in just a moment. Let me finish the
thank you.
JNS on this case.
Thank you.
Yep. Right on the Mullen matter, confirmation on 19th of August at 11 o'clock, trial 28th of August at 9 o'clock, if not resolved on the 19th. Thank you, Mr. Murphy, if he's still here. Thomas Murphy, come on up. Or Thomas Smith, rather.
Is it Trent Smith?
Nope. Thomas Smith.
Sorry.
That's okay. Go ahead and have a seat. Let's see. This is on the 9 o'clock calendar.
I want to see what Mr. Wagner's up to. He's not here. Is he? Or is he in the courtroom?
So we're running speedy trial through the 4th of September. We'll set confirmation trial dates for Mr. Smith. I'm assuming that's what you wanted to have happen, Ms. Langley?
Yes, and the city also has a motion, I believe, here to amend the complaint alleging domestic violence. And no objection.
Okay. All right, Mr. McClellan.
That's correct, Your Honor. I think in the initial arraignment, there may have been a question of whether it met the requirements for domestic violence. There was a supplemental report that established a relationship sufficient for domestic violence. I don't know if there's sounds like no objection to that. The only thing the city is asking that wasn't previously requested was for a domestic violence no contact order, given that information and the city's contact with the alleged victim does have safety concerns and supports an order. So I did in the judge's folder prepare a no contact order, and the city would be asking the court to prepare that today.
All right, thank you, Ms. Langley.
I don't believe they reside together. I don't think I'd have any objection at this point, with the ability to readdress it after like getting some more details from him.
All right, thank you. You need to get to work?
Yeah.
Okay. Next court date is the 19th of August at 9:30. And are you receiving text reminders of hearings?
No.
Give us your cell number.
Okay. Her.
Yeah, go ahead.
It is
867-5309.
$564.
Oops. 867-5309. There's the rest of it. All right. high speed chase in Charlotte right now. Where are you seeing that? Where's the video coming through?
I'm
Yes.
signing a no contact order as to Ms.
Someone's
Ratty.
vacuuming. I'm
Is
trying
that
to
her
figure
name?
out what they're doing. They might just be playing with the vacuum.
Okay. A Lisa Leanne Ratty, you're to have no contact with her and not to go within 1,000 feet of her residence or workplace or where she is. And we'll give you a copy of that order. And then as to the other matters, I have signed an order resetting the court date.
Okay.
And that'll be in August, and we'll give you a copy of that.
Okay.
So you have it when you walk out right now. And then we'll also text you reminders of it. And your key is to stay in good communication with Ms. Langley.
Okay.
Okay. If it's not resolved at your next court date, you'll be going to trial the following week.
Okay.
Okay. So you can come on up here and pick that up and you'll be free to go.
Thank you.
You're welcome.
They're almost done vacuuming. I've been trying to mute it as much as I can, but see.
What's the name?
Lavalley, Shannon.
Yep. Yep.
I could listen to see Charlotte. Let's see. I think we might have a police scanner in Charlotte.
You're all set. Yep. Yep. It's Miss Langley.
United States, North Carolina. What county is Charlotte in?
360
Yep.
458 9272.
Oh man. Sorry. Is that? I think that's might be the court's number.
And
Just disregard that one.
Okay. In the meantime, is Miss Will in the courtroom? We might be able to address that.
She's not here. And your name in the back?
Yes, I am.
Yes, I am.
Oh, is she on Zoom?
I'm on Zoom.
Looks like
Okay.
we can address Miss Will.
Okay, hold on just a second. And your name in the back? Okay.
Hello. Okay.
And Mr. Barbero is present as well. Okay, so she knows now, so sit tight. All right. So Marie Will,
Yes.
good morning.
Good morning, Your Honor.
And Ms. Will, looks like you're due back here on the 5th of August. Are you aware of that?
I am now.
I am now.
So you're not receiving text reminders?
I do have text reminders, but it had only reminded me of today's date.
Right, yeah, it won't. We send it out, I think, 3 weeks prior, then a week prior and a day prior, something like that.
Okay.
So we'll see you on the 5th of August at 9:30 in the morning. And if it's not resolved on that date, you're then going to trial on the 14th of August. So the key will be for you to stay in good communication with Ms. Langley.
And she has been, so.
Okay.
Okay. All right. Thank you, Ms. Will.
Thank
Richard
you, Your Honor. Have a
Peters.
good day.
You too. Bye-bye.
Good morning, Your Honor. For the record, Nodder Nor present via Zoom with Mr. Peters, who's also present via Zoom.
Yes, Mr. Nora, good morning.
There's Richard.
And Mr. Peters matter.
Marie's frozen, and they did her dirty on the pause game, too.
See, we have confirmation on the 5th of August. Is that what we're doing?
Still here.
That's correct, Your Honor. I think I might need a little bit more time to resolve this matter with the city. But if Mr. McCallum's okay with it, I'm happy to leave it as is for now if we try to work something out rather than setting extra retrial hearings.
Appreciate that. We'll leave it for the 5th of August at 11 o'clock in the morning. And did you say Mr. Peters is present?
Yes, Your Honor. Mr. Peters.
Oh, there we go. I
He's
see
been
him.
here for like
Okay.
2 hours.
And Mr. Peters, are you receiving text reminders of your hearings?
No, I'm.
Oh, and would you like to?
Yes.
And your cell phone number?
31.
867-5309.
Thank you very much. And we will see you next on the 5th of August at 11 o'clock in the morning with Mr. Nur. If it's not resolved on that date, the trial date is currently the 14th of August. You and Mr. Nur will let us know whether that's realistic or we'll need to continue that date.
Of course, Your Honor.
Okay. Thank you, Mr. Peters. You're all done.
Thank you, Your Honor.
Thank you. Thank you, Mr. Nur. You too. And George Wagner.
Christopher George.
Mr. Murphy.
Morning again, Your Honor.
Good morning. And
Mr.
here
Wagner is appearing through counsel today.
Right. And are we doing a speedy trial waiver on that or confirming for trial?
We have submitted a speedy trial waiver, but I believe that we will be able to dispo at the next hearing. So we can just set that out.
Okay. Mr. Wagner, good morning.
Mr. Wagner. Come in, Mr. Wagner. It's one thing to appear on Zoom, but you also have to be present.
All right, Mr. Wagner. Looks like you're muted. There we go. Okay. Now we got you. Are you receiving text reminders of your hearings?
Yeah, yes, I am, Your Honor.
Your Honor,
Okay.
Your Honor, this is for George Wagner, correct?
It's for George Wagner.
Yeah, that's not George Wagner.
Oh, wrong Wagner. Okay.
Mr. Wagner is appearing through counsel today, Your Honor.
Okay. All righty. Thank you.
You said George, but I thought Christopher's close enough.
19 August at 11 o'clock for confirmation with trial on the 28th if not resolved.
Sounds great. Thank you, Your Honor.
You're welcome.
So many
Thank you,
people with
Mr.
the
Murphy,
same
for
name.
standing in today.
This Langley's working the phones like crazy. Home office is really showing its usefulness right here. Jenny's going to get all the court notifications.
All right. As soon as we have Ms. Langley's attention, we can start working through her clients.
Let's just raise your hand, Judge, and wave at her.
And actually, while we're waiting, Mr. McClellan, Krista Alvick, have we heard any more?
Yes, Mr. White is planning on hearing. His intention is to file a waiver with a request to continue, but he said he's tied up in Grays Harbor. So he was inquiring about our status, and it's on for confirmation. So I noted, I think he needs to appear because he asked about if we could enter the agreement.
Okay, we'll hold off and see if he appears. All right, Ms. Langley, you're on deck when you're ready.
Okay, let me see who we have.
She hung up on whoever it was.
Doing what I can. Is Mr. Barbaro there?
He is. Come on up,
Okay,
Mr.
ready.
Barbaro. Is it Barbaro?
Barbaro.
Is that how you say it?
Barbaro.
Okay, go ahead and have a seat.
Thank you.
You're welcome.
Good morning.
Good morning. And
Jen Del Rio, did I welcome you? Welcome. Welcome to the channel. Thanks for becoming a member. Welcome to the gallery. Help yourself to reserved seating and all the emojis.
This shows as a pretrial, and it shows that we don't have a confirmation date. So Ms. Langley, what was the desire here?
I think let's set a trial date on the, just trying to coordinate them. Let's set a trial date on the, why don't we? Oh, I see why. Yeah, let's set, maybe we can set a trial date on the earlier charge, which was the they're charging in 5434, and maybe set a pretrial along with the confirmation on that in hopes of resolution at that date.
Okay, thank you. There's no basis. I haven't even looked at the charge. It looks like it's a driving suspended on one and both. Okay. So they won't be joined, but we'll set the same confirmation date with separate trial dates.
Mrs. R.A. is cleaning right now, and she keeps bringing me things. She's like, I found this. This is yours. Look.
And Mr. Barbero, are you receiving text reminders?
Apple Watch.
Yes, sir, I am.
Okay, very good.
Haven't seen that in months. Judge Dwayne is in the house. Ooh, Travis is here. Hello, Travis. Looks like he's in a vehicle with a very low roof, or maybe he's a very tall man. Like his head is in contact with the ceiling.
All right. So on the older one, speedy trial expires on the 1st of August. So I suspect that's not what you had in mind, Ms. Langley.
I guess I'll defer to my client if he, I don't know why he would.
And do you want to continue your trial?
Yes, sir.
Okay. All right, Ms. Langley, will you get us a speedy trial waiver today for Mr. Barbero?
Yes.
Travis has a lot of junk in his
we're going to
trunk.
get a waiver. Mr. Clone, did he have any objection to striking the current trial date set for next week?
No, Your Honor.
All right. And Ms. Langley, you'll add both case numbers to that speedy trial waiver?
Yes.
Okay, thank you. Okay, new court date will be 19 August for confirmation and 28 August for trial.
My kid just sneezed, like EL sneezed.
Both cases will have the same confirmation date, and then
you probably heard that.
It'll be the 28th, and then I think the 4th of September.
We're getting seasick watching Christopher rock in the rocking chair.
And we're going to give you these documents here, so when you walk out, you'll have all that information.
Yes, sir. Thank you.
Sure. And are you receiving text reminders?
Yes, sir.
Okay, good.
It's a great idea.
All of us communicate by text these days. That's the most dependable way we communicate.
Yes, sir.
So
it helps, believe me. It does.
good. Yeah, that's the whole point there. Try to make it useful for folks.
It works.
Good.
We gave them a day off. Are we missing stuff that we should be catching? Trying to understand where Travis is seated, because the row behind him looks awfully close. Like, I don't think he's in the front seat, but he's also not sort of on that seat. I do think he's actually in the car. I mean, I've seen people use like the seats from a car.
Just for counsel's information, since both have speedy trial waiver, I noticed that I assigned the older case the later trial date. So don't come in on the first trial date expecting the older case, the newer case, or the older case, because that's the second one set. So anyway, just look at the numbers on the dates. The newer one goes first, the older one goes second, since they'll both have the same speedy trial time. You can come on.
Braxton, you're right. There is somebody on a pillow next to him there. We see
you too. Yep.
We see a forehead and a little bit of an eyebrow in Travis's picture.
Oh, let's see. Why don't we call Miss Geiger?
All right, Miss Geiger. Geiger. Renee Geiger.
Yes, I'm present.
Can you turn your camera on?
Hello.
Hi.
All right, and do you have video capability there?
One second. I'm just getting somewhere private. I'm sorry, what was that?
So do you have video capability?
Yes, I do.
That was sort of like a hint. You should probably turn it on.
All right, thank you. And the name is Geiger.
Yes.
Okay, want to make sure we have that right.
Her name is Geiger.
And Ms. Langley, we're keeping the date of 19 August.
Yes, and I need to make sure I have a good phone number for her. I don't
two
think
last
the one I
names.
have works.
All right, Ms. Geiger, your cell phone number?
360.
867-5309.
Thank you.
All right, we'll see you on the 19th of August at 9 o'clock in the morning.
We'll see both of you.
If it's not resolved on that date, you're coming back to trial on the 28th of August.
All right.
Okay, you're all done. Thank
I
you.
imagine
Bye-bye.
she's going to grow up and be
Thank
a
you.
lawyer, and her law firm will be Geiger and Geiger. It'll just be her.
Okay, why don't we call Trent Smith?
All right, Trent Smith.
Trent, oh, I need to.
Mr. Smith, good morning.
Sorry.
Morning.
And
Trent's rocking the headband. What does that say?
we had arraignment on the 6th of June after a prior missed hearing. So it looks like we're running speedy trial through the 4th of June, or pardon me, 4th of September. Ms. Langley, we're just doing a set today.
Let's just do a set, and I want to make sure I have a good phone number for you.
Oh, it's
All
not
right,
words.
Mr. Smith, your cell phone number, please.
253.
867-5309.
Thank you. And I'll give you a court date here in just a
Getting
moment.
better at this. More gifts from Mrs. R.A. This happens to be a radio-controlled.
That court date
power
will
switch.
be the 26th of August for confirmation and the 4th of September for potential trial. So if not resolved on the 26th of August, you'll be going to trial the following week. So the key is to stay in good touch with Ms. Langley.
For sure.
All right?
All right, thank you,
Okay.
sir.
You're all done.
All right, thanks.
Yep, bye-bye.
Bye-bye. Love you. Trent's son, I think he was sitting on his roof.
Who's
that
left?
was on his deck.
I'm going to need to speak quickly with Mr. Wagner and with Mr. Gackey.
And Ms. LaValle's in the courtroom. Don't forget that.
Oh, we can address that.
Okay. Ms. LaValle, right up here at the table.
Oh, it's more than a hint. It's more than a hint. If I don't take, Tyler's here as well.
Ms. Langley.
Mr.
So
Martin
let's just set dates in this matter.
and
Your
his
Honor.
beard are both present.
All right, thank you.
LMR.
No, Mr. Martin as well as.
He can hear you, Miss Langley. Will Travis wake up? Oh, Travis is awake. He is in upright position, well as upright as his car will allow. Mr. Wagner's ready to get some sleep, I think.
All right, speedy trial runs to the 5th of September for Ms. LaValle, so we'll be back here on the 26th of August with trial set for 4 September, and we'll give you a copy of that document that says that.
Miss Langley needs a breakout room with 2 of the remaining witnesses.
And Ms. LaValle, do you receive text reminders? Okay. So stay in good touch with Ms. Langley. We'll give you a copy here in a moment. And then if not resolved on the 26th, then you'll come back to court the following week for trial. Thank you. Yeah.
Someone was whispering, thank you. Christopher just revealed that it is, in fact, No Pants Friday. And he's going with the green boxers today, which is a bold choice.
And thank you for your patience this morning.
Bold choice. Thanks for sharing, my friend. Christopher's in no state for a foot
and
race.
Thank your friend for her patience this morning. Ms. Langley.
Thank you. I need to still speak to the people at Mr. Wagner and Mr. Gacky. And Mr. Tyler Martin is here too.
And do you need to speak to him as well?
Let me see.
Which case is he on? I don't know.
Yeah, he's not on our calendar.
Yeah, I don't know why he's here.
Okay, how about Mr. Franklin?
Mr. Franklin.
Anthony Franklin. Mr. Franklin, good morning.
There's Tyler.
Good morning.
Okay, we're here for confirmation on Mr. Franklin.
Mr. Franklin has half the facial hair.
10 o'clock.
Of, who was it? Not Travis, but the other guy.
Trial set next week. You going to do a waiver today, Ms. Langley?
Mr. Franklin, you want to let's take more time and keep working on this?
When would my next court date be?
Your next court date would be the 26th of August.
I'm just going to go out on a limb and say this is going to be a drug or alcohol
Yeah,
case.
that's fine.
Okay.
For Mr. Franklin.
All right, with the waiver filed today, you're coming back to court on the 26th of August at 9:30 in the morning with a trial, if not resolved on the 26th of August, a trial on the 4th of September. And so we won't reset this since it's been reset already. So this will be the last time. So 26 August and 4 September, stay in good communication with Ms. Langley, okay?
Can I get your number real quick, Miss Langley?
Sure. It's 360 58
867 530. Wait, I'm not ready. He's like, wait, I'm not ready.
All right, go ahead.
60
867 5309.
Thank you.
All right, you're all done.
Thanks, Your Honor.
Yep. And Mr. Martin, why'd you think you were here?
Because he is here. Mr. Martin and his beard showed up.
I got a text reminder this morning for this time for this courtroom.
There you go. He signed up for your text reminders.
What kind of case do you have?
I had one of two. I wasn't sure which one exactly. So I brought all my paperwork because I wasn't sure. I just got a text yesterday and I was like, oh, crap. Okay.
What's the, I'm going to guess that there's a issue here. So give me the case number.
I don't, that's the one thing I am missing. I don't have my case number for Thurston County right now. I have my date of birth, my last
Yeah.
name, if that helps.
That will. Go ahead.
0.
We're not going to get that either because, you know, privacy. He knows his birthday. He passed the first test.
Bro, stop.
Bro, stop. Stop it. I'm on with the judge. You're going to get me in trouble, man. Stop it. Don't blow the smoke this direction. They're going to see it.
You have an address on that file. It's verified.
I do it intentionally, Krista. Sorry.
Okay. You live on 400 Wynwood?
Yes, Your Honor.
Okay. So I think the next court date we see is the 9th of September. Is that what you saw?
Judge Granville
The 9th of
has
September
been recused
at
from the
10
Young
o'clock
Thug
in the
trial.
morning.
That
Thank
just
you, Your Honor.
breaking
And
right now.
That's on the DUI.
Thugger Daily broke.
Thank you. I appreciate that.
And that comes through Amber
Okay,
Clipson
you're all done.
Victon.
Thank you.
Vixen. He's been recused.
All right. And so you
He's
need to speak
off
to Mr.
the
Wagner and
case.
Mr. Gacky?
Yes.
Okay.
Holy cow.
We'll put you in the breakout rooms. And we'll deal with our other folks. I see Ms. Alvik is here. I don't see Mr. White.
So yeah, last I heard he said he'd be here in a few minutes. So he's planning on it. I did forward to the clerk what he sent me as far as a waiver.
Okay. All right, we'll go back to the top of the calendar. Connor Brown here for preliminary failure to comply.
Okay, we've got a document we need to go over really quickly. It's the order to get rid of Judge Granville. Sorry, I just unceremoniously dumped us out of court. Yes, that was me. Sorry. Let's see, where am I at? This one. Guess what? Court hopping.
No proof of
is
evaluation
on
or
hold.
treatment, it looks like.
Let's turn that one off for just a second. Because we have this latest breaking news from the Young Thug trial. Let me run down to my regular spot. Where's regular? I forget where that is. How about right down here? There we go. Let's zoom out just a teensy bit. Not that much. Go to continuous scroll. All right. Big breaking news here. There's a contempt charge there. Let's check and see what we got. Judge Granville with it. No, not mine. Miss Sorry has more stuff. Orders on motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including defendant DeMonte Kendrick's motion to recuse Chief Judge Earl Glanville, filed on June 12th. I keep adding an R to his name. Caleb Bumpus' motion to quash the show cause order and or to recuse Judge Glanville, and defendant Jeffrey Williams' motion to disqualify and recuse Judge Glanville from all further dealings in the above referenced case and amended supplement. So 3 people asked for this to happen. Looks like they got their wish. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follows. Let's see, the asterisk was about the defendant Jeffries. Yes, those are mine. They just arrived today. Woot, multicolored. Another package. Woot, woot. Cable organizers, guys. I'm getting organized. Let's see. Findings of fact. These recusal motions arise out of multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th. The motions to recuse all arise from the same circumstances related to the state's witness, Kenneth Copeland. On June 7th, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that, if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury, then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated that he would revisit the issue with Copeland on Monday at 8:30 a.m., and the court was adjourned for the day. On the 10th, which was Monday, at approximately 9:10 a.m., Judge Glanville met with the counsel for the state, Adrian Love, and standing counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. The transcript reflects that Miss Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risks of refusing to testify and allow Mr. Copeland to ask questions before he testified. Miss Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Miss Bumpus, Miss Love, and Judge Glanville also discussed the scope and effect of the state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Miss Bumpus, Judge Glanville, and Simone Hilton, the counsel for the state who had been joined the meeting. During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all the defendants in the case, not just the 6 currently on trial. Judge Glanville discussed the law with Mr. Copeland, or the rule of law, the rules, with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke Mr. Copeland spoke privately with his standing counsel, Miss Bumpus, and then advised the court that he would testify. After the meeting, and immediately before Mr. Copeland was brought out to testify, Defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt, though Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams. Ultimately, Kenneth Copeland did testify on June 10th and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered, setting July 1st for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse followed, filed by DeMonte Kendrick on June 12th. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 14th, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on cursory review contains assertions of fact to support the allegation of bias and impartiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, there was no actual evidence of the extent of the discussion during the in-chambers meeting. The affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. On June 14th, Kayla Bumpus then filed a motion to quash the show cause order and to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus, resulting from alleged disclosure of the ex parte meeting. On June 17th, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from its hyperbole, Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Let's see. There's technical changes to how things were actually filed, but it doesn't cause any differences. Let's see. Mr. Williams' motion alleges that both actual and bias and both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. On July 1st, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. Judge Glanville advised that he had not instigated investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper and under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendant's right to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with the rule. The motions to recuse were then assigned to this court for consideration. So the legal framework is motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and reasons for the belief that bias or prejudice exists. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of any adverse party or prejudice toward the moving party in particular, or a systemic pattern of prejudicial conduct toward persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. Bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and the alleged facts. If all three criteria are met, i.e. the motion is timely, supported by an affidavit, and the facts alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned. The standard is objective, from the perspective of a reasonable, fair-minded, and impartial person rather than the affected judge or other interested parties. If a motion to recuse satisfies the three threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for a recusal. A judge has no interest in sitting on a particular case. Oops. I dropped my toy. I had to pick it up again. At most, his interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy which persists after the motion to recuse is denied. So it might make him an enemy just by fighting against the motion, which he did. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that recusal might be authorized if the facts alleged in the motion were true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions and argued why those actions were proper. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, so that the judge is not possibly perceived as a hostile witness or advocate. In presenting his record to the recusal issues and in ruling on Kendrick's motion, Judge Glanville elevated and accepted the truth of his own factual allegations, mandating his recusal. This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. Based on the foregoing, the court hereby orders as follows. Defendant DeMonte Kendrick's motion to recuse Chief Judge Ural Glanville is granted. Caleb Bumpus' motion to quash the show cause order and or to recuse Judge Glanville is denied as moot. Defendant Jeffrey Williams' motion to disqualify and recuse Judge Glanville and from all further dealings in the above referenced case as amended and supplemented is granted. The clerk of court shall reassign this case using the court's case assignment procedures. It's so ordered this 15th day of July. Signed, the Honorable Rachel Krause. And like that, we have a new judge in the Young Thug case. The key parts I'm pulling out of this is that this judge, Judge Krause, who filled out this, who made the decision to recuse Judge Glanville, agreed on the ex parte meeting. Said nothing happened there. What that means is there will be no mistrial. There will be no dismissal of the case. That she says the problem happened when Judge Glanville argued against his own recusal. That was the issue. All right, what do we have here? Where were we on, I think we were watching something else. I think we were on Thurston County somewhere. Let's see, okay, we want to go back to him. Let's see what we have.
He's in a place where he has zero headroom.
Yeah.
Oh, yes.
And it looks very uncomfortable. Okay. So we'll just leave the trial date set for the 24th. So that's a week from Wednesday. And if the matter's not going to go to trial, if it's going to be resolved on the 24th, just let us know so we can strike the jury.
Okay.
So Mr. Gackey, we'll see you on the 24th at 9 o'clock in the morning. And that's in courtroom 4. It's not in this same courtroom. So if you're logging in by Zoom, you have to log into courtroom 4. If you're going to appear in person, it's in courtroom 4, which is not in the courthouse building. It's about a quarter mile away from here. Okay.
He gave a thumbs
All right.
up.
We'll see Mr. Gackey on Wednesday, the 24th of July. Thank you.
24th of July.
And Ms. Langley, I believe that concludes your cases.
Oh.
What about Christopher Wagner?
Thank you, Your Honor.
Right, way to hang in there this morning. And Ms. Alvik, good morning. And we received a waiver. Okay, we received a waiver, and
the Young Thug case is going to continue where it left off.
Set new court
with
dates
a new judge.
For Ms. Alvik.
I'm not sure what happened to Christopher.
And was there any discussion of time period with Mr. White?
Miss Alvik's back. She has her headphones in. She can hear us now.
No, not specific in our correspondence.
Okay. Ms. Alvik, good morning. Can you hear us? Okay, so that's a yes. You're not logged in audio-wise, apparently. You might try to unplug your earbuds and see if you have the computer logged in otherwise.
Mr. White's joining.
Okay, apparently Mr. White's now joining us. All right, Mr. White, you are requesting a continuance on the trial for Ms. Alvik?
Yes, Your Honor, we are expecting that this case will probably resolve. We're just gathering more information, doing affirmative conditions.
Okay, so let's see here.
We're going to pause for just a second and jump back over to Judge Simpson's court because I think he had a resolution in that
People
case.
versus Robert Jones.
I'll get you back here on.
George Sotomayor with on behalf of Robert Jones.
All right. The record should reflect that we had a in-chambers conference on this case. And what I'm going to do is I'm going to adjourn the sentencing in this matter to August 5th. August 5th, 2024 at 1 p.m. Defendant therapy, and your counsel can explain that with you in detail. The other thing is that with reference to these addresses that were given, I'm going to need some verification or proof, and I explained that also to your counsel.
And that'll be emailed to Ms. Polaire as well, Your Honor, the verification. And Your Honor, if I heard you correctly, I believe you said enroll in and begin therapy. I think because of the tether may be problematic, but that maybe he brings in proof that he's enrolled.
Enrolled in it.
Yep, okay.
And if it were to begin and there needed to be an exception to or an appointment, you can let my probation officer know or let my office know directly, and we can make an exception for that period in time regarding his tether.
Very well. Thank you.
All right.
Appreciate your time.
Thank you.
That was quick. And they're done as well. Holy cow, everyone's finishing for lunch or something. So you missed the beginning. It looks like he did have proof. It looks like he had actually sent off the application. That's what I'm thinking. So he did not get in trouble for that. Everything got pushed out, but they didn't give him his free latitude to go to every place unless he has proof first. Look at this. I got cable ties. These are like reusable Velcro cable ties in like a billion different colors. Are those just happy? They'll just make you look happy. You've got red, yellow, blue, green, and black. So with Judge Simpson, that was what we just saw, Angelo. It looks like the evidence did check out that he had actually submitted an application, even though he's not accepted yet. All right, so with that said, all my courts have just faded for the day. I did receive 8 new cables today. 4 of them are SDI cables, which are right here. These are going to be for audio antenna signal, but it's basically an SDI cable. It's basically the same thing. It's a BNC, I believe it's actually a connector. Not officially SDI, but. And then I got 4 short XLR cables, which I'm hoping will be long enough. They're a foot long. They need to be a foot and a half. So I'll stretch them in the cable stretcher and see if they work still. I got my back plate for the antenna mounting kit for my wireless antennas to be mounted on the back of my audio device. And I've attached all those little ports right there. And I got a huge drawer that has foam inserts for all my wireless handheld microphones and my belt pack microphones, so I can keep them stored in the audio kit and not have to carry around a whole bunch of boxes of stuff. Yes, and my wife has been handing me all sorts of goodies that I need to put away or lose ownership of. Krista says, how are you streaming while on your trip? Just curious. Couple ways. First of all, we have a live view. It's one of the toys I was most happy about getting for the channel. It is a live view is a bonded cellular encoder, which means it has 4 different cellular modems. Okay, imagine having 4 different phone connections, like 5G phone connections, and the modems are carrier agnostic. They will go anywhere. They're not tied to any one carrier. So at one moment, one particular modem could be with AT&T, and then there's a better signal on Verizon. It would jump to Verizon. Then it would jump to T-Mobile or whoever. It can jump between all the carriers, whoever has the best signal. My contract allows me to have the best signal from any carrier, and they're truly unlimited, not throttled at all. So there's no data caps. But it takes 4 of those, and it puts all the signals together into one big internet connection, and I can send out a signal from anywhere. I mean, as long as you would have a cell coverage at all, I'll probably be able to put out a signal. So I have that. Also, on the Airbnbs that we've rented, they have fiber internet. That's why we rented the ones we did. So I'll be able to live stream like normal from the Airbnbs. Although I won't have my entire studio. I'll have most of it. I won't have my lights. I'm probably taking a mic boom sound machine. I have to figure out what I'm going to do about, I don't want to take this big computer, but all my sound effects are on there, like the ones you guys trigger. So I don't know what to do about that. We might just be without our sound effects for a month, which is crazy. Anyway, so I'm gonna do that. We'll be traveling for a little over a month, but there will only be 1 or 2 days where you're going to actually notice that I'm on the road. So basically, you're a techie superhero. No, it's just I have some really cool toys. That's all. I've wanted that bonded cellular encoder since they were first invented, years and years ago. I've been wanting one.
This is not Burger King. People do not get to have it their way.
Let's see. Let's see. You can do them manually. I can do which ones manually? Oh yeah, that I could just hit the buttons every time you type it in. I'll be like,
that's not him.
Why is the dog chewing on this guy?
I don't think that's him, Mark. I don't think that's him.
yeah, I could do that. I could keep up with all of y'all doing the right sound effects. Are you going to read some documents for my bedtime? I just read 10 pages for the recusal of Judge Glanville. That was your bedtime story.
I saw a chicken fight.
Saw chicken fighting. All right, it is only 3:30, but it's a quiet Monday. There's not a ton going on. I can check and see if there are any other courts we have to jump in on before we wrap up. I might do a live stream building the rest of my audio box, my traveling kit. Ashley, I missed the 233 pages last week. Can you read it again? I can, Ashley. I'll send you a link. Let's see, Judge Boyd, is she doing a trial right now? She's not. Let's see what she has going on. It's awfully quiet there. There's like nobody in the courtroom. I've never seen her court that empty. I bet everybody's going home for the day. Yeah, nothing's happening right there. All right. Anything else? Our next big trial that we're planning on covering is the Ashley Benefield trial. It starts jury selection on Monday, next Monday, so we're going to have a little bit of court hopping this week. CBD says, please answer my questions. Do you check for hidden cameras when you stay at Airbnbs? Yes. Do you have hidden cameras in your Airbnb? No. I'm required to disclose any cameras on my Airbnb. We have no interior cameras whatsoever on our Airbnb. Exterior cameras are just security camera for us, for our house. But it covers the same areas. I did not cover the response to Reed's attorneys yet. Let's see. Any other questions? When do we go on the road? August and the first part of September. We're wrapping up right now, Krista. You might be able to get to go finish. Or I thought you said watering your plants. No, watching where I left off in your other ones. I saw that you were on the replay crew. I saw some comments you'd made. So thank you very much. Love that you're on the replay crew. CBD that I answered. I landed up being a mod for Judge Fleischer. Vicky, you're a mod for Judge Fleischer. That is awesome. That is awesome. You definitely connected with him. That was really cool. So, all right. That being said, I think we're done. I'll probably do a live stream on Mrs. RA's counter if she will let me again. With rebuilding the rest of the audio. It won't be nearly as long because it's going to be pretty quick. Probably about a 20-minute rebuild, but we'll build the audio box that way. DSN, we just got a new air conditioner. It's been 90 and humid for a couple of weeks in our house. I'm thrilled. That's awesome. It's because he was in Cape Town in 2010 and he seems I want a place in his heart. He's got a warm spot in his heart for you. Don't get her, man. I won't. All right, we'll be back with some more court hopping action as well as any possibly some documents coming up. I did just check again. Sarah Boone has not dropped a new document yet. We don't have a letter yet from her. Actually, let me check one more time. Yep, nothing yet. So we'll keep an eye out for that. We're going to watch and see who the new judge is, who's going to be picked in the Young Thug trial. The 22nd, we have a hearing in the Karen Reed trial, which is probably the next thing we're going to watch. That's deciding if they're going to retry the case. Then we have the Ashley Benefield trial that's starting immediately after that. Let's see. In August, we have Corey Richens, which I'll be at physically. I'll be there in the courtroom, which is going to be fun. Lots of fun things coming up. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning about 8:30, 8:45-ish. They're not going to start over. They're going to pick up right where they left up on Young Thug. The reason I know that is because they say the only thing he did wrong was defend himself against the motion to recuse. So, you guys be good to each other. We'll see you in the morning. Have a good one. Or maybe tonight on the Build live stream. Have a good one. Bye-bye.